Good morning. My name is Joyce Manajanto, and I'd like to welcome you to the virtual JOLT Symposium. And pandemic notwithstanding, I think it is highly appropriate that JOLT, the first totally online law journal, should hold its symposium virtually. This year's topic, Emerging Technology and Law, goes far beyond what is typically imagined when this subject is mentioned. Today, we will hear from speakers not only of ways in which technology has changed the practice of law, but ways in which technology has the power to revolutionize the provision of legal services. It holds the promise of not only expanding access to justice, but also of providing opportunities for previously underrepresented communities to fully participate in the legal system.
Would you mind turning on your video, Professor Janto? Thank you.
The symposium will close with a panel discussion to help us all better understand the underlying issues that are causing gender equality in the legal profession. The JOLT staff has assembled an outstanding lineup of speakers. George Grice, the William S. Potter Professor of Law and Director of the John W. Glenn Jr. Law and Business Program at the University of Virginia, will address blockchain and the law. Tom Spahn of McGuire Woods, a nationally recognized expert in legal ethics, will outline the ethical issues when dealing with artificial intelligence. Andrew Bull, principal of Bull Blockchain, will discuss blockchain and cryptocurrency. Malou Lammers, compliance manager at iLand Cloud, will talk about how to vet a tech provider. Renee Dancer, Associate Director of Research and Strategic Partnerships with the Access to Justice Lab at Harvard Law School, will explore issues of remote justice. Sharon Nelson and John Simek of Sensi Enterprises will offer their predictions on the future of the law post-pandemic. And as I mentioned, the program will close with the Women in Technology Law panel. It will feature our speakers, Sharon Nelson, Renee Dancer, and Malou Lammers. They will be joined by Ashley Dobbs, Associate Professor of Law and Director of the Intellectual Property and Transnational Law Clinic here at the University of Richmond, and Veronica Canton, partner and co-founder of Empower Us, a company working towards bridging the gap between legal service access, technology, and privacy. I would like to thank all of our speakers for participating in today's symposium. I would also particularly like to thank Sharon Nelson and John Simek, who have generously given of their time and expertise to previous JOLT symposiums. Finally, the JOLT staff has asked me to expand their deepest thanks to Dean Wendy Perdue, who supported JOLT's efforts to stage this symposium, to Mary Beth Walters for assistance with the many complex details that go into producing an event such as this one, and Carl Ham, who has so expertly handled all of the technical details. So, once again, welcome to the symposium, and I'd like to turn things over now to Alex Tillman. Thank you.
Good morning, everyone. Thank you for joining us today. Two quick housekeeping things before we get started. First, please type any questions you have for the speakers today in the chat, and we will ask them for you at the end of each talk. Second, keep an eye out for the participants polls that will come out, that will pop up 5 minutes before the end of each talk in your Zoom. That will be our primary way of taking attendance, but if those don't work for whatever reason, no need to worry. We will be able to get a report from Zoom at the end with each list of attendees. Now, on to our first speaker. Professor George Grice is the William S. Potter Professor of Law at the University of Virginia School of Law, where he has taught since 2008. Professor Grice also directs the John W. Glenn Jr. Law and Business Program and the JD MBA Dual Degree Program. And from 2012 to 2017, he served as the Vice Dean of the Law School. He teaches contracts, corporations, agency and partnership, accounting, and corporate finance. He earned his JD with honors and an MBA with honors from the University of Chicago. He received a BS in finance from the University of California at Berkeley, and also spent 5 years as a management consultant with McKinsey & Company, where he served clients on corporate strategy, merger planning, and many other issues. His research focuses on problems relating to business alliances, merger transactions, shareholder litigation, and other topics involving the intersection of law and business. His work has appeared in Northwestern University Law Review, the New York University Law Review, the University of Chicago Law Review, and the University of Virginia, and many other leading academic journals. He's the co-author of Digital Deals, a book on business partnerships and alliance strategies published by McGraw-Hill, and is also the co-author of Corporate Finance, Principles and Practice, 4th edition, published by Foundation Press. Finally, he is a serving professor at the University of Chicago and the Indian School of Business in Hyderabad, India, and the University of Auckland in New Zealand. Please join me in welcoming Professor Geis.
Thank you very much. It's wonderful to be here. Someone please let me know if you have any sound check problems, but I think hopefully things are going okay. I have to say that I'm really impressed with the turnout. It looks like we're almost at 150 participants, which is pretty wonderful for an icy Friday morning. Let me see if I can share my screen, because I've got some slides that I want to use for my talk today. All right, so again, good morning, everyone. My topic today is blockchain in the law. And like many of you, I have been trying to pay more attention to some of the ways that blockchain technology or distributed ledger technology might start to impact our markets and our laws. In fact, it's pretty impossible to ignore this topic because almost every day brings new headlines about the hottest cryptocurrency or the latest regulatory puzzle that impacts this area of technology. I think it's fair to say that this has been happening for a few years now, and I think many of us are still wondering exactly to what extent this type of technology is going to take off. But it's everywhere. I mean, the other day, for example, I looked over at my son's online video game, and there were all these ads about how he could trade the latest cyber currency or Bitcoin or invest in Ethereum. I'm not sure that this says more about how prevalent cryptocurrency is or the types of video games that my 9-year-old son's allowed to play, but you get the point, I think. It was not always this way, of course, and I still remember probably about 10 years ago when one of my students came up to me and said, Professor Geis, have you heard of this new thing called Bitcoin? And I said, no, what's Bitcoin? And the student said, well, it's an online currency that has nothing behind it except a technological algorithm, and you can buy it and sell it. And I said, well, that sounds like a pretty lousy idea. I think I'll take a pass. Not the best investment move on my part. If you look at the price of Bitcoin since inception, it's skyrocketed. Recently, of course, it's really hit the news. This morning I checked, the price was up over $52,000 per coin. I did a quick back of the envelope calculation. If I had spent $10,000 to invest in Bitcoin back in 2010, when my student first called it to my attention, it would have been about 8 cents per coin, which would have grown today to about $6.25 billion. So yeah, maybe we don't want to look to law professors for investment advice. But despite all this attention, I would bet that many people still don't have a great understanding of what exactly distributed ledger technology does, or maybe more importantly for this talk, how it might impact our laws. And so what I want to do today is talk a little bit about some potential implications. There are a lot of different possibilities here, and there's a wide-ranging set of applications. I think it could impact payment systems, tax regulation, financial systems regulation, even national security to some extent. We don't have time to talk about all of this, of course, and I don't have the expertise to talk about all of this. I do want to talk about one specific application in some detail, and then I want to then I do want to spend some time near the end of the talk talking a little bit more generally about some possibilities for other areas of law as well. So I thought I would talk specifically about corporate law and just give you an illustration of how distributed ledger technology and blockchain technology is beginning to affect the way that corporate law is working, at least in some areas. To be honest, I think that the more interesting part of blockchain technology is not necessarily the cryptocurrency and the skyrocketing rise of assets, quote unquote, like Bitcoin. I think it's more interesting for me to take a look at the underlying technology, the blockchain technology, and some of the foundational systems that underlie cryptocurrency, because I think that's the technology that could have a big impact on various legal systems. So let me try to explain. I thought it would be interesting for me to do it by telling two quick stories. One about the history of corporate stock markets and clearing systems. And then second, a story about how distributed ledger technology works and what it does. Then I'll try to pull it together by linking the two and seeing if seeing how some of the technological changes here might impact this area of law. And then finally, after I finish the stories, I'll turn to some other legal systems as well. So let me begin with story number one. This involves the historical purchasing and selling of stock. What happens after you buy a share of stock? How do you actually get ownership in a way that transfers your dividend rights, your voting rights, all the other things that come with an ownership position in stock? For most people, this is a pretty uninteresting question. They don't really care that much about what actually happens in the back office plumbing of stock settlement and clearing. But I think there's actually a pretty interesting story here. Once upon a time, if we go back to the first half of, say, the 1900s, trading stock, buying and selling and clearing stock looked a lot like the system that you would use if you were buying and selling a used car. So when a corporation would issue new stock, evidence of the ownership in that stock would usually be accompanied by a security or certificate. So you would have a certificate as a shareholder. If you invested money in the corporation, you would then receive a certificate. And then when you were ready to sell the certificate, when you were ready to sell the stock, you as both record holder and beneficial holder of the security would go through a series of processes that would allow you to then get that certificate over to a buyer. Usually what would happen is you would keep these certificates maybe in a filing cabinet in your office, or maybe you would have your broker keep them for you. But when you're ready to sell, you would get them notarized. You would send them off to the buyer or maybe the buyer's broker who would work on their behalf. The buyer would receive the certificates, you would get your money, and then they would usually send it into a corporation's transfer agent. That certificate would need to be canceled, and usually a new certificate would be reordered to the buyer. It's possible that they might just, endorse the certificate and hold it, for the buyer, but usually they would re-evidence the ownership position so that now the corporation would have a record of who the actual owners of the stock certificates were. This worked okay for a while. It, again, it's similar to what you would do with a pink slip of a car, evidencing your title ownership with the car. But over time, stock certificates started to trade much more frequently than a used car would. And by the 1960s, the system just didn't work anymore. And Wall Street started to become snowed over with paper, and stock certificates were everywhere. Brokers had to hire thousands and thousands of new employees, but they still ended up running days or weeks behind. They couldn't just process the paperwork in time to keep up with all these transfer of shares that needed to take place as stock market volume increased. So, for example, there's one Lehman Brothers analysis that concluded the following. Well, we have 475 million in securities whose owners we can't locate, and we owe clients 220 million in securities that we can't find. Not a great problem, or not a great situation. And later congressional testimony into the overall problem related to the transfer and clearing of securities even concluded that the mafia had taken advantage of some of this chaos to steal hundreds of millions of dollars worth of securities. The stories here are actually really, really interesting. According to one witness in the congressional hearings on this matter, it was super easy to step in and to steal these certificates. All you had to do is figure out, through various contacts when they were arriving at airports. You go drive out to the airport, you put on a jumpsuit that makes you look like a worker, you grab some boxes of certificates, you haul them off, and then you launder them through another financial intermediary. And so this obviously was a problem. And finally, near the end of the 1960s, at the height of the crisis, the entire market had to close every Wednesday. And the only goal of Wall Street on that day, every single Wednesday, was to just try to catch up with this backlog of paperwork that was existing because of all the trades. This clearly was not going to do, and settlement system 1.0 was not going to be okay. Was not going to work effectively. So Congress and the SEC all pushed for a fix, and eventually we were able to implement what I guess we could call clearing system 2.0. The solution centered on something that we might describe as share immobilization. Share immobilization. How does this work? Let me try to explain with an example. Imagine that we have a firm, we'll call it GameStop, and GameStop decides to issue some stock. Well, instead of issuing the stock directly to individuals through share certificates, there is now going to be an intermediary. In the US, this is known as DTCC, or maybe some of you have heard of its subsidiary CD. And GameStop is going to have most of the share certificates actually sit up at DTCC in their warehouses. DTCC will hold all of these stock certificates in fungible bulk, in immobilized fungible bulk, meaning it's not really going to differentiate very much between one certificate and another certificate, between one share of stock and another share of stock. It's just going to collectivize it. It's going to centralize it. And then it's going to keep track of different share changes of purchases and sales through bookkeeping records. So for example, let's imagine that you decide you're going to buy some stock in GameStop. You work through your broker, we'll assume it's Fidelity, to purchase the shares. And as you see the price of the stock go up and up and up, you eventually get wise and decide that it's time to sell. How does this happen? Unlike before, you don't even have a certificate. The only way that your ownership is tracked is through Fidelity. And you're going to contact Fidelity. You say, well, I'd like to sell my stock. And Fidelity is going to look for a potential buyer. If it turns out that the buyer is also a Fidelity client, then Fidelity can handle the trade here. And the shares aren't even really touched down in DTCC. All that needs to happen is that Fidelity makes a bookkeeping entry that says, you no longer have the shares, you got the cash. The buyer no longer has the cash, they've got the shares, and we can just manage the trade internally within our own brokerage system. Now, it's possible that under Settlement 2.0, Fidelity may not be the representative for the buyer. Let's suppose that the buyer instead uses a different broker, BNY Mellon, we'll say. If that's the case, then Fidelity can't handle it itself. We're going to have to go down a level to DTCC. But DTCC similarly has bookkeeping records between how many shares of GameStop are allocated to Fidelity and how many are allocated to BNY Mellon. And the trade can now be managed here. So at the end of the day, we can see how this might help the paperwork problem. If all the shares are just isolated in fungible bulk at DTCC, then we just have bookkeeping arrangements back and forth. We don't even really need to track who owns what stock. Instead, we can just hold the shares in fungible bulk and manage the trade down there. Well, what's the problem? In large part, there has not been a problem since the 60s. And in fact, we could say, I guess, this system is critical. It's impossible indeed to imagine how we could have the volume of trades that we witness today without having some system that takes away the need to process paperwork evidence of ownership for all of these different shares of stock. But there has been an incredible degree of complication. And once we've moved to this system of fungible bulk, we've introduced now new forms of information complexity and costs. Anytime a company needs to hold a vote or issue dividends, it's going to have to work up and down through the different systems to send information up through the brokers and have that information and vote be sent back down to the corporation. Indeed, a corporation like GameStop at any point in time may not have any idea who its current array of investors or owners really are, because there's this opacity between all of these different layers in the system. More troubling, I suppose, is the fact that every now and then the system leads to illegitimate voting. People that may not own the shares may still have cast votes before they sold their shares. And sometimes this can lead to tabulation errors. There are some infamous examples of what we might call overvoting, where more shares vote for for a specific corporate decision than even exist. And finally, in corporate law, some rights actually require specific share identification. A number of corporate laws were written with mental reference to Settlement 1.0. And so they asked for certain requirements that related to showing that you owned a specific share of stock. I'll give you a quick example. If you've studied securities regulation, you may know that if a company issues a registration statement and there's a fundamental problem with the registration statement, suppose they just lie in the registration statement, the investors that purchase the stock pursuant to that registration statement will have a right of action. They can file a Section 11 claim. The problem, though, is that once we've moved to a system of fungible bulk, it can now be impractical or even impossible for any given investor to show that the shares they bought were the ones that were issued pursuant to the registration statement, assuming that there were at least a few other shares that existed prior to that specific registration statement. So if the problem's in an initial public offering and there's no other shares that are released, then maybe there's not a concern. But if it's if it's an offering that's taken place after there's already been some shares that have been out in the public market, it's now impossible for me as a potential investor that's upset about a lie in the registration statement to go back and say, I bought those shares that were issued pursuant to the registration statement. I just can't prove that because there was no specific provenance of what shares I owned as we go back in time. And there are other problems in corporate law too. Appraisal rights, for example, can sometimes require a potential shareholder plaintiff to prove that certain shares that they own were not voted for a merger transaction or something similar. And it can lead to real indeterminacy problems where we just don't know if a given shareholder plaintiff has the right that they claim they have, because we don't track the ownership history. We don't have a great provenance of who's owned what at every single point in time. Okay, bottom line, we've cobbled together a functioning system, but corporate law has paid the price for this system to some end with increased complexity. All right, this brings us to story number 2. In this story, I want to talk at a relatively high level about what is blockchain or distributed ledger technology and what can it do. Fundamentally, distributed ledger technology is, we might call it a 3-dimensional or a more sophisticated form of historical ledger technology. We've had bookkeeping ledgers and individual company ledgers for centuries now as a way of tracking ownership information about specific assets and various pieces of property that a business organization might have. With a traditional ledger, it's limited in that it's often private, and it relates to a single company's perspective. So if one company trades with another company or contracts with another company, each of them might make a bookkeeping adjustment, but it's just going to reflect their own personal situation. And each of their books are going to look different from the other, of course. With distributed ledger, we're now going to move to a system where we're going to have complete ownership records of an entire system of assets. It's really analogous to the real property registration system that we all studied as first-year law students. where we've got public records of who's owned a given piece of property forever. We can go back in time since the system was initiated and look at how the various ownership interests have progressed. And furthermore, we can go in and look at these records and we can see who owns the entirety of a certain cluster of property assets in a given neighborhood or county or community. The difference with distributed ledger technology, however, is that now we have more than one system. So you don't have to go down to your county office and try to access dusty old records. Rather, we've got a system that is potentially public and potentially available in many different locations. So it might not just be in one spot, it might be in lots and lots and lots of different areas. How does it work? How does it work? Well, there are different methods. There can be public blockchains, there can be private blockchains. Indeed, the technology is still evolving. Let me try to just give a quick example with Bitcoin, which is a public blockchain technology. Suppose that I want to transfer 100 Bitcoins to UVA Law. I took my students' advice earlier and now I'm ready to donate them to my law school. How do I do that? Well, both me and the university are going to have to exchange online address information. We can think of this as like a public key or like an email identifier. And then I'll state that I want to make the transaction and the information will be released to the public. A number of miners who operate in this space will pick up the transaction. You've heard of miners, right? These are the various server farm owners that are processing all types of cryptocurrency transactions. What do they actually do? Well, they are going to try to collect a series of transactions as they're queued up. Maybe my transaction is in one of them. And they are going to try to link these transactions into a new block that's going to add on to the very end of the distributed ledger or the blockchain. How do they do that? Well, with Bitcoin, there's going to be a crypto puzzle. And they're going to have to process this crypto puzzle in order to link the new block to the chain. I'm not going to go into a lot of detail here. I believe there's a talk a little bit later on today that's going to talk more about the technology of cryptocurrency and how it works and what some regulatory issues around cryptocurrency might be, which are really interesting. Let me just say a little bit more though about how this crypto puzzle might work and what the miners are trying to do. Because I think it's helpful to understand how this technology plays out. Usually, when you're trying to create a new block, there'll be a series of inputs. In this case, there might be the output of the prior block solution. There might be a timestamp. There might be all the information relating to the current transaction, like my effort to transfer 100 Bitcoins. There's going to be some information relating to a new coin that's going to be created by this new block. And then there's going to be something called the nonce or the open-ended variable. This is what the miners are trying to solve for. They're trying to take all this information, piece it together, run it through something called a hash function, which is just an algorithmic function that takes all this information, process it, and then spits out some sort of an output solution. And the goal when you're trying to mine for a new block is to basically figure out what nonce will be run through this hash function in a way that will lead to some specified solution. The solution can differ, and there are different approaches here. With Bitcoin, for example, we might be looking for an output solution that starts with, say, 12 zeros when you run through the hash function. And the point is that it's really hard to do this, but it's really easy to see whether the output solution is correct. One commentator said that this is akin to finding a single grain of sand from all of the sand in the entire planet. So that's why you see these big server farms that are trying to process it. Let's figure out which nonce is going to actually work. But once they find it, everybody can look at the solution and say, oh yeah, that works. There are 12 zeros. We can have quick validation. Once that validation takes place, then the block will be published. The output will be established and put out there for everybody, and the whole process will start anew. So that's the underlying system, or that's one example of the underlying system. The end of the day, however, what this gives us, coming back to legal implications, is a system of perfect provenance over historical ownership of some given asset. So this, I guess, then brings me to the main question: how might this change the law? What might this type of technology do for various legal systems? And again, I want to come back initially to corporate law and link up blockchain technology to some of the corporate stock trading problems that I mentioned earlier. And then again, I'll talk briefly about some other possible areas of law that might also be changed by this type of technology. I should emphasize, of course, that I mentioned a public system like blockchain. There can also be private systems. It doesn't have to be the case that there's full transparency into what's happening. We could have lots of private systems where there are certain private actors that are able to create a similar type of technology that's limited in who can actually view and see and manage this information. So how might this change corporate law? Well, it could change a lot, but one important implication of this relates to the way that shares would be specifically identified and traded. As we talked about with stock settlement 2.0, we don't necessarily know which specific share was traded when any given sale was processed. With blockchain, the trade could now be managed here. And if the technology works appropriately, we would now have a perfect provenance of who owned a given share of stock in GameStop forever, since the system started. It would make it very easy for us to go back and see that you bought, share number 4, 5, 6, 7, 8, 9, 10, and you sold that share to me when you decided to wind out that specific position. What does that mean for corporate law? Well, there could be a bunch of benefits. For starters, we might now get to a system where voting accuracy is pristine. We don't have these problems related to overvoting. We can have transparency if we want to in who's voting the shares and how they're being voted. If there's a sale that occurs after someone has already cast a vote, we could cancel out their vote and give that vote to the new buyer in a way that eliminates some of these concerns that we've seen in the past. Similarly, any legal rights that require share identification now become determinate. If you receive a dividend, you're supposed to receive a dividend and it's a recent purchase, we can have that dividend be sent over to you very easily. If you're supposed to get information related to the corporation, we can have that information come to you very easily. If you want to file a Section 11 lawsuit in securities regulation, we can see whether the shares you bought were actually shares that were issued pursuant to the registration statement, or if they were shares that had been existing in the market prior to that incremental registration statement taking place. So I think there's a number of important benefits that might arise through a system like this. Of course, there are new complexities. There are some new challenges related to governance. Who's going to run the system? Related to security. Do we believe that this system is going to be safe? Do we believe that this system is going to be able to process the large volumes of trades that we see in today's markets? There might be complexities related to fragmented trading for different rights. Imagine that there's a share of stock and there's a possible legal claim for that company. Some shares might enjoy that claim. Some shares might not enjoy that claim. If you're interested in aggregating shares to pursue that claim, you might want to buy shares, but only if they have the right to pursue that claim. It would be a very interesting bifurcated trading system that we might see where certain types of purchasers are only interested in buying shares that qualify for this Section 11 securities lawsuit. And finally, I think it's plausible that we might start to begin to explore some new theories of liability. So I have an article that's coming out shortly that explores some of the differences between corporate liability and shareholder liability. And the question I'm asking is whether we shouldn't, in some cases, hold former shareholders accountable or responsible when they've incurred gains due to corporate fraud. So we might imagine situations where a former shareholder bought the shares, held the shares, benefited when the share price went up in connection with some corporate fraud, sold the shares at a high price, and then the fraud is later discovered. We don't really go after those former shareholders, only in really rare cases like Ponzi schemes or something akin to that. Mostly because we haven't been able to go after them. We don't know if that selling shareholder had this share or that share, and so it's been impossible to link them back in a really clean way. With distributed ledger technology and perfect share ownership, we might now be able to track back who owned a given share of stock and conceivably recover some of those, quote unquote, ill-gotten gains from former shareholders. I don't know that we will do this. I don't know that we should do this, but I think the possibility now becomes present because we have this provenance of ownership history. Okay, so I think there's certainly a lot to talk about. This is obviously relatively contingent. I want to stop in a few minutes and see if you have any questions or comments. Let me real quickly though, just talk about my thoughts on some other legal systems that we should watch. Beyond corporate law, what else might be impacted by distributed ledger technology or blockchain technology, and how should we think about paying attention here? Well, if you ask many people in this area which legal systems are going to be the first to change, they would probably say payment systems. Cryptocurrencies are obviously a mechanism that could conceivably be used for payment. So far, Bitcoin hasn't really taken off terribly effectively as a payment system, in part because the transaction costs are relatively high. It's been more successful as a form of an alternative investment class, perhaps as a hedge against inflation, or perhaps as a speculation. But I think payment systems are going to be impacted by distributed ledger technology, and it's really important to watch what's happening here. One of the more interesting questions for me is whether we might see entire currencies replaced with distributed ledger systems. The U.S. has not moved aggressively here. It's taken more of a watch and wait approach. But one country I think that's fascinating to watch is China. The Financial Times, even yesterday, reported a really interesting story on efforts by the government of China to set up an yuan digital currency using blockchain technology that in some ways might compete with the private systems like Alipay and some of the other technologies there. What was fascinating to me about this was not only the possibility that digital currency might replace paper currency to a large extent, but the possibility that China might use the presence of this digital national currency as almost a form of monitoring of what happens within the country. So almost a form of payment system surveillance. Can you imagine a system where every single transaction that every citizen of a country incurs could be mined by big data? I think some of those payment systems are interesting and fascinating. And I do think that at some point we will see a digital currency emerge. Second area to watch involves property registration or property titles. I don't think that the way that we track our property ownership will continue. Really, any system where we want evidence of an asset ownership could lend itself very nicely to this blockchain technology. Third area might involve contract execution. Some of you have probably heard of smart contracting. I'm not sure that means the same thing to everybody that uses the term, but basically I think we're talking about a world where certain types of contracts might be written on a blockchain in a way that makes them self-executing. So if a certain contingency happens, then the transfer automatically takes place. Maybe that takes some of the pressure off of our legal systems that are designed to try to enforce and execute contracts. We don't need to worry about enforcing them through contract litigation, but if instead we can set up an automated system that automatically processes and enforces those contracts. Fourth possible area to watch might be tax processing or compliance. Again, our tax situation often depends on private information that we possess related to what we own and what we've done with what we own. I'm not sure that that's going to continue forever. There probably will be some pressure. I don't know if this will happen or not, but there'll probably be some pressure to say, can't we get some of that information available in a way that the IRS or other agencies can use information that's available on a distributed ledger to make an assessment of what taxes we might owe, or maybe to conduct some sort of an audit if there's a concern that we've paid the right level of taxes. I suspect that this will be controversial, but I do think it's something that is worth watching. I also think that there's going to be a whole new set of legal issues involving information regulation. In some ways, this relates back to what I was talking about with payment systems and how much information do we want to be out there on what different people are spending and buying and selling. But I think this notion of information regulation is much more broad. It could get into issues relating to intellectual property, because we have the possibility of having such detailed tracking of information related to ownership. I think there's going to need to be a whole new area of regulation related to what information is available, what information is not available. We've seen some of this, of course, already with various data privacy concerns. But I suspect that the pressures and the urgency to manage this are only going to grow greater over the next decade or so. And I'm sure there's other areas of the law that are going to be really important for us to watch as well. But let me stop here and see if you have any comments or questions.
Great, thank you, Professor Geis. Just to remind everyone, if you can send your questions in the Q&A function, I apologize, not the chat since that's disabled. So any questions, send them there. And before we start, just to remind everyone, we're going to send out a poll to confirm your attendance so that you can get those coveted CLE credits. So now on to the questions. First, I know you mentioned China. Are there any corporate or any other corporate or governmental entities governing trades of blockchain? Have prototypes been created for blockchain?
Yeah, there are a number of different states that are exploring what to do here. And again, I think it's important to distinguish applications from the underlying technology. So the application that I was describing with China was a payment system. What I think is important about what's developing in China is that China, I think in many ways is leading the world in the acceptance of digital money. My understanding now is that when you want to buy something in China, you don't pull out your wallet and pay with paper. Right, you do a face scan and your private Alipay will, or whatever system will be used to execute on that transaction and to pay the money. But now we're talking about a government system in China, and China, of course, as some of you have seen, has blocked the recent initial public offering of Ant, which runs Alipay. I think the reason that happened is complicated, but one theory might be that China wanted to slow down that a little bit so that it could develop its own digital currency that's owned by the government. And they're moving pretty aggressively here. Apparently, they want to try to release something that will be available by the time they host the Winter Olympics next year. So China is, I think, really focused on payment systems. Other countries are in some ways focused on different applications. So Switzerland is being fairly well known for stock market tradings. Singapore is trying to do a fair amount on stock market tradings. Australia is aggressively moving on stock trading. And so that's another application that might not be the first application like payment systems. And I should mention that lots of other countries besides China are also experimenting with blockchain-oriented payment systems. But a number of countries are already starting to do experiments and even prototypes of how a stock clearing system like the one I described would work on blockchain as well. In the US, we've also seen some private experimentation. Delaware, for example, in their corporate laws have welcomed experimentation here and have made some changes along these lines. There's still some regulatory barriers to full-scale implementation for public companies. But I do think that there's continues to be real interest here. And then there are some other countries that are also experimenting with blockchain technology. It's been reported recently that North Korea, for example, has been involved in various cyber hacking efforts that are trying to set up fake blockchain technology currencies, and then using the information that they gather in connection with those fake currencies to try to hack in and appropriate crypto assets from more legitimate systems. So there's lots of state interest here as well. In my view, that I think makes it all the more important that we start to think about what's the appropriate way for us to regulate some of these systems. And I don't suggest it's easy. I mean, in some ways, the Chinese payment system is the exact opposite of a Bitcoin system. With Bitcoin, it's distributed, it's anonymous, there's no entity that has control. With the China payment system, it would be centralized, and there would be perfect control over where the system was being used, how it was being implemented, and how it would necessarily roll out. So I think this is a long journey. I mean, people have been talking about this for the last 5 years, maybe a little bit more. But I do think we're going to need to continue to watch what happens here for the next decade or even more before we know how each of these different areas of law is going to play out in various countries.
And do you anticipate a future crisis of confidence in Bitcoin or other blockchain currency, or even a crisis of confidence in the stock market based on virtual ownership of wealth?
I think that's a really interesting question. I don't know that I can say I understand why one Bitcoin would be worth $52,000. Like with many things, there are two stories here. One story would be, well, it's now going to replace gold as a hedge against inflation. And there's clearly some concern about inflationary pressures taking place right now. What's gold? When we think about gold in comparison to Bitcoin, it's just something that we ascribe value to. And it's possible that as a global community, we could make a decision that instead of ascribing value to gold, because it's scarce, we could ascribe value to Bitcoin because it is also scarce, and there's a limited quantity of Bitcoins that's available. On the other hand, the value of all Bitcoins in the world is approaching $1 trillion. I'm not sure I understand why that should necessarily be the case. I mean, to me, that's different than a share of stock, which is linked to an expectation about future profitability. And so I don't think I have the answer to whether Bitcoin is more like gold or more like a tulip bulb that ultimately is going to pop and drop down in value. I don't know that even $1 trillion is enough that we would have an underlying crisis in confidence in if the price were to plummet back down. Only a couple of years ago, it was down in there was a 100% drop. So I'm not sure that that I would worry as much about that. To be honest, I'm a little more worried about phenomenons like GameStop and some of these other stock trading situations where it does seem like there's a bit of a decoupling from the economic expectations of the firm and the price that some investors are willing to pay for the company. But I think that's another cluster of questions. There is a little bit of a link here, by the way. Part of the reason why I think GameStop was such a concerning situation related to the settlement and clearing system that I talked about as settlement system 2.0. And one of the reasons why Robinhood apparently had to stop trading in the stock was because its clearing system got concerned about the risk that broker might be taking on in the volatile GameStop trading situation, and they just didn't have the capital that they were expected to contribute over to the clearinghouse. So I don't know if I have a huge crisis of confidence related to this. I suppose that if I wanted to get really worried, the areas that I'd get really worried about would be a security breach problem. I think if we set up an alternative stock trading platform and there was a major securities breach, that would be fundamentally bad. And so that's why I think we need to be careful. We need to think really carefully about how we were to, if we want to migrate to settlement 3.0, to use the stock example, how we migrate to that situation.
And I think we have time for one or two more questions. How does blockchain avoid people storing illegal material in the ledger? And what are people's exposure to liability for other parties' bad acts on the blockchain if it's on your server?
Yeah. So a lot of it can depend, I think, on the architecture that's put in place to try to manage information about ownership of the various currencies and how that information is being processed. And you know, we have anti-money laundering laws, right? And so I think you know the more you know, the systems that have been established that are trying to create payment systems that will be durable are putting a lot of thought into how they can try to follow some of the anti-money laundering rules that would be required in a place like the U.S. in order to make sure that there are not nefarious transactions taking place with the currencies. But again, it depends on the system. And if you're trying to set up a private system that might be permissioned and who can make the changes and who has visibility to the changes, then I think it's going to be especially important to put some of those rules in place. If you've got a public system, though, then it's not clear that you would be able to police who's using that specific currency to trade, right? And so I think that comes with the nature of having a decentralized asset like Bitcoin. And I think that's been a cause for celebration among some, and has been a cause for concern among others, that maybe what we're really doing here is we're establishing a currency that might allow for money laundering or might allow for crime. I talked earlier about mafia theft of stock certificates. Maybe something like this is going to create other problems down the road. That's why I think, to be honest, having more of a private system related to digital currency will ultimately be the way that we go, certainly for state-owned currencies, and that might allow some protection against money laundering problem. But again, it's only going to raise information regulation questions as well. How much information do we really want a centralized entity to have and to possess about how we've spent our money in every single thing that we do on a day-to-day basis. As far as the liability question for holding assets on your server and having those compromised, I just don't know. I'm not sure. That's a little more of a technical question than I could answer right now. I do think that there is a lot of concern about this type of topic, and I do think that the notion of security and governance and potential liability is important, but I just can't answer it off the top of my head.
Great. Well, thank you so much. I think we are at time, but I'd like to thank you, and everyone join me in thanking you, Professor Geis, for joining us here today.
Thank you very much. It's been a pleasure. I've really enjoyed the chance to be here today. I've got to drop off to go teach a class, but I wish you all the best with the rest of the panels and the events today. And I hope things go really well. Thanks, everyone.
So up next, we have joining us Mr. Tom Spahn. He practices as a commercial litigator with McGuire Woods in Tyson's Corner. Mr. Spahn was selected as the 2013 and the 2020 Lawyer of the Year for Bet the Company litigation in Metro Washington, D.C. In 2018, he was selected by Virginia Lawyers Weekly for induction into the inaugural Virginia Lawyers Hall of Fame. He has served on the ABA Standing Committee on Ethics and Professional Responsibility and is a member of the American Law Institute and a fellow of the American Bar Foundation. He has spoken at over 2,000 CLE programs throughout the U.S. and in several foreign countries. Through links on his website bio, Mr. Spahn has made available to the public his summaries of over 1,600 client privilege of over 1,600 Virginia and ABA legal ethics opinions organized by topic, a 300-page summary of his 2-volume, 1,500-page book on the attorney-client privilege and work product doctrine, over 1,000 weekly email alerts about privilege and work product cases, materials for over 40 ethics programs on numerous topics, totaling about 10,000 pages of analysis. Mr. Spahn graduated magna cum laude from Yale University and received his JD from Yale Law School. Please join me in welcoming Mr. Tom Spahn.
Great, thank you, everybody. I'm not very good with technology, which is kind of ironic, but Tammy Carroll here at McGuire Woods has got me signed up. I'm in Northern Virginia. Thanks, Tammy. It's always an honor to speak at the University of Richmond. I love coming to the campus because it's one of the prettiest campuses in the country, but this is as good as it gets now. Let me first thank Stephanie Seibert for the invitation and Dylan Phillips for the technical assistance as we're getting ready for this. The materials you have are related to the ethics issues involving artificial intelligence. And then I also added, if Dylan had a chance to do it, if not, just let me know, we can add it later, some materials on the ethics of the pandemic, which I'm going to talk about today. Ironically, I spoke about 3 years ago to the day. It was February 23rd of 2018 at another symposium about artificial intelligence. A lot has happened since then, as you know. I was actually in the hospital with COVID for 9 days in September. I don't know how I got it. I have no idea, but it was my first sick days since the 1970s. And I wasn't in any mortal danger, but it was a real shock to me because I had never been admitted to a hospital since the day I was born. Certainly didn't expect that. So it's hard to predict the future. We're going to talk about the future a little bit. And no one could possibly have predicted what we're all going through this year. And it's going to be reflected in my talk as I go through about the future of artificial intelligence. And you know better than I do what that is, but let's just agree on that. It's machines that mimic human reasoning and problem solving. So that's what we're dealing with. And let me say, we've always had experts that have worried about artificial intelligence. Elon Musk is a genius for sure. And so we don't want to discount too much what Elon warns us about because he's been right about so many things. I remember growing up as a little kid watching the old space movies where the rocket took off and then landed again. And I said, well, that can't possibly be, but he gets it about 95% of the time. Back when I spoke in 2018, I read from an article from the Daily Mail, and this is kind of scary. Tesla's Elon Musk warns we have only a 5 to 10% chance of preventing killer's robot from destroying humanity. That's certainly a bright future there. You probably don't have to worry about exams or anything if he's right about that. And the debate continues about that. I just read recently that he still warns about that. I read an article from just a couple days ago, February 17 of this year, in Bloomberg. What if artificial intelligence decided how to allocate stimulus money? It was by a Yale law professor, Stephen Carter, really bright guy. And he talks about this brings us to an unnerving paper published last month by 6 AI researchers who argue that it's impossible to show that an artificial superintelligence can be contained. So he's worried about it. We've always worried about that, sort of the dangers of the robot ever since Space Odyssey. Everyone mentions that. So let me start by saying it. I mentioned in 2018, and I'll mention again today, that many so-called experts, not just in this area, but on all areas, have been wrong. So I'm going to take a very optimistic view of AI and the future of the legal profession here. So I hope I'm right about that. I'm phasing out of the profession. You're just beginning it, but I'm very optimistic about the future. So I get to, but let me tell you, when I went to college, I started at college. It was very clear that the world was going to start facing mass starvation. Now, I know that seems odd now, but we read a book. I only took one science course at college and I barely got through that one. I was a history major. But the one science course I took, we read The Population Bomb by Paul Ehrlich, who is still at Stanford, I believe. He was there then. I think he's still there last time I checked. The prologue said this. Now, I arrived in college in 1970. Listen to this. The battle to feed all of humanity is over. In the 1970s, the world will undergo famine. Hundreds of millions of people are going to starve to death in spite of any crash programs embarked upon it now. At this late date, nothing can prevent a substantial increase in the world death rate. That was the prologue by the CEO of the Sierra Club. This is what Paul Ehrlich said. All of this boils down to a few elementary facts. There is not enough food today. Now, he wrote this in 1968. How much will there be tomorrow is open to debate. If the optimists are correct, today's level of misery will be perpetuated for perhaps 2 decades into the future. And if the pessimists are correct, massive famines will occur soon, possibly in the early 1970s, certainly by the 1980s. He was certain, absolutely certain, that we're going to face mass starvation. Now, the population in 1968 was 3.5 billion. We now have 7.6 billion people last time I checked. And thanks to Norman Borlaug and others, I mean, there's still starvation, which is more of an allocation problem. But we, with new kinds of wheat and everything, we're in pretty good shape. We have not had mass starvations as a result of lack of food. At the same time, I arrived in college. The consensus, the absolute scientific consensus, was the Earth was cooling. Now, I know you're probably thinking, well, okay, that was wrong. We're right now, the Earth is warming. Maybe so, I don't know. But the scientists in the 1970s were just as certain that the Earth was cooling. This is from a Newsweek article right after I graduated from college. This is what we learned. There are ominous signs that the Earth's weather patterns have begun to change dramatically. The changes may portend a drastic decline in food production again because of global cooling. There is almost unanimous in the view that the trend will reduce agricultural productivity because of increased cold. In other words, we're going to, maybe not a whole nother ice age, but we were definitely cooling, just no question about it. So I remember when I was in college, I won't want to harp on this too much, and I'm kind of making fun of Yale people here, but I debated a young professor, Robert Nordhaus, and the question was peak oil. This was in the early 1970s, and the Yale Political Union had debates that they sponsored. And he said there was just no question, this is Robert Nordhaus, young professor, that by 1990 or 2000, that we're going to run out of oil. Everybody agreed. He said, it's not even open to debate anymore. And I kept saying, well, no, we've always said that. We're not going to run out of oil. And of course, he was proven wrong. In 2018, he won the Nobel Prize for economics. One of my college classmates, another economist, Paul Krugman, famously predicted 1998. I'll just read this. This is 1998. By 2005, it will become clear that the internet's impact on the economy has been no greater than the fax machines. So economist Paul Krugman predicted that. 10 years later, he won the Nobel Prize for economics. And 8 years after winning the Nobel Prize, when President Trump was elected, he said this: we are probably looking at a global recession with no end in sight. So I'm not saying this necessarily to kind of make fun of people, and you should always take what any expert says with a grain of salt, including me. If you consider me an expert, take what I'm saying with a grain of salt. But I think the fears of artificial intelligence, they get a lot of news. That may be why people do it. I don't think we have to be obsessed with that. And what something tells us about how seriously people took this threat of robots killing us all is that most people weren't worried about that. They were worried more when artificial intelligence came up of losing their jobs. And that's true of lawyers too, which I'll get to in a minute here. But when I spoke in 2018, artificial intelligence take over. This is from Newsweek late into 2017, just before I spoke last time. If any of us are still alive in the year 2100, we'll look back at artificial intelligence as the definitive development of the 21st century. Then we'll have a robot write a blog post about it for us. There's a 50% chance that AI will be able to perform all human tasks better than humans in 45 years. And that was in 2017. And all human jobs are expected to be automated within the next 120 years, according to a survey of AI researchers conducted by Yale University and Oxford University of Oxford. And so we were more worried about that. This is another one. This is January 18 of 2018 from CNBC, how to stop extremely disruptive artificial intelligence from harming society. This also mentions the Oxford University study along with Yale. 47% of the jobs can be replaced by automated technology within 20 years. And our leaders, our political leaders frequently have blamed automation for job loss. President Obama said this is in 2011. There are some structural issues with our economy where a lot of businesses have learned to become much more efficient with a lot fewer workers. You see it when you go into a bank and use an ATM. You don't go to a bank teller, you go to the airport and you're seeing a kiosk instead of checking in at the gate. Now, when I come back to the ATM story in a minute here, the predictions were the same for our profession in 2018 when I spoke. This is from 2014, a Fordham Law Review, The Great Disruption, How Machine Intelligence Will Transform the Role of Lawyers in the Delivery of Legal Services. And the first paragraph started with this sort of ominous analogy of us to journalism, which is kind of ironic in a way. Law is an information technology code that regulates social life. In our age, the machinery of information technology is growing exponentially in power, not only in hardware, but also in the software capacity. As a result, the legal profession faces a great disruption. Information technology has already had a huge impact on traditional journalism, causing revenues to fall by about a third and employment to decrease by 17,000 people in the last 8 years. And this Fordham Law Review predicted the same thing would happen to us. May 23rd of 2016, Law 360, Latham and Watkins, a firm you've heard of, and Von Bryson and Roper, who I haven't heard of, are getting their feet wet with artificial intelligence through IBM's budding legal expert, which could eventually supplant attorneys on certain legal research projects. This is Law 360. Artificial intelligence has Big Law Rethinking Associate hiring, November of 2016. This is of April 2017. Big Law is less reliant on lawyers in high-tech world. It mentions Denton's, K&L Gates, Simpson Thatcher, Jackson Lewis, and so on. So we were really worried about. And these warnings about automation resulting in the loss of jobs have almost always been wrong. That's the thing that I'm trying to emphasize here. Maybe I'm going on too long about it, but they've been wrong. Remember what I said about President Obama. There's an article from, I'm not sure where it's from, but this is from 2011. So the Bureau of Labor Statistics, there were 600,500 bank tellers in 2008. And this is 638 by 2018. In addition to, well, let me get this. At the dawn of the self-service banking age in 1985, for example, the U.S. had 60,000 ATMs and 485,000 bank tellers. By 2002, the U.S. had 352,000 ATMs, up from 50,000, but they had 527 bank tellers, 1,000 bank tellers. And I had mentioned that we've got even many more of them now. In addition to that, there's more tellers because they do more things. They're just more efficient because they don't just take your checks and everything. We used to get paid in cash at McGuire Woods for our expenses. I can't imagine that. Now you just get an automatic deposit. That's the way the world's going to. But in addition to the more tellers, there's also, this was as of 2011, 152,900 computer automated teller and office machine repair people. So there's a whole other generation that's coming along, a whole bunch of group of people that have gotten jobs because of ATMs. And I read another article about that time about bookkeepers. The bookkeepers have shrunk by 44% from 2 million in 1985. This is as of 2017. But the ranks of accountants and auditors have gone 41% up. And so it's simply a way of, it's a shifting of employment. But automation we've always faced this since the Stone Age, that technology is going to bring job loss. And I read an article a while ago about Queen Elizabeth. This is the first Queen Elizabeth, who didn't reign as long as the one we got now. 500 years ago, she refused a patent protection for automated knitting machines because she said this, she had too much regard for the poor women and unprotected young maidens who obtain their daily bread by knitting to forward an invention which, by depriving them of employment, would reduce them to starvation. And so we've always had that problem. Well, not a problem. I guess we've always had the problem of people complaining about technology losing jobs and then being wrong about it. The 1961 article in the Time magazine reported raised new alarms about an old scare of automation and said, oh my gosh, we're going to lose jobs. As at that time, there were 54 million American workers. And as of 2017, there were 71 million. So I wish I could do a show of hands here, because I frequently ask when I talk about this, do you know a farmer? Have you ever met a farmer? I don't know any farmers. I don't remember meeting any farmers. I guess I met one farmer that was up in Rochester, New York, where I grew up. But in 1900, 1/3 of our workers were farmers. In the year 2000, 1% of them are. And yet they produce as much food more food than they did in 1900, just they do it more efficiently. So this is a process called creative destruction. Joseph Schumpeter, the great Vienna School economist, called it that. And there's a story about Milton Friedman, another kind of Chicago school coming from the Vienna School, that, and I don't know whether it's true or not, it probably should be true, but supposedly he was over in some Asian country years ago, and people were using shovels to build a dam or a road, do some big construction project. And he asked his host, why do you have people using shovels? There's machinery that could do it. And the host said, well, we don't want to have those people lose their jobs. And so we're not using the most efficient machines. And Friedman turned to him supposedly and said, well, if that's the purpose, just have them use spoons. And it's sort of laughable, but you see the principle here. So how about us and AI? Let me get into ethics now. That's what I was supposed to talk about. Every profession tries to protect itself, and it uses, unfortunately, the government to do it, and they use the government to do it because the free market would frequently not protect them. And this is a pattern that appears not just in our profession. I'll get to our profession soon, but every profession. There's a great article from the Wall Street Journal in 2012 about the government's increasing occupational licenses. Now, we've always had to, not always actually, but in the last many scores of years, we've had to have an occupational license to be a lawyer. I'll get to that in a minute. But in the 1950s, the number of workers needing a license from the government to do their thing was apparently 1 in 20. As of 2012, it was 1 in 3. And it mentions some examples. I'll give some more recent examples. If you want to be a shampooer as of then 5 states, you needed a license to do it. And in many states, according to this article, cosmetologists needed 10 times more training days before they could be licensed than EMTs, believe it or not. So it was easier. It was easier to get a EMT license than a shampooer license. And as you can see, I don't go to the barber much. My wife, I shouldn't say cuts my hair. I guess she just shaves it every now and then. But this is what this guy who wanted to increase the difficulty of getting a barber's license in Michigan saying this, and this is an actual quote: "I'm not saying we as barbers are as important as doctors, but we are the closest you can get. We are turning this into a wild, wild west that is not requiring a license with lots of training for barbers." This is what the director of a barber's school, I wonder if he's interested in having a lot of training required. This is what he said: "I'd like to see them get a haircut in a barbershop 5 years from now. It'll be like rolling the dice." So, oh my gosh, can you imagine that? There's another more recent article from I read last August. New York Democrats push for law mandating 500 hours of training for shampoo assistants, not shampooers. This is shampooers' assistants. Because, and of course, the people pushing this were the people that taught shampooing assistants. That's a shocker. The ABA Journal in the 2018 article about hair braiding, which is in the African tradition. I think it looks great. You needed in Arizona 1,600 hours of training to become a hair braider, which took about $10,000 to do it. And so this is the way that they try to restrict competition. In New York, last time I checked, you needed a license to be a dog sitter, but not a license to be a babysitter. So getting to our profession, we have been remarkably successful in protecting our turf. And what's remarkable about it is, at least I can tell what a dog sitter does. I know what a barber does. No one has been able to define what we do, which nobody else can do, or else it's a crime. There's got to be some definition of that, but there really isn't a definition of it. If there's some in the criminal law, we just revamped it in Virginia, but it doesn't say very much. And the ABA, the world's largest voluntary organization, last time I checked, created a task force in 2002 define the practice of law. And it gave up a year later, said, we can't do it. We can't define the practice of law. Virginia has the ABA model rule definition, well, not lack of definition, I guess, but this is what the ABA model rules say, and we have this in Virginia. It's a comment to Rule 5.5, which is the unauthorized practice of law, multi-jurisdictional practice, which I'll get up to. This is what it says. Now, if you go to the Virginia rules and you're a lawyer, you'd want to know what it is you do. It says the definition of the practice of law is established by law and varies from one jurisdiction to another. Well, okay, but how about telling me what it is in Virginia? That would be helpful. It doesn't do it. But it does say this, whatever the definition, limiting the practice of law of members of the bar protects the public against rendition of legal services by unqualified persons. There we go. So we'll use the government to stop it. And yet every day we see non-lawyers giving legal advice. I used to travel almost nonstop before the pandemic. It's kind of weird that I don't travel. I'm a lifetime titanium Marriott member. They keep coming up with new elements here. And I was hoping eventually I'll get to uranium, but I've stayed like 2,000 nights in Marriott hotels, and lifetime US Airways, a million miler, which I gave up, and now I'm a million mile United. But whenever I travel, I try to look for, when I buy local newspapers, I look for stuff like this. This is in the Portland Oregonian from a couple years ago. This is the answer from Amy Dickinson. Everybody seems to be either Amy or Abby when they answer questions. If your roommate brings an open bottle with him, drinks in public places, then he's breaking the law. New York City is an open container law, making this illegal. Business advice. Jacksonville Times Union, 2019. This is Annie Lane, another A person. By default, unmarried couples don't have any rights to each other's property. Unless you've drafted a property agreement, I'm afraid that you're out of luck here. Washington Times, 2019. Dear Abby, this is the big one. You're not legally or morally obligated to pay for this biological father who was a molester. Okay, so we don't even know what we do, frankly. And so AI is the latest iteration of that is resisting it, of trying to exclude competition. That's what professions do, and we've been really good at it because we can't define what we do, and nobody else can do it. It started in 1968. This move toward machine learning. This wasn't really machine learning, but it was a book called How to Avoid Probate in 1968, and he was actually faced jail time. He was arrested for a misdemeanor of unauthorized practice of law for writing a book that you could buy, How to Avoid Probate. And to show you what a big seller it was, in 1966. So I guess he published it earlier because he was convicted of a manslaughter in 1968. But in 1966, I think that was the year it was published, How to Avoid Probate outsold Mattress and Johnson's Human Sexual Response. So more people were interested in probate in 1966 than that. New York court eventually said, well, no, we're going to let you out of jail for writing a book about how to avoid probate. 1969, the next year, Texas tried to shut down some software this is on Palmer versus Unauthorized Practice Committee in the State Bar of Texas. And same thing, he came up with some software to try to answer people's questions. 30 years later, Quicken Family Lawyer was one of the first times that you could get a computer program to help you practice law, in a sense. This is for non-lawyers to do it, and Texas tried to shut that down and failed because the legislature changed the rules there. And then there was LegalZoom a couple of years ago, and everybody went after that. This is from 2017. IP firm files $60 million antitrust suit against LegalZoom and state bars. LegalZoom was opposed everywhere, and it eventually won everywhere, frankly. And so AI is just the latest iteration of ways that we worry about job loss, and we try to resist to the extent we can. And we've been good at it as a profession, the practice of law by people other than us, frankly. And is AI the practice of law? I've got that in the materials. Well, of course it is. It's How to Avoid Probate, a hard copy book. Is the practice of law. It's what does what we do. If you don't have any children, you go to chapter 2. If you do have children, you go to chapter 3. If you got children, you go read 3, then you read 4. If you've been divorced, you go to chapter 15. That's what we do. And so we clearly use our judgment, but books can use judgment too. And you can go into a Walgreens or a CVS and buy books like that right now, and you can buy software that helps you as well. I mean, doing taxes has never purely been legal, but the same thing has happened in that profession. So what effect will AI have in our profession? I think it will eliminate the kind of work you don't want to do, frankly. Let me tell a little bit about my experience in McGuire Woods. When I started in 1977, you had to do a house closing, you had to do a title search. We had mag cards a couple of years later where you could put like 3 lines of something. You had to shepherdize by book. I remember because you had a big book and then a smaller book that was more recent, then a little paperback book, which is even more recent than that. We had to cut and paste briefs. So we had to farm out briefs to 5 or 6 typists, and then we'd cut and paste because if we were in a real hurry, that sort of thing. We've gone from 90 lawyers when I joined to about 1,000 lawyers. So it's just going to make things more efficient. Some smart analysts even years ago thought that it wasn't going to stop the growth of jobs in the legal profession. There was there's an article, Law 360, that I cited years ago. Not many thought this, frankly. He just thought it was going to help people make better decisions, which I think is exactly right. And there was a PricewaterhouseCoopers back said that there's actually going to be more lawyers rather than fewer lawyers. And that was kind of surprising to everybody because we all thought that the world was going to collapse for us. So you'll have to be more careful when you use AI. And this is one thing that when we started Lexis, which I'm not very good at even now, so take everything I said with a grain of salt on the technology side. One thing that worried me when Lexis started is that our young lawyers would just focus too narrowly on what they were looking for. If I were to say, well, can you research affirmative defenses in something, and this is what I got 2 or 3 in mind, they would research that. And I'd always say, did you read the whole case? Because there's probably things I haven't thought of, other affirmative defenses. And if you read the cases where the affirmative defenses that I thought of, some other smarter lawyer in that case might have thought of other ones. So you got to see the big picture. And I think that's really important. There's an article from Legal Week in the UK, July of last year, is the rise in artificial intelligence use damaging junior lawyers' skills. That's one thing that I think you have to be really careful of. And as long as you cast a wide net and don't just narrow in like a rifle shot, I think you're fine. So the bottom line, I think that AI will be a tool for you to use. It'll make your life better, easier. It's a lot easier to shepherdize with a push of a button than to go to these different books. And I would you'd have to write down the sites you'd have to read and stuff. So let me turn to another topic, and that is what I think is accelerating or will accelerate, has already begun to accelerate the use of AI and all technology, and that is the pandemic. I know this sounds kind of odd, but I think the pandemic is having a dramatic effect already for 4 or 5 reasons, which I'll give you here. First, all of us have been forced to use technology and become more comfortable with it. I still struggle, frankly. I haven't appeared as a cat in any hearings, so to me, I haven't embarrassed myself too much in that setting, but I've embarrassed myself enough in other settings with my inability to use technology very well. So, but we all have to become more comfortable with it, and we're all working. I talked to one of our lawyers in Baltimore who's been working from home. I talked to somebody in Charlottesville this morning, one of our offices there, or our office there, working from home. So. And we also have to have documents available to us and to our clients, and in many cases, and they have to be available to everybody, and therefore they're in a spot where they can be accessed for AI. In other words, they're being accumulated and gathered, which is helpful too. There's a December 21st article in Law 360. Everyone's working from their computer terminal, and so all the documents have to go online and have to be migrated into a system. As a result, law firms' AI abilities are skyrocketing, and which is totally understandable. And others have seen this pandemic effect. I just read an article of February 10th of this year, Law 360. Let's emerge from the pandemic as legal innovators. And so all of us are just, we are, our nature is to try to do a better job to help our clients. And so the pandemic is forcing us to become familiar and comfortable with technology. Second, we now can work from anywhere. And we have to share things online. This is sort of a continuation of the first, and therefore they have to store them somewhere. Not only do we need them, but we may need them all over the country. And this may, ironically, well, not ironically, I guess importantly, become one of the lasting benefits of the profession, frankly. This is the geographic turf protection we've always had, which is just ridiculous. You can drive anywhere across the country, but if I were to go across the river where I can see Maryland from my office here, I can't see Russia, but I can see Maryland, it would be either misdemeanor or a felony for me to set up shop in Maryland, even if Maryland's approach, even if I represent only Virginia lawyers, apparently. So we've always had temporary practice of the law in other states. That is, that's Rule 5.5, multi-jurisdictional practice, which no client ever complains about, by the way. No client I don't think, has ever complained about me going to Wyoming and doing something, or you going to New Jersey. It's always the other lawyers where you're taking their business away. But only one state that I'm aware of, jurisdiction, has dealt with the temporary practice that's pandemic related. But we've always had temporary practice. I've traveled all over the country, taking depositions and meeting with witnesses and stuff. As long as it's temporary and it's related to your link with your home state, you've always been good to go. But DC has said in the pandemic world, well, it's okay to go live with your parents, and ironically in DC. In other words, the DC bar said non-DC lawyers can come to DC and live, which is ironic because most people are fleeing the big cities and going to the suburbs. But every bar will be very forgiving about that. The thing that's changing is not the temporary practice in another state, it's the systematic and continuous presence in the other state. That is, and I dealt with this a while ago at McGuire Woods. One of our young lawyers wanted to go to Colorado because his wife was going to be in grad school or medical school. And he said, can I go there and just sort of hang out in the basement and practice in Virginia? I mean, no one will even know I'm in Colorado. I checked at that time, and the answer was no. It would be a criminal conduct in Colorado if you're domiciled there permanently. I mean, enough to a domicile with all whatever that legal standard is, and even if you never represent anybody in Colorado. But starting a year or so ago, states began to deal with this. Utah had such a refreshingly modest, non-interventionist approach in 2019 on this. And this, I think, is the trend, because the ABA dealt with this in the pandemic-related one, which I'll get to in a minute. Utah said, what happens if somebody comes to live in St. George in a vacation home, or retires there, I suppose, or comes and takes care of an ailing parent in Utah, but they're sort of invisible. They don't represent people in Utah. They don't hold themselves out as representing anybody available. Most, like Colorado, when I checked it, said, no, I can't do that. This is what Utah said. What interest does the Utah State Bar have in regulating an out-of-state lawyer's practice for out-of-state clients simply because he has a private home in Utah? The answer is none. Well, great. So the geographic, this is partly driven by the pandemic, but this geographic turf protection, which has been just as bad, frankly, is starting to weaken. And that may be really important for you. And I think the fact that people have been fleeing the big cities, New York, San Francisco, going to other places that are a little bit more suburban or rural, is going to increase the permissibility of multi-jurisdictional practice. And that's helpful because what it also makes, though, is necessary is to have a collective sort of an electronic database of documents that everybody will be using. So it helps in the AI, I think, and also it's going to help you live in a place you can afford a home. I moved to Richmond, where people bought homes instead of going to New York. I wanted to raise a family, and I loved what I heard about McGuire Woods. I've been there for 43 years, so I made the right decision. And everybody thought I was nuts going to Richmond. I'd driven through Richmond. That was it. But you'll be able to live anywhere in Nashville or Richmond or Texas if you don't like the. I grew up in Rochester, New York. You know, who likes the weather in Rochester, or Buffalo, or Syracuse? So that's going to help you. It's going to if we move in that direction. The other thing the pandemic is doing, my third point, is that it's creating work, and I think in the future will create work that lends itself to AI. In the transactional world, for sure. I mean, gosh, I wouldn't want to be own real estate, commercial real estate now. Think of that. Oh, what a nightmare. We had already downsized in the Tyson's Corner office all of our big offices. I had this corner office that no one ever came into because we didn't let them after a while because of confidentiality concerns. A lot of our big clients, and we don't want people, strangers going onto the floor. So I had this big office, 2 leather chairs that no one ever sat. I gave them to my daughter, who's a lawyer in Charlotte. I'll mention in a minute. But anyway, and all law firms are doing that. They're shrinking their footprint and they're having the same size offices for everybody, which is, I think, perfect. And so that's happening for sure. But think of real estate people are worried about it. This is what from February 11 of this year, Law 360. Individual practices took this even further in AI. At a recent legal industry conference, one presenter described how the organization had, thanks to digitalized contracts, remember using them not in the file cabinet because everybody needs them because we're all working remotely, quickly developed scripts to search 24,000 contracts for terms related to force majeure, partial shipments, and so on. The law department was able to complete this process in a short period by using automation to narrow the document search. And so in that world, that's built for AI, looking for that stuff. On the litigation side, not the transactional side, we're going to have discovery. Lots of discoveries coming up here. This is just as the pandemic was starting to hit hard. Law 360, an article last April, consider legal ramifications before recording video calls. Too late. The month later, virtual meetings could be fertile ground for legal discovery. And then the final one was about the same time. Anticipate government subpoenas of your Zoom recordings. So what's going to happen when litigation really picks up, which it already has, but now it's going to pick up, with non-feline people appearing in court and stuff like that. I think this is a lurking danger. By the way, the discovery that will come of it. If Martha Stewart lost the privilege by giving something to her own daughter, for instance, and so I think there's going to be a lot of discovery about who was in the room when you talked and so on. But there's going to be enormous privilege reviews, and those are made for AI. In fact, privilege review may not even be the practice of law. The Second Circuit said it wasn't in 2015. That's depressing. I did it for years. And then the Southern District of New York later said, oh, it's a practice of law because of one sentence in the privilege reviewer's guide. Privilege is tricky and there are lots of gray areas. That made it into the practice of law. The fourth factor that I think that is increasing the pandemic effect on AI is litigation funding. Dramatically improving, and litigation funders are smart business people that have to anticipate the future, and they're going to be much more open to innovation, than we are. That is, if they're putting their money in the game, they're going to want to know what the future is, and they're going to have to, I bet they'll use AI to do it, not just the judgment of lawyers. Maybe it's a coincidence, but there's 2 other even more dramatic effects from the pandemic that I think are going to affect the use of AI, and that is non-lawyers practicing law. Now, we've always had paralegals that have practiced law, but they have to do it under the direct supervision of a lawyer, and that's always seemed stupid to me. I mean, I'd be permitted legally to write a will, but it would be total malpractice. And yet someone, Wirewood's paralegal, who has done nothing but write wills for 30 years, if he or she had opened up a little storefront, started writing wills, it would be a misdemeanor in Virginia, and he or she could spend a year in prison. In New York, it would be a felony and spend 4 years in prison. And so, which doesn't make any sense to me. And that's our turf protection. I think it's a good thing that he or she'd be able to do that. It's access to justice. I'm going to talk about that in a minute. But we're starting to move in the direction of allowing limited trained non-lawyers be able to do limited things. It started in Washington State. They had limited licensed legal technicians in 2015 for family law. Ironically, they terminated it in June of last year, just as the pandemic started. And that was ironic because now every other state's starting to look at it. California started before the pandemic. This is from January of 2020. California opened the door to non-lawyer practice and tech-driven firms. But then it's hitting big time as of last spring. Utah Supreme Court officially proposes largest reforms to the legal profession in a generation. Arizona, California will allow non-lawyers to practice law, which I think is a good thing on the edges. People are still going to want a lawyer to do the important stuff, but some of the stuff like simple will writing, I think it's good. This is September last year, why Arizona's legal paraprofessionals push could lead to major shift in legal market. So is AI, if these people can practice law, robots can practice law, AI can practice law. And sure enough, this is from December, the world's first robot lawyer sued for illegal spam texts. So, and finally, the states are considering a structural change that could change our profession forever. Rule 5.4 prohibits us from splitting our fees with non-lawyers. And that seems kind of odd to me. I mean, most of us earn our money are through fees. We pay non-lawyers in the firm. We can pay them, our paralegals and our secretaries and so on, our file clerks. We can pay them bonuses, if you know what I mean. We just can't share our fees with them, but we are sharing our fees with them. What we can't do is to pay them like a percentage of a case they bring in. Well, there was a move starting about 20 years ago to allow lawyers and non-lawyers to share their fees and actually work together. It's called multidisciplinary practice. It was lawyers partnering with non-lawyers. And the examples would be, if you were an elder law lawyer, you'd be able to have a psychologist or a social worker as your partner, as opposed to an employee. If you were a construction lawyer, you could have an engineer. Now, the ABA shut that down quickly. Virginia shut it down. I drove all over the state arguing for it. I said, let the market decide. There'll still be traditional law firms, but if somebody wants to hire somebody with a elder law, with a lawyer and a social worker, let them do it. And I was so persuasive that of the 64 people on the bar council of this Virginia State Bar in 2002, I convinced all but 60 that I was right about it. As I kind of ran out the door, I said I probably should have left my car running because they were about to chase me out of there. I've always thought the lawyers would be trusted to be ethical if they had partners who weren't lawyers. And there's one state, DC, that's always had the most mild form of multidisciplinary practice, which is partners who help the lawyers practice law. You can have a partner in DC who's the marketing person, and you can always pay them a bonus and so on. You just could never be a partner. Well, the ABA rejected multidisciplinary practice again more recently, but now the states are taking the lead. Illinois, this is last July, intermediary entity model they're going to. September 3 of 2020, Law 360, Arizona law firm ownership rule change is a win for clients. And what they're now thinking of going all the way to the end of multidisciplinary practice, which is ownership by non-lawyers. Now, along the way, either the intermediary, which is having non-lawyers help us practice law, that's the mildest form. But if we do that, they'll use AI, technology, they're entrepreneurs, they're business people, they're efficiency experts and so on. If those people can be our partner, not just helping us practice law, but doing their own thing, even more they'll help us as lawyers get into efficiencies and use AI and technology and so on. And so I think that's going to happen one way or the other, but it's going to be even more dramatic if they own law firms. And this is what the September 3 article said. And then January of this year, Arizona may have nudged U.S. law firms toward future IPOs. And some people say, oh my God, lawyers they'll be pressured into doing something unethical if they're in law firms that are owned by non-lawyers. And I thought to myself, I don't think so. I mean, we're trusted. I've always been a private practice lawyer, but University of Richmond has in-house lawyers, I assume. And there's labor unions have in-house lawyers, and there's some of the biggest law firms in the country are law departments. Those people can be trusted to act ethically, even though they report to a non-lawyer. The people at GM or Boeing or Wells Fargo or Bank of America, they're not pressured into doing something unethical. So I think we may get there. We can look to the UK, as I'll mention in a minute here. We may end up with accounting firms owning law firms. and and that, to me, that would be, I mean, that would be okay, it seems to me. We've lost partners to accounting firms because they practice tax, frankly. And in Europe, in fact, around the world, the largest law firms are accounting firms. This is from January of this year again. KPMG has law firms in 53 nations. EY and Deloitte is 69. PwC is 85 nations. That they're the largest law firms, and it's usually good jobs. They can. I think the lawyers can act ethically if they're working for accounting firms. I mean, I've been delighted to work in McGuire Woods, but as I say, we've lost partners to accounting firms. We've gotten some back, and it's sort of the same thing. In the UK, they've had ownership of law firms, non-lawyer ownership of law firms. And I guess my point on that is that they'll really get into technology and efficiencies. And will we have to resist some pressure to act unethically? We always have to resist that pressure. And we have to be competent, we have to be diligent, we have to be loyal, we have to keep confidentiality. That's the materials that I'm giving you. We'll always have to do that, but in-house lawyers do. You will always have to do it. If you work for an accounting firm doing tax, you're still a lawyer. There's limited rules that apply when you're just practicing law, but some of them apply to you whatever you do. And there's been an interesting debate just in the last couple of weeks about the UK's experiment in non-lawyer ownership. This is Law 360, February 2nd of this year. UK is proof non-lawyer ownership threatens legal profession. And February 16th, a couple of days ago, US legal system can benefit from non-lawyer ownership. So we're seeing people still debating this, frankly. And that may be what the future holds. And along with all that will come all the technology. Think about accounting firms. They've got a massive data. They use AI, I'm sure, to do their audits, to do their checking of check registries, whatever accountants do. And that's going to come to us, I would think. It's going to come either way, but I think if that's where we end up, then it's going to be even more important. So what's the future of AI? Take what I'm saying with a grain of salt. If I come back 3 years from now, I may be saying different things. I think it's going to be a tool to make your life easier and better. Clients will always need your lawyer's judgment. You're lucky that you've gone to a really good law school. My son both my kids became lawyers. My son went to Stanford Law School. He was on law review at Stanford after being a submariner after the Naval Academy. He eventually went to the business side. My daughter went to a law school that doesn't exist anymore, Charlotte Law School, and yet she has a thriving one-woman immigration law practice in Charlotte. So your success will not depend on where you go to law school. It'll depend on how successful you are in being a lawyer, using your judgment. And clients will always need that. So you're lucky to go such a good law school. Our former chairman, Richard Cullen, was a U of R grad. I had to talk to him yesterday, or not yesterday, about a week ago, but he was just talking to his client, Vice President Pence. So you can be really proud of your grads. I'm very proud of my partner, Richard Cullen. Anyway, let me turn it back to Stephanie and Dylan. Thank you very much for the opportunity, and welcome to a great profession. We're lucky people, the best profession in the world. Stephanie, back to you, or whoever.
Thank you so much, Mr. Spahn. We are going to be taking a 10-minute break, and we will come back at 10:55 for Mr. Bull and his talk on blockchain and cryptocurrency.
Hi, everyone. I'd like to now introduce Andrew Bull. Mr. Bull is one of the people who actually found Bitcoin very early on in 2011 before it gained all the popularity. And he's been working in that industry since. He's a founding partner at Bull Blockchain Law. He specializes in technology-based transactions and represents businesses operating in the cryptocurrency industry. He has become a leading lawyer on blockchain, and he's doing extensive business in both like the legal and academic experience. He wrote a master's thesis on the regulation of cryptocurrencies He founded a digital asset investment fund, and he ran one of the first cryptocurrency mining companies in the US. He started Bull Blockchain Law in direct response to the lack of clarity in the legal industry. And he's a very well-known person throughout the US in this field on both blockchain and cryptocurrency issues. Mr. Bull, yeah, we really appreciate you being here for us. And yeah, I'd like you to take it from here.
Hey, everybody. Thanks, Dylan. Appreciate the kind words. And obviously, thanks to the University of Richmond School of Law for hosting, and Jolt and Carl and Stephanie, thanks for all your help. Obviously, Dylan kind of gave a brief introduction into some of the experience that I've had in the space. And today I'm really going to try to give kind of a very introductory perspective into the legal field that is now blockchain and cryptocurrency law. Obviously, an extremely nascent field that hasn't been around very long. And there's a lot of differences in terms of the way that the traditional law is applied in this industry. And so one of my main goals today is really try to give everyone a little bit of insight into not only how my practice functions, the clients that we service, but also a lot of the regulatory uncertainty that is both here in the US as well as abroad. And so that a major goal is understanding, obviously, the technology. I know the prior presenters have done a great job of giving you a lot of information. And so I'm going to try to kind of combine a little bit of the technology side as well as the legal side. And hopefully we all kind of have a pretty sound takeaway from that perspective. So I'm just going to give a quick brief agenda. I'm going to talk about some of the regulation. I'm going to talk about a lot of the governmental agencies, specifically here in the United States. I tend to think of there's two different areas to the legal side of this industry. There's definitely litigation and being in the court or arbitration, but then there's also a lot of administrative law that is going on in this space. So governmental agencies have really taken a liking to this industry in terms of not only providing regulatory guidance, but also obviously going after companies that are potentially running afoul of the regulations that they've imposed. I'm going to talk specifically a lot about the Securities and Exchange Commission, the Financial Crimes Enforcement Network, and all of these are, I said, federal governmental agencies that are really targeting companies within the space. And so when I think about kind of my legal practice and the services that we're providing to clients, a lot of it is around either providing guidance or insight into these regulatory developments as they unfold, as the industry expands, and really trying to find some type of middle ground and understanding, because as I'll get into in a second, this is very much a unique technology and something that is really disrupting kind of the traditional notions of legal administrative law in the federal governmental context. And then I'll also talk about some of the smart contract concepts as well and how they play into the legal regulations, and talk about some specific cases on top of that. So Dylan did a great job of giving me an introduction. As he said, I came in the tech side of this industry initially. I ran a mining company and a digital asset investment fund. That was years ago, so there was little to no regulation outside of a little bit of guidance from FinCEN here in the States, and the industry was significantly smaller. And as I'm sure a lot of you know, in 2017, that all changed and the industry expanded exponentially, and a lot of the governmental agencies started getting involved, courts started getting involved because they had a lot more caseload in regards to the application of cryptocurrency. How are they going to categorize it? What were the definitions under not only statutory interpretation, but also how would a judge interpret those traditional definitions and apply it towards cryptocurrency and certain blockchain applications? Dylan pointed this out, and I really wanted to just reiterate it. There was just a lack of clarity. And to be honest with you, there still is a lot of lack of clarity in the industry. There are definitely a lot of concepts such as decentralized finance, or just open-ended decentralized blockchain application platforms that really don't fit within traditional models of how we not only evaluate assets, but also how we evaluate culpability, who is responsible. When you have things like DAOs and decentralized, which are decentralized autonomous organizations, it's really tough to try to figure out the best regulatory path for an organization that is fully decentralized. So, and I'll get into some of that in a little bit. So like I said before, trying to combine kind of an understanding between technology and the law. And I've found that being a practicing attorney in this space and having a law firm that solely focuses on this industry, having an understanding of the technology is equally as important as understanding the law. I've found that it helps with clients to really understand not only the functionality of blockchain and crypto, but also all of the real world applications, how they're being used. And that really gives you a leg up in terms of providing guidance to clients. And so anyone who's potentially interested in the field, I would very much implore you to make sure that you have a really firm grasp on the technology, because it does help in terms of not only making you different from traditional attorneys who are potentially evaluating the industry, but also it really does kind of create a bond with clients, because a lot of these individuals or entities are very much immersed in this industry. And as a result, they have a really deep knowledge. And so being able to not only discuss kind of the regulatory concerns and considerations, but also being able to blend that with a conversation around how the specific application of technology that your client is using is really a great productive service component to the legal profession. There's a lot of different concepts and a lot of different applications with blockchain and cryptocurrency. And as a result, there's a lot of different industries. And so our clientele is insanely diverse, actually. I mean, everything from fintech to real estate to gaming on the blockchain, mining, cryptocurrency ATMs, payment applications. Everything is kind of all encompassing in terms of the way that this technology can be applied. And as a result, there's a lot of considerations there. And so when running a law firm or considering practicing in the area, it's really important to kind of have an understanding of the different aspects or different regulatory considerations for businesses based on what they're doing in the space. There's a lot of uneven and even non-existent international legal views. I would say that the US stands at the top in terms of strict securities regulation comparatively to the majority of countries in the world. And as a result, we've seen companies and entities leave the United States, and I'll get into that in a little bit, but also the EU and some Asian jurisdictions like Hong Kong and Singapore are taking more of a let's let the technology development approach rather than kind of a more administrative, okay, we're gonna make sure that nobody's using this for illegitimate purposes. And there's a spectrum for sure. And when we talk about these concepts of decentralization, there's no scenario where you're just either decentralized or you're not. It's very much a blend, and different projects are more decentralized and some aren't. And so when we consider kind of how the application of blockchain and crypto really functions, it's really important to kind of have that spectrum mentality, because you'll see that some companies that claim to be fully decentralized actually aren't, and some companies that are saying that they're utilizing blockchain are fully centralized. And that's not to say one or the other is bad. It's just a consideration that is very much at the forefront of the mentality of this industry. So the regulatory beginnings were very much about combating fraudulent use, specifically with Bitcoin. We have two major examples of this. Mt. Gox was a Japanese exchange that actually ended up being hacked and lost a significant amount of Bitcoins, and which actually even to date is still ongoing from a case perspective. And that really kind of showed early on in the industry that third-party applications such as exchanges could have vulnerabilities, even though the underlying blockchain technology was an immutable, kind of virtually non-hackable technology. And so it's important to kind of understand that concept from a regulatory perspective, because a technology could be all well and good in terms of its application and be extremely secure, have all those benefits. But if the third-party application that is utilizing that technology also doesn't have the proper procedures and protocols and safety measures in place, then they can be taken advantage of. And Mt. Gox is a really good early example of that. I personally actually had Bitcoin on Mt. Gox, and I remember it was basically gone because a lot of people, all their accounts were just vulnerable to hackers, and all that Bitcoin was taken. And also Silk Road is another good example of the early kind of FBI and FinCEN kind of targeting this industry to combat fraudulent use. and focus in on, okay, here's a platform. And for those of you who don't know, Silk Road was basically an online marketplace where you could use Bitcoin to purchase drugs and other illegal products and things along those lines. The individual, Ross Ulbricht, is now serving multiple life sentences in federal prison. And really that showed early on that utilizing this technology for illegal purposes, one, could actually occur because they ran this website for more than a year and made a significant amount of money via Bitcoin through that platform, but then obviously ultimately were taken down because of all of this illegal activity. Now, the industry is drastically different today compared to Mt. Gox and Silk Road examples back in 2013 and 2012, because we have a lot more requirements for the industry. And that is a direct result of regulatory clarity. So in 2013, after these incidences, FinCEN, the Financial Crimes Enforcement Network, provided this extensive guidance that really at least provided the beginnings for a regulatory build upon that administrative agencies have been able to use and provide clarity. And so someone who was running Silk Road back in 2013 compared to trying to do it today would have a significantly larger amount of clarity and precedent to rely on. And that was really early on in terms of the application of the technology. And so there was a lot of gray areas going on there. I wanted to just highlight initial coin offerings and again, just kind of making sure that we all have this understanding and how much of an impact this really had on not only the industry, but also the regulatory framework here in the United States, especially when you talk about the SEC, because in 2017 with the ICO boom, that really changed the perspective of governmental agencies in that they were somewhat considering the industry, but not very much in terms of importance. ICOs start kind of cropping up 2015, 2016, and then they really explode in 2017. And having gone through that area of the industry, I can tell you that there were a significant amount of projects that were raising an absurd amount of money off of just having a white paper and just describing what they were anticipating to do in the future utilizing this technology. And as a result, there was not only a lot of offerings that were violating the Securities Act of 1933, but were also making them not compliant and taking advantage of individual investors who didn't have any KYC verification or anti-money laundering policies in place. And as a result, that really started to garner the attention of the SEC and the other governmental agencies as well. And so we really start to see a robust kind of regulatory framework start to build out as a direct result of ICOs and the amount of money. Now, I want to kind of pause and just highlight a really important concept that I think all attorneys practicing in this space should always have at the forefront of their mind, and that's jurisdiction. Where is the company located? And we're in a situation where we now have a technology that can virtually, depending on the application, be accessed by anybody, anywhere in the world. It's extremely innovative from that perspective, not only being able to transfer an asset, but also transfer information, say in the smart contracts context or in other contexts as well. And realistically, when you're having kind of a conversation with a client or considering an entity that is potentially going to do something in the space or is already doing something in the space, jurisdiction is such an important consideration, because not only do you have jurisdictional limitations from a regulatory perspective, the governmental agencies themselves actually having limitations in how they can address companies who are doing certain things and so on and so forth. But also on top of that, making sure that your client is aware of potential different impacts of regulatory environments that their business might be bleeding out into, especially when you talk about exchanges. So I've had clients that are cryptocurrency exchanges, and when they expand into foreign jurisdictions, there's a lot of considerations. There are a lot of legal considerations, and being a US practicing attorney, we may understand those regulations, but we might not have the full encompassing perspective as opposed to somebody who's maybe practicing in that jurisdiction. And so there's collaboration opportunities there with foreign attorneys and foreign law firms as well, but also making sure that your client is aware of those jurisdictional considerations is extremely important. And so a lot of these companies, and having been a legal advisor in some of the businesses that went through ICOs in 2017, there's a lot of situations that really occurred that they were not doing any due diligence and not considering any regulatory components of some of the clarity that we had and some of the precedent that had been set, at least in the securities context. And so as a result, we've seen an aftermath of a lot of administrative opinions by the SEC that have been really focused in on making sure that these entities are not getting away with offerings that are either not registered with the SEC or not seeking some type of exemption, which I'll get into in a little bit. So one of the other components that I want to highlight in terms of the legal perspective within this industry is the difference in definitions that governmental agencies have. And so when we talk about the SEC, really one of their main MOs, especially in the token context, is determining whether a token is a security. And in 2017, they issued the Dow report, which I'll get into in a minute, but I want to highlight that this was basically the first time that a governmental agency said that a token could be a security. Now, that obviously this created a large uproar in the industry because all they did was categorize one specific token as a security for specific reasons. However, there was a lot of uncertainty, and today there's still a lot of uncertainty around tokens and how they fit within that traditional securities regulation and application. Now, we do have direct statements from SEC commissioners that say that Bitcoin and Ether, which is the token that is for the Ethereum blockchain, are not securities, but outside of that, we don't really have much clarity there. But I want to highlight the difference in definitions. So the Commodities Future Trading Commission, they think that obviously some tokens can be commodities, and the SEC thinks that some tokens can be securities. FinCEN also has jurisdiction over tokens as well, especially in the payment processing component, if a company qualifies as a money service business, and then you have the DOJ and FBI kind of carrying up the criminal side of everything. And so depending on how a client structures a token or the actions that they carry out in regards to that token, there can be different definition considerations. And this is not to say that a token that is created can't be a security and a commodity, depending on which governmental agency you ask. So that's a really kind of multi-layered consideration from a legal perspective, and practicing lawyers should definitely do well in terms of advising their clients about these potential regulatory situations and considerations. So the Dow report is the one that I just mentioned, and really this created an outgrowth of a lot of administrative agency rulings from the SEC, and this was kind of the first application of the Howey test, which is from an old Supreme Court case and maps out 4 factors for determining whether something's a security. Now, these factors seem simple, but in their application, they can get quite complicated. And as a result, in this scenario, they specifically targeted a company that was issuing a token, but it was a decentralized autonomous organization, which is called a DAO. And one of the concepts in there is that they sold tokens as interests in the actual enterprise itself, so in the actual DAO. And the investors were told by the company itself that they would increase in value. And going down to the Howey test, we have these 4 prongs. You have an investment of money, common enterprise, expectation of profits, and efforts of others. First prong is almost always satisfied. It doesn't have to be fiat currency. It can be cryptocurrency. There's also a couple examples that you can actually have an investment of money with no investment of any type of fiat or cryptocurrency, and instead it's an action on behalf of the individual who is receiving the token. Common enterprise, I'm not going to get too detailed into that. There's vertical and horizontal, but realistically, when there's an entity, especially in the DAO situation, there's a company called Slockit, you're going to satisfy that prong. The third and fourth are a little bit more complicated in terms of the evaluation from the SEC perspective, and the expectation of profits is really from the perspective of the investor. So it's not from the perspective of the company. And the company in this situation, by saying that the token would increase in value and it would be listed on third-party exchanges, you kind of have a little bit of satisfaction in both of these prongs. I also want to have the caveat that you need all 4 prongs to be an investment contract and or security under the Securities Act of 1933. And in this situation, the Dow report, it was a seminal report. It came out, it was a really big deal. And basically all these companies out there started applying this Howey test to their tokens, or they were applying it in determining whether they were going to launch a token. And so when you think about the third and fourth prong, we're talking about not only the perspective of the investor, but also the actions of the company. And so the efforts of others, I'm going to just kind of highlight when I was talking about this spectrum earlier of decentralization to centralization, there's a lot of considerations there, because do you satisfy the efforts of others if there's a decentralized organization that is kind of running the show in terms of whatever the application that is being created? How do you figure out who's culpable in that situation? If there's an individual software developer that's sitting in Houston, Texas, and then the other one is sitting in Singapore, okay, so what's the culpability component to the application that they've created and when it's actually going out and functioning? And also, how do the users use that, whether there's a token involved, or say whether it's a decentralized exchange that allows transactions between third parties, but doesn't actually have any control over those transactions. So there's a lot of considerations there in terms of the expectation of profits, as well as the efforts of others, and really codifying that and figuring out a way for your clients to make sure that if they aren't going to register the token, which in the US today has its own inherent risk, because of the lack of clarity and just these very specific administrative rulings that we have. But if they are considering that and they're not going to register, they really need to not only apply this test, but use a framework that the SEC has provided in the last 2 years. So I also want to have the caveat as well, is that, like I said, I kind of just alluded to it, but these are individual administrative rulings. So these are not necessarily creating precedent such as a federal legal court case would create from a higher court. And so we got to always consider that from the perspective of what does this mean in terms of operations within the industry for stakeholders and entities that are using blockchain and using a token. How do they factor this into their overall business model to ensure that they're not going to end up the way that Slockit did? And Slockit ended up returning all the funds, were fined, and ultimately dissolved. And so this is a situation that a lot of companies who are potentially thinking about creating a token have to consider. So the subsequent administrative rulings that came out of the SEC, one of the more important ones was Munchie. And again, very similar situation, except for the fact that it was a different type of application. It was a restaurant review application, but they issued a token, and they told individuals that the token was going to most likely be worth more in the future. They also were curating the restaurants that were in the application for review. And that was an effort on behalf of the entity, going back to that fourth prong that I was just referring to in the Howey test. And that's something that's really important in terms of how not only the token functions, but how it gets listed in the third-party marketplace. Because if you have a company that is not registering their token and then they're entering into a contracts with an exchange to list their token on the exchange, I mean, they're basically agreeing to liquidity in the market. And as a result, that's really an effort on behalf of the company that if an investor, an individual receiving the token saw or was aware of, they would certainly have an expectation that there was going to be increased value. I mean, that's the main point of getting it listed on an exchange, is so that liquidity is created and people trade the token, and then ostensibly it creates value increase in the token itself. So Munchie came not long after the DAO, and really that this was kind of a combination of these two cases. And then subsequent cases, we had the Telegram case. Telegram was actually in the middle of a multi-billion-dollar token raise, and ultimately decided to stop because of the SEC filing a preliminary injunction, and they had this whole back and forth, and ultimately they paused that. The Kin Messenger app is actually a really good example of a company that raised over $100 million and fought the SEC on this. The previous cases, there was administrative ruling, like the company pretty much agreed, somewhat fought it a little bit, but the Kin they really went to bat and started having a full legal team that was trying to battle the SEC's perspective, and ultimately the case ended up against them, and that was a pretty large detriment, because they were arguing that their platform was functional. They had a messenger app that was already operational. The token was used to create liquidity in the company and was allowing them to expand and develop and so on and so forth. And the SEC still determined that this was a issuance of securities. And we think about that overall concept of, okay, well, companies traditionally, how they fundraise is they go through either an equity raise, or maybe there's some alternative opportunity for them to distribute the right to future profits and so on and so forth. And those are all very important in terms of securities considerations, because they might fall within those categorizations, or maybe the company seeking an exemption. And Kin was really trying to do something similar, but obviously was trying to use the technology as a justification for this not being a security. And ultimately they lost. Tomahawk is a really good example, because Tomahawk utilized a component of the Ethereum blockchain where they airdropped tokens into users' wallets, specifically to users who would go on and post about the Tomahawk platform and token on social media. They would also go vote for it to be on exchanges. So these are the actual users that are doing this, and then they were receiving the tokens in exchange for doing that. There's a concept called a bounty, where the company Tomahawk in this example basically said, if you go out and do this, you will get this, or if you solve this problem for our platform, you will get these tokens. And ultimately the SEC determined that even though there was no exchange of investment, no actual dollars changing hands or crypto or anything like that, this still equated to an investment of money and satisfied that first prong, because it was fostering the development of the community. And these tokens were creating value as a direct result of the users going out and doing things that were very much directly related to a lot of what previous companies had done that had gotten them into trouble with that fourth prong about the efforts of others. So that was a really large consideration there, and really kind of added in an additional concept to the overall framework, in that it doesn't necessarily mean that just because you aren't paying for something that that company that's issuing that token might still be issuing a security. So the SEC's changes, I think that these are both important to address, because while obviously we still have a lack of regulatory clarity in the industry, the SEC has definitely made a lot of good positive steps as well to address the industry. And Commissioner Pierce proposed this safe harbor rule, which, going back to that decentralization spectrum and understanding kind of, okay, how do platforms function? How are they sufficiently decentralized? And this proposed this idea that would allow a company to go out and actually have a token sale and not necessarily be concerned about violating securities laws, because they're going to have a 2 to 3 year grace period where they're actually going to be able to provide information to the SEC and sufficiently prove that they are decentralized enough and not satisfying all those four prongs. It's very early. This was just a proposal, so it hasn't been approved yet. I think it would be really beneficial for the startup industry in this space in the United States specifically, because I think a lot of companies that are utilizing blockchain and crypto, especially in their early stage development, are very limited in the US. And there's a lot of opportunity in the EU and other jurisdictions. And as a result, I mean, I've seen it directly. I have clients that have left the United States jurisdiction specifically because they want to do a token raise, but they don't want to adhere to the limitations that are imposed by the exemptions to the Securities Act. Some of those limitations are, if you say you do a Regulation D offering, you have to make sure that you're going towards accredited investors only. There's all these KYC and AML procedures that you have to provide, as well as information that you have to provide in the offering documents. And so we've seen definitely companies that would potentially have stayed in the US had you had something like this 3 year grace period, but instead left. And that stifles innovation in technology development in the US for sure. The SEC's FinHub, so this is actually a service that I interact with quite frequently on behalf of clients, and it's such a great resource because they do allow you to speak directly with SEC representatives, and they've actually created a department that is specifically addressing cryptocurrency and blockchain technology. And as a result, there is a lot of collaborative effort and a lot of candid conversations that go on with that. I'm on a monthly call with a couple other attorneys that practice in the space with a couple of specific SEC representatives, and they're very open and willing to give information, because at the end of the day, they really want to provide as much clarity as they can. We all have to acknowledge that they're limited in what they can do, especially with the lack of federal legislation from Congress that talks about this industry, because we've seen a couple bills that have been proposed in Congress, but nothing's been passed yet. And as a result, like the SEC can only do so much. And so this is great that they've kind of created this fin hub for you attorneys and clients to be able to go and actually have candid conversations with them. So these are exemptions to the Securities Act of 1933 in that companies can utilize these exemptions to raise funds. And this is actually outdated because I guess 3 months ago, the SEC changed and expanded the numbers specifically in terms of how much companies are able to raise. And so we see Regulation D kind of at the far right in those two sections. Those are mostly used for security token offerings. And just to provide some clarity, since the Dow report in 2017, we now have had a lot of traditional companies or entities in the space that have done securities compliant offerings, which ultimately are security tokens. And those tokens typically either represent maybe equity in the company, they might represent some debt that the company is going to take on, or a right to future profitability within the company, all very much akin to the traditional concepts of fundraising and securities regulation. And so these exemptions have been utilized by a lot of companies. We've had numerous clients that have tokenized and sold tokens to either accredited investors, or maybe they did the regulation CF, which actually I don't think is on there, but it's a crowdfunding regulation where a company can now raise up to $5 million from the general retail investors that are not necessarily accredited. They do have to do it through a FINRA approved third-party portal, but there are portals out there now that actually do token raises. And so that's a new area of the industry that we've seen development in the last couple of years since the Dow report at the end of 2017. So yeah, a lot of clients will definitely consider these as having a registered or an exempt offering. And I think it's really important, obviously, for attorneys to know this information kind of very well, because then they can properly advise on what the best jurisdictional considerations are, as well as the best offering considerations from a security standpoint. So the other most important governmental agency, in my opinion, in this industry is FinCEN. And the Financial Crimes Enforcement Network has a lot of regulatory oversight to exchanges and also payment applications. And so there's a definition within the Bank Secrecy Act, which is the federal statute that gives FinCEN their authority, that allows a company that is transferring money, which is ultimately categorized as a money service business, that if they're doing some type of money transmission, then they need to register with FinCEN as a money service business. Now, this is a federal registration, and the subsequent consideration for a lot of these companies is state regulation as well. So we have money transmitter licenses in the United States, which are actually done at the state level, which means that a lot of these companies, if they want to operate in one state versus the other, they need to get a money transmitter license if they satisfy that regulatory requirement. So Coinbase is probably the most popular exchange in the world, but it's based here in the United States. And they got all 52 money transmitter licenses very early on. I think it was back in like 2014, or yeah, maybe even earlier before that. And they basically were able to operate in all states, and they became a very much a first mover in the industry here in the States. And so that's a large consideration. I have clients that they do money transmitter license applications all the time at the state level. And realistically, there is a consolidation effort going on where companies are being able to utilize a multi-state compact, where I think now today there's probably 32 states where you can leverage a money transmitter license application in one state across a lot of the states through a multi-state registration database. And that has sped up this process, because back in, I guess, 2017, it would take 2 years and a significant amount of funding in order for a client or a company to get money transmitter licenses in all 52 jurisdictions. You're probably wondering why I'm saying 52, but it's because there's other jurisdictions as well outside of the 50 states. So 2013, we had FinCEN that published this application. I referenced this earlier, and this is a really comprehensive document and was really ahead of its time, in my opinion. I felt that it gave a significant amount of clarity in the industry very early on, and was super helpful for not only Bitcoin operators, Bitcoin ATM operators, payment application operators, and now we've seen the likes of PayPal get involved in the space. And obviously, that's a huge transformation from 2013, when FinCEN was obviously providing this guidance for the small amount of companies that were really utilizing the transmission of cryptocurrency on behalf of third parties. And so that's really a large consideration there is, when does a company become a money service business? Is your client a money service business by conducting transactions? How much control do they have over those transactions? Does the individuals or entities that own the cryptocurrency have control as well, or are they completely in control? There's a lot of considerations there in terms of determining what exactly the company is going to be categorized under the Bank Secrecy Act, which then lends support to how you actually go about advising them in terms of not only their potential registration with FinCEN, or also their licensing at the state level as well. FinCEN requires anti-money laundering as well as KYC, which is know your customer. And basically those two compliance components are extremely important for any money service business, because that is how those companies adhere to the Bank Secrecy Act regulations. And so you have identity verification. So for example, I go back to the Mt. Gox situation back in 2013. If you could just make up an email address and open an account and then buy Bitcoin, send Bitcoin anywhere you wanted. Today, you can't really do that in the United States. All exchanges have much more strict rules in terms of verifying your identity. If anyone on this presentation has ever opened up a cryptocurrency account online with a cryptocurrency exchange, you've most likely either provided a picture of your license or the information from your license and or passport address. They're verifying your identity because they're a money service business, and they have to adhere to both federal and state regulations. I already talked about Silk Road, but just touching back on how they were transmitting Bitcoin on behalf of users, because you had a user purchasing a product from a seller, and Silk Road stood in the middle and conducted those transactions and had oversight over those transactions, and then could actually stop those transactions if they wanted to. That is ultimate control and really fell within that money service business definition. But unfortunately for Ross, he definitely did not consider that and or do any type of compliance in that regard. There are administrative rulings that have come out of FinCEN. I highlight the Ripple one. This slide's been in my presentation for a couple of years. And so this is not about the recent case that's ongoing between the SEC and Ripple, which will definitely have a significant impact on the industry, not necessarily from a regulatory clarity perspective, but just from okay, we have one of the largest cryptocurrency businesses going head to head with the SEC. And I know a couple of the attorneys that are working on that case, and they very much are going towards the main focus that they're going to try to win that case. So yet to be seen whether they will. But this was actually a settlement that Ripple had with FinCEN, so they're not the SEC, back in 2015, where basically they created these products, and they were claiming they were decentralized cryptocurrencies and that they didn't register as a money service business. And FinCEN said, well, hey, you're conducting these transactions, there's facilitation, processing, you are actually targeting banks specifically. That's kind of what Ripple's mantra is. They're really trying to get banks to utilize their platform, which is a blockchain-based platform. And as a result, they ended up settling with FinCEN. I think it was like $500,000, which when at the time, I think Ripple was worth multiples of billions of dollars. So it's really a drop in the bucket. Which might give some insight, and I'm not going to necessarily weigh in and give a direct answer, but I would imagine that the SEC and Ripple will probably come to an agreement in their other case in terms of simply paying a fine that will most likely pale in comparison to the amount of revenue that Ripple generates. So again, this is a situation where they didn't register as a money service business, and there's a lot of companies out there today that have either registered or are considering registering based on their categorization. And also on top of that, there are definitely a lot of companies in the world that are most likely processing transactions that have not done this compliance in terms of money service business registration. State regulation. So I've kind of talked about it a little bit in the money transmitter license context, and I'm just going to briefly touch on New York because it stands at the top in terms of the regulatory burden that companies have if they want to conduct transactions in cryptocurrency on behalf of others, especially in the exchange context. So 2015, the BIT license was created. It was an additional license requirement for a company that was interacting with cryptocurrency, exchanging cryptocurrency, allowing for trades, sales, stuff like that. And ultimately, this license has existed since then and really has only been granted to a handful. I think it's in the 20s or 30s now in terms of the number of entities that have received this license. And ultimately, having done the application on behalf of clients, and also I'm going through a couple right now, it's a heavy burden, and it really is reserved for large entities that have a significant amount of funding, as well as a significant amount of information and resources that they can provide to the New York State Department of Financial Services, which oversees the BIT license application. This is unique. The majority of states don't have some additional licensing requirement. And New York, obviously being the fintech hub that it is, and one of the main financial centers of the world, they decided to go through and create this license. I will point out that the individual who championed this license left about in 2018, I think, or 2017 from the SEC, and is in private consulting about the BIT license as well as the industry as a whole. So there's kind of an inconsistency there where it was created, and then its application has obviously been somewhat beneficial, but I definitely think it's typically reserved for larger companies. And as a result, I think this has also stifled innovation from a startup perspective in New York as well. That's not to say that this isn't the proper way of going about it, and maybe that's the best way to combat fraudulent use or potentially protecting investors and so on and so forth. But at the same time, obviously there's considerations there, and we should always make sure that we're questioning whether this is the best mantra or best way about going and enforcing regulation at the state level, because obviously money transmitter licensing is already a high burden to begin with, but going above and beyond this BIT license, I think it shows a desire to collaborate with the industry for sure from NYDFS's perspective, but also creates a pretty high burden. So that's important. I've listed a couple other bills. Wyoming is actually not on there, but they kind of stand as well clear at the top in a different context where they're pretty progressive in terms of the legislation that they've passed, in that they don't tax, say, cryptocurrencies at the state level, or they allow for companies that are working in blockchain to kind of have not necessarily an advantage, but they're friendly towards it from a regulatory standpoint. Exchange regulation, I've touched on this, talked about the AML KYC approach. Like the early days, the exchanges were technically self-regulated in that the anti-money laundering policies and KYC policies that they were implementing were very much not necessarily being reviewed. But as FinCEN got more and more into the industry, that's happening more consistently in terms of not only the review process, but also ensuring that these exchanges are carrying out these policies and procedures, because I'm sure anyone has looked into the news in terms of hacking in this industry, and the number one target is always exchanges. And that's because they have so much crypto liquidity that they really do have the ability to kind of be at the top of their exposure in terms of hackers coming in and trying to steal that cryptocurrency. And I think it was like Chain Analysis, which is a company in the industry, issued a report recently that talked about there was over $2 billion in cryptocurrency that was stolen from exchanges last year. That's in the world, not in the United States specifically. And the US does very much have a high regulatory burden for exchanges. So that's really productive from that context. So the Ether Delta ruling, I kind of touch on this and use it as a really good example of going back to that decentralization conversation, because Ether Delta was a decentralized exchange, meaning that individuals could go on the exchange and conduct their own transactions. They didn't need to verify their identities. They didn't need to adhere to a third party or anything along those lines. They really just had the ability and had carte blanche in terms of being able to conduct their own transactions. The individual, Zachary Coburn, a guy out of Chicago, I actually met Zach a couple years ago, but he basically ran into issues with the SEC because he was not registering the decentralized exchange. And the whole idea, or at least argument behind it, was, okay, well, he doesn't have control over the transactions, so why is he culpable? Why is he responsible for something other people are doing? And just because he created an application that people then are going off and utilizing, where's the disconnect, or where is the nexus that creates culpability for Zach? And realistically, in this ruling, what happened was the SEC determined that Zach was holding an order book on a private server. So it wasn't fully decentralized. It wasn't this scenario where there was this ability for anybody to do whatever they wanted, and Zach had no really authority over it. He did, in fact, have, and also on top of that, the other consideration was that there were transactions that were occurring on the platform of tokens that the SEC had specifically categorized as securities, and Zach knew that that was happening. And so ultimately, he settled and paid a fine, and then I think like maybe less than a year later sold the company for an undisclosed amount, which I know to be in probably the high tens of millions of dollars range. So there's that as well. So I think that's always an important consideration when thinking about administrative ruling fines and how much of an impact they actually have. So this is actually a somewhat outdated map. I would move the US maybe a little bit more to the right, but this is kind of an oversight of a lot of the jurisdictions that are creating regulation in the space and how favorable or unfavorable they are. What's funny is that China used to be probably the most unfavorable and really came out hard against the industry, and it has definitely backpedaled over the last 2 years. They've really started considering not only application of the technology, but they are in development of a national currency-backed stable coin, basically tokenizing their national currency, which we're seeing a lot of other countries do as well, including Russia. And I do really think that in the future, the majority of countries will have some digital form of their national currency just from a market competition standpoint, so that transaction processing occurs faster and is easily able to be accessible by obviously other jurisdictions as well. Because, I mean, you think about when you change the model of, say, transferring funds through banks, not in the enterprise context, that's relatively fast, but say in the individual context, I want to send money to somebody who's in China. It's a complicated process through my bank and their bank and so on and so forth, when I could send Bitcoin in a couple of minutes, or even other cryptocurrencies that actually go even faster. I mean, that changes the whole consideration of the transfer of assets, not only in the finance context, but also in other like commodities contexts, and how products and goods function in a global marketplace. So this is just kind of highlighting that aspect of it. So smart contracts are obviously a really innovative technology, and the Ethereum blockchain really brought this into the mainstream perspective of this industry, in the ability of smart contracts to kind of allow for this, not necessarily a full removal, but a somewhat removal of the third-party intermediary in terms of reviewing contracts and verifying them and executing them. Obviously, us all being attorneys or future attorneys, our largest consideration is what role do we play in the contract context. And I was sitting on a panel years ago, and I remember when smart contracts were just starting to kind of gain some traction in the industry, there was another attorney that said that smart contracts would replace lawyers. And him and I actually got into a debate about this, because I vehemently disagreed with that and really felt that, if anything, lawyers would have an opportunity to learn and understand smart contracts and be able to advise clients on the utilization of this very kind of innovative technology. If I have the ability to go list my house on the Ethereum blockchain and somebody else can purchase it, and I have a combination of text and code that I use the application on the Ethereum blockchain for, and someone sends me Ether and I've now sold my house, the deed is transferred, it's an immutable ledger that is on the blockchain, it's very easily provable. I mean, that is a pretty efficient process comparatively to the way that that transaction, for example, has been conducted in the past. So we've seen a lot of platforms that have been subsequently developed, and there's all different types of smart contract applications. And I was lucky enough to be in a arbitration hearing situation where we had to bring up the Ethereum blockchain and actually show the transactional ID that showed proof of ownership. And from a technical perspective, that can seem quite complicated, but it's actually not that complicated. And once a lot more lawyers kind of gain understanding of that, there's definitely going to be a lot of application in the legal context as well in regards to contracts and settlements and things along those lines. So I have a couple of use cases here, and the smart contract context. There's obviously like identity verification is a really big aspect of the blockchain industry. Civic is kind of one of the leaders in that context. We have Insure ETH, which is an automated flight insurance program. And a lot of times you can kind of conceptualize a lot of the applications as streamlining the process, right? Like that's what I was kind of highlighting in those smart contract examples, especially in the real estate context, is that there's an efficiency and a cost saving component to application of this technology. That's not to say that it's a one-stop solution and is extremely like all of a sudden the newest thing and is going to replace every other contract, but there are opportunities for utilization in that context. And especially when you think about the insurance industry, we're seeing a lot of development for sure from an insurance perspective, where companies are doing things like real-time risk assessment and then storing that information on the blockchain so it can be verified and improved and shown later on. So drawbacks and limitations, obviously a nascent technology. There are a lot of platforms out there that are really clunky in terms of their technological application. They might not necessarily be the most efficient. And going back to that decentralization spectrum, like when you go more towards decentralization, you find that there's more inefficiencies because you don't have a third party that is overseeing kind of the functionality of the platform and how it works. And as a result, that's kind of like one of the main considerations there. Obviously, adoption and integration concerns as well. So yeah, so I mean, I kind of always update this presentation and just highlight these relevant topics, and I really want to just make sure that obviously there's a lot of news that goes around and surrounds these different instances of people getting heavily involved, companies getting heavily involved in the space, and a lot of it is structured around cryptocurrency in terms of investments with Tesla, PayPal, integration, stuff like that. And with stable coins, I really, like I said, I'm going to see a large expansion, not only in the governmental context, but also just the private transaction business-to-business context. DeFi is a whole nother beast that I think a lot of governmental agencies don't necessarily know how to deal with yet, but will very much have to address it in the future. So that is really the presentation. Carl, I don't know if there were any questions that came up. I wanted to make sure that obviously we had enough time, and also it might be over my time. Do I have more time? Can't remember.
Yeah, I think we're running short on time now. That was very, very interesting and insightful. We really appreciate that. So yeah, I would like to next go and introduce Ms. Lammers. So she's a compliance manager at Island Cloud, and that's a cloud hosting provider in Houston, Texas. Hopefully everything is warm over there where you are still. And she holds a JD from the University of Richmond. She graduated just a few years ago from this school. And she has work experience working in legal compliance. She does legal compliance advisory services related to things such as data privacy, IT services, tax, financial risk, international corruption, and a bunch of other types of corporate compliance related to ethics for companies all over the world, such as the US, UK, EU, Australia. So she has a lot of experience to offer in this very particular type of legal service that's becoming more and more prevalent. So we really appreciate you coming and presenting.
Hi there. Yeah, can you hear me okay?
Yes.
Okay, perfect. Thanks, Carl. Anyways, hi everyone. Yes, my name is Mila Lammers. I am a proud UR alum from the University of Richmond School of Law from graduating class of 2018. So still relatively recent to some of the law students that are on today. So definitely please reach out if you ever have questions as a new grad or a young compliance professional. I can definitely answer any of your questions, and very excited to be here today. I am in Houston, so I'm very fortunate to be joining you all with power, and we just got water back today, so we're pretty excited about that. So it's been a hell of a week here, honestly, so I'm very happy to get to be here, but definitely keeping everyone here impacted in my thoughts for sure. Our coworkers have pretty much been down all week. So it's actually a pretty fitting conversation because I'm definitely going to talk about business continuity as well. But yeah, so I manage, I manage the compliance program for Island Cloud, which, as Dylan said, is a cloud hosting provider. We offer infrastructure as a service, disaster recovery as a service, backup as a service, and object storage. So we are headquartered out of Houston and have about a workforce of about 200 employees globally. And we have, I believe, I don't like when I count, but I have about 12 different audits that I manage annually around the globe. So we do have a lot of travel and different regulatory requirements that we're considering. As an in-house provider, I thought it would be interesting to give you all a perspective within the legal services industry specifically as to how you should be vetting your technology providers. Whether you're helping your IT team internally look at different vendors from a due diligence perspective, or if you have a client that's coming to you and asking about any of questions that they have or information that they want specifically industry related, what they should be looking for. I'm trying to give you kind of the little tidbits of what I look for internally as the manager of our due diligence program, as well as the person who answers all of our questions. So my team, we get in between 500 to 1,000 customer questions related to compliance and security every month. They're very different. Always, they like to change things up on us. I wish they were standard so we could just have a standard template, but they're not. And that is, I think, what sets my organization apart, is that we do actually take the time to answer all of these questions customly. But it does make me have a pretty good wealth of knowledge in terms of the types of questions you should probably be asking somebody like me. So I'm giving you kind of the tricks and maybe kind of shooting myself in the foot later on when these questions keep flooding in, but I'll be happy to see them. So anyway, so the topic areas I want to focus on is just first, the compliance program in general, what you should be asking internally of your technology providers. Then what types of documentation you should be asking for. And then I want to focus on business continuity and disaster recovery, incident management, and encryption as main topic items, as well as vendor management. I do have a couple extra slides on how to actually do some analysis on privacy policy and SOC 2 reports and how to analyze them. I'm cognizant of time, so I'm going to try my best, but I don't want to overload y'all with information. So I'm going to focus on some of the main focuses. And for y'all specifically, it's going to be a lot of focus on encryption and business continuity and disaster recovery. So first off, the first thing you should ask is just get a gauge of an organization's compliance program. I would want to know, first off, do they have a dedicated compliance program? There isn't necessarily a bad thing if an organization has compliance and legal together, but best practice is still to have those two departments separately. So internally, I manage our compliance team. We have a legal team as well. We work together on a lot of issues, but we are separate. And then I'd figure out who you're supposed to reach out to if you have specific compliance and security related questions beyond just support at XYZ organization. I'd want to know who the privacy officer is. If they have a data protection officer, I would want to know who that person is and how to contact them, because that's really the person you'd want to be talking to in the case of a breach, as well as, who manages the compliance department. And then I'd also figure out how many individuals they have from an information security perspective and who manages them. So do they have a chief technology officer, or do they have a designated CISO, a chief information security officer? If so, what does that look like? What is the type of information that they're looking for? And how many people do they have as a support on their team? Honestly, for organizations such as my size, I can speak to that. We have over 200 employees globally. Our compliance and security team is around 20 to 30 people that I can, jump into audits, bring them in, specifically related to compliance and security. Obviously, we all wear multiple hats. That's technology. It's just kind of what we do in the startup life. But, I have enough resources internally within my team to know that, I know who's exactly working on internal security, and I can provide that assurance to my customers. So that would be where I would start to talk about. And honestly, if they don't have a very robust compliance program, to me, it would be a pretty big red flag, because honestly, that compliance program is generally dedicated to internal audit as well as external audits. That leads into kind of the questions of what types of documentation you should be asking for as well. Is just, here's kind of the baseline. And these slides are available on the JOLT website, so definitely use them later on. But the first thing I would ask for is a SOC 2 Type 2 report. It applies to the US providers, so usually they're scoped just to US operations, so keep that in mind for a global organization. But they are done through the AICPA, SSA 18 is the version that they're on, and the SOC 2 Type 2 means they did a SOC 2 Type 1 audit, did a readiness, fixed everything, and now they're on a Type 2. And once you have that, you maintain that with different, even if you move auditing firms. The Type 2 audit itself has over this, the AICPA has over 500 controls that you can theoretically audit against. There are 5 different trust principles. So there may be scope things to look at when you're actually looking at the report. And I do have some tips on what to look for there. The next thing I would definitely ask is, do they have an ISO 27001 certificate, which is an external audit that you would do with an independent third-party auditor? Again, they line very similarly in terms of security controls against the SOC 2 report, but the ISO 27001 audit, since it's an international standard, it's more far-reaching and it has honestly better controls than the SOC 2 in my perspective, since it's more globally focused. So I would consider it a stricter standard. Generally, though, you won't get an auditor report from a SOC audit, or excuse me, from an ISO 27001 audit. You'll just get a certification. They might send you a redacted version of an auditor's report, but generally the certificate is what you're looking for. If you want to dive into controls, though, I would look for the CSA STAR, the Cloud Security Alliance, on their registry, and it's called something, we call it a cake. So CAIQ, it's called the cake. It's over 500 security controls that you can look over. If a member, an organization is on the registry, you can actually just download their controls mapping directly from the CSA STAR registry. They're required to update it on an annual basis. So you don't even actually have to reach out to somebody like me to access it. You can just go to the CSA STAR registry, download it, and then review it every year to see if anything's changed. Those can either be self-attestations, so the organization internally is conducting them, or they could do external third-party audits, again, similar to how you would with a SOC 2 or a 27001, where you have somebody else certifying your controls and the compliance to those controls. Then the next thing I would focus on is penetration test results summaries. Usually you won't actually get the full report because most of them contain proprietary information related to potentially code development, especially for software as a service platforms. A lot of penetration testers do secure code reviews at the same time. So, first they're trying to effectively hack your system and break in, which is an awesome thing because they're working as white hats. So, they're the hackers that are trying to help you figure out what's wrong. And then from there, they'll probably also actually get into code development and code review and look over the code internally. So you probably won't actually expect to see a full report. Again, maybe you will, or it'll be redacted. But what I would look for in the summary is what are the steps that they took afterwards? Because it would be, honestly, it's shocking if you get a clean penetration test summary. As much as we all love to think that we are very much on top of security, it would absolutely be impossible if somebody doesn't find something. That's why you pay these people a lot of money to find the things that are wrong. What I would look for, though, is as an organization, did they conduct a retest afterwards? So generally, like internally, we have a threshold that if we have a high or a critical alert for a pen test, that triggers our need to pay that external party again to do a retest once we've remediated everything, because we've decided like, hey, that issue is urgent enough to warrant the retest. So that's what I would look for. And even if they don't want to give you the retest, ask them if they can provide any evidence internally of how they remediated it, whether it's, getting on the phone with somebody like myself or talking to their software developer, whoever was responsible for remediating the controls. They do have to have evidence for this for their audits. So it exists. Then I would focus on four main policies to ask for. Would be the information security policy, the data destruction policy, which would come into play, if you cancel the service, what's going to happen to your corporate data that's stored within that service? How are they treating it? What is the guidelines that they're following? It really should be best practice would be the NIST 888 standard. That's kind of the key thing you should look for. And then as well, I would look at, ask for their vendor management policy, as well as their business continuity policy. And then obviously for industry specific clients that you might have, I would also look at any industry specific standards that you want to look at. For HIPAA, for healthcare, it would be high trust. For US government contractors, it would be a lot of NIST requirements such as 80171 or 853, depending on the classification of the data that they're storing within a cloud provider. Or CJIS stands for Criminal Justice Information Services. So if they have a CJIS policy for the information security policy. Then let's talk about business continuity and disaster recovery. This has been particularly at top of mind for my organization this week, since we just reenacted our BCP plan this week because of the winter storms in Houston. So we actually are exercising it still, since obviously due to the COVID pandemic, we enacted it in March of last year, and technically we're still in an invocation of the BCP plan while our workforce is fully remote. This week, again, we got to test it again. So I have a new test date to provide when customers asked. It was tested this week in an active scenario where most of our employees did not have power, did not have cell service, could not access any of their services. So definitely, ask your provider for a copy of their business continuity plan. If it's proprietary, they might say, hey, that's confidential, we don't give that out. That's okay. Then follow up and ask them how frequently it's tested, when was it last tested, and is it reviewed during any external audits? And I'd also then focus on, if it is an external audits, look in the SOC 2 report that they should have, and look at what their disaster recovery strategies are in place. Are they using like a disaster recovery as a service model where, they're replicating from one data center to another, they can fail over automatically? Are they testing the failovers? Are they testing their backup integrities? These are all questions you should be thinking about from a DR and a BCP perspective. And then double check too as well that their business continuity plan is tested against their service level agreement requirements. So if they're giving you like 100% uptime guarantee, test to make sure that their recovery time objectives and their recovery point objectives meet those two things to hit that SLA requirement. Because you obviously might have some contractual bonuses in place if they don't meet it. So you need to figure out when you can ask for those credits if they have missed it in the case of an outage, right? Take a breath. I was doing this with a coworker and they were like, oh, wow, I don't want to waterfall and flood you all with information because it's all very important. So incident management is the next area of topic that I want to focus on with you all, because it's particularly important if we're thinking about, worst case scenario, if there is a breach, right? You have either client data stored within the cloud, which is a very viable option these days due to the encryption technologies that are available to you. Or even if you just have business to business data, whether it's customer relationship data, such as like what you might store in Salesforce or have a client storing in Salesforce, or something, in your ticketing system or your billing system, that's still really important data. And if it's breached, you still might have reporting requirements, regardless if it, it doesn't have your attorney work product in it, ideally, but it might still have client details in there. And really, we all just want to minimize reputational damage from a risk management perspective, that we never want our company name associated or our firm name associated with a breach in the news. It's just never a good look. So these are the things I would ask your technology providers to prepare in advance. I would focus on one, do they have a vendor incident management program? They should. Honestly, if they don't, that's a huge red flag. I'd walk away. If they do, how frequently is it tested? So similarly to a BCP, like a business continuity plan, it should be tested every year unless it was invoked. So, if there was a major incident, then you should know if it was invoked, and you can ask recently. You might even be able to ask like, hey, what was that incident about? Again, they might not tell you, they're not really obligated to, but you can always ask, and you never know. They might actually give you the answer or be able to tell you like, hey, yeah, we had a test, or we had an incident, we did a lessons learned activity. These were the things that we changed. Maybe we updated our policy or we increased our reporting process, whatever that was. Then I would also figure out who is going to get contacted within your organization in the case of a breach. So if we're thinking from a data controller and data processing perspective, so I'm jumping into the general data protection regulation, the GDPR and the EU, right now, just as our highest best practice standard, it might not apply if you aren't processing EU data. But I would say from a GDPR perspective, it's the strictest regulation, right, in terms of data privacy at the moment. So you as a law firm would be the data controller. You control the data, it's your data. If it's client data, you're responsible for maintaining it on behalf of your clients. From there, you would be relying potentially on technology providers to host that data for you in a secure environment that it cannot get corrupted, can't get breached. That would then put your service provider as a data processor. If you're looking at breach notification laws and we're taking the GDPR as the highest standard, you as the data controller have a 72-hour reporting requirement to report to regulatory authorities and or data subjects, depending on what type of breach it was, right? Like if it only impacted corporate data, then maybe you don't have to report to the data subjects. Your data controllers actually don't have a reporting requirement that is as strict. It's just within a reasonable amount of time. What that means for you is I would ask to contractually determine that reporting period in contract, that, in the case that your service provider has a breach, that they know XYZ law firm had a 72-hour reporting requirement, they have to get notified or we are in breach of contract. That gives you a little bit more leverage. Again, stuff might happen. I would hope internally, just as the person that's involved with incident management and, monitoring that and making sure I communicate to authorities and clients, we absolutely would try our utmost best to meet those reporting requirements and try to let them know as soon as possible, but you might not have that. So, putting it in contract, if you can ask for it and the deal is big enough, they might actually do it. So I would definitely ask for it. Those are kind of the main things I would focus on, and definitely just figuring out internally who's the contact as well. So from your perspective, who would be the one you would have to call? They would have to call, because if it's the person who signed the contract, maybe that's the right person, but maybe you want your technical point of contact, maybe, your internal CTO or, one of your top partners internally also on that contact list to make sure it just doesn't really get lost. Say it's like accidentally somebody in accounting who doesn't know the severity of, what that invocation could look like if there is a major breach. Then I want to spend a good amount of time focusing on data encryption for this audience, because honestly, this is the most important if I'm thinking about hosting potentially, privileged client data within the cloud for one of your service providers for whatever processing activity or storage that they're offering you. Focusing on encryption is honestly the biggest thing. And I think it's, it's pretty obvious for client data, but less obvious when we're thinking about, just corporate business to business data, how we manage what we do every day from a billing or a ticketing perspective. I would say as a best practice, any data that you're hosting in the cloud with a service provider, and I think you'd be surprised once if you do an analysis within your organization already how much data is in the cloud, because I think for the most part, people don't realize how much is already, hosted on the cloud versus on premises in the servers that you're maintaining and upgrading internally. First off, best practice, everything needs to be encrypted. There are significantly different reporting requirements involved if that data is encrypted on the back end. So say you host with a cloud hosting provider, they have a major breach, but your data was encrypted and you were managing the encryption keys, you don't have to report that to the authorities if you are confidently sure that that data was encrypted and you didn't have any data loss. Even if you were like, oh, well, the data in there, it's, it's only like customer name, maybe their contact details, first and last name, it's still all personal data that's still protected under all of those breach notification laws within the United States, within, pretty much any privacy law around the globe. You still have different reporting requirements. So it's just something to be very mindful of. Somebody's first and last name associated with a business email, a business address, and a business phone number is technically personal data that needs to be protected. When we're thinking about key management, so we're talking about encryption key management, I would focus on, obviously what encryption standard are they using? 256 is kind of the main one. So, that would be the one you'll see most frequently, but figure out how are they storing user credentials within a secret service, like a secret vault or a secret vault platform, effectively like a password management solution. Your encryption keys obviously should be stored within those, but then you need to think about your technology provider will have a vault and you can figure out who it is to just make sure you can monitor if they ever have a breach, worst case. But if you have the option to manage your own encryption keys, I would absolutely take that option. So then, your technology provider would manage their keys, you would manage your own keys. So even if their keys get compromised, your keys are not. That also means you need to loop in a different technology provider in this conversation. You also need to be looking at, vault password protection services. So, whether it's like secret server or, something similar where like it's a password manager, and then figure out who internally has access to it. It should be incredibly limited, effectively like 2 people, the main person, either being your chief technology officer or your main partner involved in technology, and then, have a backup so you're reducing your potential for a single point of failure. But that's it. Like very, very limited. This should be the strictest access that should be taken incredibly seriously, but that would be also another thing you need to think about. And that person, that provider, you should be asking all of these same questions to make sure from a due diligence perspective that they also are on top of what they do. So then I'm going to talk about third-party vendor management, but I do definitely want to let there'd be a little bit of time for questions. So otherwise, there are a couple slides on how to look over a privacy policy and what to look in a SOC 2 report that I have in here. I'm just not going to cover today. So definitely look over it, and please feel free to reach out to me afterwards with any questions too. But I do want to focus on third-party vendor management because it's particularly important if we're thinking about, again, that relationship with the law firm as the data controller. Your cloud hosting provider is your data processor, and then they're probably also using processors. So they're sub-processors is what we call them. So, just like a cloud hosting provider probably uses a data center provider to actually host their servers within a secure facility, that's a critical service provider that you really need to know about. And you also need to look at their documentation, right? Because I could have all the physical security controls in my office. I could have fingerprints, eye scans, whatever within my physical office for my employees, but my data center could just kind of be rogue. So definitely focus, because that's where your data is. As much as you want to see that everything is locked and I have a key fob at my office, I don't have access to your data within my office. It's stored in a server offsite at a data center. So you need to be focusing on that data center, because ultimately you care the most about where your data sits and where the equipment is. And so you need to be doing a lot of risk management review and analysis on their sub-processors. So fortunately for you, if it's a global organization, for the most part, most organizations have a sub-processor list that's publicly available, and there's usually a notice period as well. So say suddenly I decide to onboard a new critical service provider that's processing customer data in some way, we have a notice period, we let our customers know, and then we post it on this website. So, that's one of the things you can ask for is hey, do you have a sub-processor list anywhere? Or from that compliance team, can I please get a list of your critical service providers? Ask for critical. We have so many vendors within an organization, just like any other company does. As much as I would love to give you the information of the consultant that potentially helps my creative team make their awesome images, it doesn't help you, right? You need to know about my data centers. You need to know about my main partners for technology. Who are we concerned about having a breach? And that also comes to play if you're thinking about, something like the SolarWinds Orion event, where there was a very massive breach for a monitoring platform called SolarWinds, specifically in their platform Orion. You need to be able to know if your technology providers are using that solution, so you can figure out hey, that major provider had a significant breach. Did you have that breach? Do you use that software, and did you have impact? Because those are the questions you need to be asking during your engagement once you have done your due diligence and you have this provider as a partner to help you do business. Is hey, wait, do I have any impacts? So these are the things you need to be thinking of from that perspective. And then again, definitely make sure they have contracts in place. This seems really baseline, but it's a question we actually get asked very frequently, and I'm honestly surprised. But I will say from experience during doing due diligence recently of a technology provider for us, for our organizational data, I reached out and asked them, was hey, can you send me your compliance due diligence package? That's usually what it's called, or a trust package is what you can ask for. And they sent me an NDA, and I was oh, great, a non-disclosure agreement. Wonderful. Is this just, how you're vetting your people so you can send me those confidential docs? And they were no, this is what we use. So we all know that that's a retroactive measure. That does not help me in any instance of great, cool, I can sue you on the back end if you lost my data, but that does not help me in protecting my customers and our internal data by any means. So that's just an automatic non-starter and a red flag, walk away immediately. But beyond that, I definitely want to open this up for questions and see if there are any. So, otherwise, if there aren't, then I'll keep going. But Dylan, are there any questions for me?
Hi, yeah, so if a law practice is using a cloud-based law office management platform, what should be considered and looking at server locations?
Okay, yeah. So if you're doing due diligence of server locations, you should figure out where the cloud hosting provider has their data center operations. So, generally they'll have multiple, I would hope, from a disaster recovery perspective, right? That they can fail over from one data center to the other to avoid an outage, but figure out what the actual physical locations are of the data centers, and ask. They usually, a data center, if they're a big enough provider, they'll also have that SOC 2 report in the US, and they will definitely have a 27001 certificate as well. So for an organization such as mine, our ISO 27001 audit and our SOC 2 audit sit on top of those data center audits. So, since we outsource some of the physical security controls, we can rely on their auditors to be looking at those things, and they have reporting as well. So I would look at places, with very minimal flood risks, low impact zones in terms of hurricanes. But I mean, honestly, natural events can happen anywhere. I mean, we have a data center in Dallas that fortunately didn't go down because of the amount of redundancy it has in place due to the winter storms. But look at, capacity management, power input, the diversity of power sources. Again, the natural disaster risks are all things you should be thinking about for server locations.
Great, thank you. Also, is there any guidance on like the size of your firm compared to the amount of security regulations you need to consider, or the size of your firm and what you need to think about in terms of how secure you keep your data?
Yeah, so unfortunately, I think in technology, compliance is customer driven. I wish it were, we are excellent advisors and we want everything to be incredibly secure, but it's not that way in the industry. It's honestly like a big enough customer asks us for this particular certification, and then we're like, all right, let's go for it. That's generally how it works internally for all of the big technology providers. It's because we're relatively unregulated within the industry anyways, so we don't have specific requirements such as like financial or healthcare would. We help support customers that might have those, requirements. So I would say it absolutely depends on the type of industry that you're in. There's no really sweet spot. It's honestly like what works for your organization. And internally, I can say like, if I failed an audit, that might be like a pretty big clue as to like why, and do we need more resources internally? We do internal audits to figure out like where our weak points are before an external auditor comes. And that can be a really good gauge from a resource perspective if you have enough security measures in place. But the maturity of the program, you'll see these certifications are all customer driven. So, if customers ask for them, that's, enough, and they're big enough deals. That's when technology providers go after these audits. We're not exemplary in the sense that like, we're not charging to go audit 600 controls just for fun. So just keep that in mind.
Great. And then what are your thoughts on a smaller organization using Google Suite?
Yeah, so G Suite is awesome. We actually internally use Google Workspace for my organization. It's really, really great. Their security is actually top notch compared to some of the other competitors. It's definitely a software I would look into, but I would make sure you have an internal IT person who can look at and keep your team updated in the case that there's ever a vulnerability. For example, Google Chrome last week had a security breach and had mandatory updates. And if you don't have a monitoring solution in place that you can monitor all of your employee workstations, you need to make sure you have somebody internally who can send out that message to be like, please stop everything you're doing, update Google Chrome. So just make sure you have the resource to manage it. But G Suite is definitely a very secure software platform.
It's good to know. I feel like this is a very relevant topic right now when everyone's switching over to virtual workspaces. This one question is, what type of cyber liability insurance is available? And are there any recommendations you have for the size of a company and the limits of cyber insurance liability that they should have?
Yeah, so there's not really like any specific guidance on like what makes sense. I know internally, cyber liability insurance is definitely something you should be asking your technology providers for, as well as just get a copy, see if you can be added to it in the case of a breach, anything like that. General limits, again, it's very much customer driven on the technology side. So a specific customer will be like, hey, we need $5 million. And that's the situation. So I can't necessarily say it's like a specific set amount. It's probably was, again, a customer request that they wanted a certain value for their organization, and the deal was big enough for the technology provider to go after that amount of liability insurance. But definitely over $1 million is pretty common. 5 million is usually relatively standard, and it can go upwards to 20 million. So just keep that in mind, ask for the certificate, see if you can get onto the coverage itself.
Great. So the next question is, should you consider where servers are located, whether inside the US or outside of the US, when looking at different technology platforms, in a sense of like what is more or less secure?
So Yes, absolutely. There are definitely cross-border considerations you should be thinking about if you're thinking about where you're hosting your data. Something to keep in mind of is like when you're bringing on a technology provider, figure out where their headquarters are located, but then definitely ask them to where they're actually hosting the data. They might be using, a cloud hosting provider such as Island or AWS or Azure, whatever they're using. Figure out which data center their data is at, because that's actually where your data is. It's not at the headquarters of the vendor that you're using. We are headquartered in Houston. We don't actually have a data center location in Houston. So if you host with Island, for example, your data's not in Houston. It might be in Dallas or DC, or it could be all over the globe, depending on the data center you contractually agree to. So figuring out where your server needs to be from a cross-border data perspective does actually matter, because there are obviously different regulations where your data is not supposed to travel across borders. So, the GDPR is a great example. You're not technically supposed to be transferring EU data into the US without standard contractual clauses in place between those two entities due to the fact that the privacy shield was recently invalidated. So you either need an adequate safeguard, such as standard contractual clauses in place, or, if there is a valid data processing agreement, you need that. So I would say if internally you're a US entity, your data needs to stay in the US. If you're EU, your data needs to stay in the EU. And then you need to have that contract in place between those two entities that are processing it back and forth across borders.
Thank you so much. This is all like such good information to know right now and in these times. So we're about out of time, but yeah, the University of Richmond just really thanks you for all of your time and your help, and really enjoyed your presentation.
Awesome. Yeah. Well, thank you so much. I appreciate it. Again, I had extra slides. I got a lot of content. So I absolutely love this field. I love talking about it. So if anybody has questions, genuinely, please reach out to me afterwards. I'm always here either via email or LinkedIn for any students or any, professionals that have questions related to compliance.
With that, I think we are going to take a 20-minute break. I'm sorry, a 30-minute break. If you could please fill out the attendance pool, we would really appreciate it. And we will be back at 12:55 with Miss Renee Dancer.
Hi, everyone. I hope you had a nice break. Just to let everyone know who's wondering about the gift card raffle, or if you didn't already know about the gift card raffle, LexisNexis has generously offered to give a gift card to someone who registered for the event. So you should get an email sometime soon if you are the winner, probably maybe like next Monday or so. So just wanted to let everyone know what the status was on that. And then I just want to introduce our next speaker. So we have Miss Dancer, who's going to speak to us next. She is one of the leaders in the Access to Justice movement. She's the Associate Director of Research and Strategic Partnerships with the Access to Justice Lab at Harvard Law School. She graduated from undergrad and got her law degree at the University of Pittsburgh. She graduated from the Institute for Court Management Fellows Program in 2013, where her project was awarded the Vice President's Award of Merit for Applied Research. She began her career as a court manager when she was chaired for the Multidisciplinary Committee to Unify the Family Court in Pittsburgh. And after that, she began oversight of self-represented litigant services. She went on to oversee all court operations as the court administrator for the 43rd Judicial District of Pennsylvania, and then transitioned over into advocacy as a deputy director of the Self-Represented Litigation Network. She has a ton of other experience and is a fantastic person in helping self-represented litigants and other people who need access to justice be able to actually have justice, and she's been using technology to do so. So we're very glad to have her at this event, and Ms. Dancer, I'd like you to please take it from here.
Great, thank you so much. I appreciate that introduction. I'm going to go ahead and share my screen. I have some slides here. Okay. So my goal today is to talk with you about remote justice and talk with you about some of the things that courts are doing, not only to respond to the pandemic and with the requiring remote justice, but things they were doing even prior to the pandemic, and talk about kind of what's working and maybe what isn't working so well or what we don't know yet. You'll see my contact information on this slide, and I do encourage you to feel free to reach out at any point. I really do love to just have informal chats about anything you want to talk about. Okay, so let's move on. The first thing I wanted to do today is give a little anecdote to get us started. So I once knew a couple who bought a brand new car and asked that the CD player be removed and replaced with the cassette player. They thought the CD was just a fad. So let's putting aside that the CD is now obsolete and the cassette tape before it, and some of our participants won't know what either of those were in the first place. Those of us who do will chuckle about that. And so the reason I tell this anecdote is I'm concerned that remote justice is going to be the CD player that's replaced with the cassette tape, that post-pandemic courts will replace all of the remote justice strides they've made with business as usual at the typical courthouse. And what we don't know is if that's the right thing to do, the wrong thing to do, or if there's a mix or a balance in between. And so that's what we want to talk about today. Courts have been considering a myriad of options to manage access to justice in the midst of a pandemic where folks cannot gather in spaces in large numbers anymore. And remote justice was being considered and implemented to some extent pre-pandemic, but those implementation efforts have been with greater earnest over this last year. But it feels temporary in large part. There's skepticism regarding whether the justice system can and should sustain remote operations in a post-pandemic world. And so our talk today, I'm going to advocate against falling victim to that skepticism. So this is our roadmap for the talk today. We're going to use the example of remote jury trials in the criminal justice context and online dispute resolution in the civil justice context. And we'll look at the concerns that both have raised and kind of chart a path forward. So we'll start with addressing ODR as a solution that was well underway to implementation pre-pandemic with much promise, but has not necessarily lived up to the expectations set. And the question is, should courts continue on the path to implementation? Thereafter, after we talk about online dispute resolution, we'll address remote jury trials in criminal justice, putting forth the often expressed concerns of the effective ability to judge credibility in a remote setting and the potential to dehumanize defendants in a remote setting. And then we'll understand the well-built body of social science literature that addresses these concerns. So we'll look to an alternate discipline to kind of understand whether or not these concerns are something we should explore more, we should put some stock in, or we should disregard. And then we'll end that section, our section on remote jury trials, with a review of the constitutionality of remote jury trials in the criminal justice context. And that would be different in the civil justice context. So we're going to focus specifically on criminal justice for remote jury trials. And then we'll end this with, I'll offer some closing concerns and issues to think about as we move forward with the future of justice, and sound a call to action to rethink the delivery of justice from the lens of the users. I'm also going to make great efforts to leave time to chat as a group, asking questions and having a dialogue, hopefully, recognizing that dialogue itself is remote. Okay, So let's move on to online dispute resolution. So online dispute resolution has been one of the most celebrated implementations of remote engagement in the court community, at least. It's a technique that was widely used in the private sector, particularly among online retailers prior to its installation in the justice system. Courts in the country, or excuse me, courts around the country have implemented, are in the process of implementing, or are considering whether to implement ODR as we speak today. But we don't know if ODR works. However, we might define working in the justice section. There's a real lack of rigorous evidence to say one way or the other, and perhaps as a product of the excitement about remote engagement, there seems to be very little appetite for developing a body of evidence. The justice system traditionally has been challenged with recognizing a need for iteration. It often wants to do something and call it done without actually knowing if it works, or changing it or abandoning it if it doesn't. So we also struggle with admitting failure and suggesting that maybe we should move on from something we tried that just isn't working. So at the Access to Justice Lab, we do rigorous evaluation of interventions in the justice system. So you'll hear a common theme in my talk today about needing more evidence for some of these choices. Well, we think ODR should be implemented, but we think that implementation needs to be accompanied with rigorous evaluation. ODR is not a free solution. So you will hear oftentimes courts saying, and it's free to the user. It's not a free solution. This is a vendor-based product at this point in time in most courts. There's at least one, potentially others who are working to build their own system in-house, but even that is not free, right? So a vendor-based product requires you to either offset the cost by charging a fee for use, or paying for it yourself fully on the back end. And you'll see courts are doing different things. And so because this isn't free, right, you should know if it works as you decide whether to invest or maintain ODR systems. And just to step back to explain that ODR itself is the use of technology to automate some or all of the steps in a resolution process. So you could incorporate negotiation in there. It can be synchronous or asynchronous. You can incorporate the negotiation can be party-led or facilitated by a mediator or even a judicial officer. There are lots of ways to kind of interact as you would in a justice system context in person, doing that online. Because it can reduce communication costs for parties who have access to high-speed internet, this could be useful, right, for any phase of adjudication. But as you would expect, there are proponents and opponents of ODR. And this slide is intended to kind of summarize some of the high-level pros and cons as espoused by those proponents and opponents. And so some of the pros are asynchronicity, that meaning the possibility that litigants in the court need not meet even virtually at the same time. The asynchronous nature of ODR has the potential to improve access to justice by removing the barriers that come with mandatory physical presence at a court facility. And in the access to justice space, we hear about these barriers all the time. We know that they exist. You can think of them as things like transportation and childcare challenges, the fact that you actually need to find those resources, especially if you're for low-income folks or someone without a reliable vehicle. Missing work for an unpredictable amount of time often is a really difficult thing to miss any amount of work especially for folks that don't have paid time off. And that's a large population of users of the court system. Concerns about public health, and this would be specifically a pandemic concern, public health for individuals who are at high risk, but also for those who may be contagious and not even know it. An additional pro put forth by proponents is that you can have increased resolution of cases by those who would be otherwise would be unlikely to proceed because it's a stressful or anxiety-laced case event. And with ODR, however, it's thought to reduce that stress of the case event, reducing some of those stressors that could cause someone to just give up and not engage anymore with their case. This can also help to help folks to compose more thoughtful responses, or language that is more conciliatory and helps facilitate settlement, rather than words that you think of in the heat of the moment, or you just blurt out in the heat of the moment, that may not facilitate settlement. Proponents think ODR could neutralize power imbalances, and proponents think that ODR and court systems especially put forth this as a pro, that ODR is seen as a way to create efficiencies, especially around high volume dockets, and it requires little reimagining the process. But then there are some cons, right, or some suggested cons of ODR. And so that very same asynchronicity that could be good could also be bad, resulting in response delays, prolonged waiting periods, and sabotaging of conversations. All of that, right, heighten emotions unnecessarily. And then, just as some suggest power imbalances neutralize, others suggest that they'll be exacerbated. And then ODR can be exclusionary, right? If courts envision ODR as a default or mandatory process for certain types of cases, which would help to create those efficiencies that we talked about just a moment ago, what will they do then to address the 21 million people in the US who lack any serious internet access, or the 44% of households with incomes below $30,000 a year that do not have broadband internet? So you look at those are perhaps a new category of folks that are excluded from the justice system process when we put it all online. So when we notice that the same argument can cut both ways, it creates an environment calling out for evaluation. So, as we're continuing to navigate a pandemic world and in-person justice is becoming less and less the norm, we want courts to, be responsive and rush to add remote engagement opportunities. That's important for public safety. It's important for access to justice, but we also want to make sure that simultaneously evaluating those programs, so we not only understand if they're working in the moment, but understand if they're sustainable going forward. So ODR, like I said, was underway pre-pandemic. And while it's an example of a remote process that perhaps should garner more skepticism, it doesn't seem to be waning at all, but rather the conversation and enthusiasm around its promise that we're not really seeing pan out seems to just subside. So courts are still working at implementation, but the product is there. It's unused by many of the constituents that you would think would typically use it, but it's also unchanged despite the fact that it has a low take-up rate. So we have a low amount of people using the product for various reasons that are, you could hypothesize why that might be. But remote jury trials, on the other hand, are a thing born out of pandemic necessity, and they have a disproportionate amount of seemingly preemptive skepticism in relation to the very few instances of use. So we're now going to talk about remote jury trials. So like I said, we'll talk about this in two parts. First, I'll talk about some empirical concerns, which are those two issues that I brought up in the beginning, and then we'll move to the constitutionality of remote jury trials. So empirical concerns that we're hearing people throw out there are deception detection, the ability to assess credibility remotely, and whether or not that's diminished because of the remote environment. And then dehumanization. Is it, do you think less humanely of the person you're viewing on the video rather than you would when you saw them in person? So lawyers and judges at present remain skeptical that the justice system should and could implement any type of online jury. And some of this, right, is no doubt conceptual. Is a jury trial a jury trial if parties, lawyers, judges, and juries don't assemble in a single public space? And some of the skepticism is also likely just fear of the unknown. But some of the skepticism stems from these empirical concerns. So in this talk and in the subsequent article that we put together for JOLT, we'll talk about those empirical concerns. We'll focus on the deception detection and the dehumanization. So again, the deception detection is whether video trials diminish the ability of jurors to detect witness deception or mistake. So detect whether someone is lying or they just are testifying to what they believe is the truth, but they're mistaken about what they remember or saw. The second concern is that using video as a communication medium dehumanizes one or both parties to a case, causing less humane decision-making. So we did an entire meta-analysis, which is a review of all of the literature on both of these ideas that exist, literature about evaluation, trying to understand whether or not these two concerns exist. And so, and what came away with is thinking they're likely misplaced. So there's reason to be cautious for sure, and include strong evaluation with any move to online jury trials, but available research will suggest that remote trials will neither alter the jury's ability to discern truthful from deceptive or mistaken testimony, and nor will it materially affect jury perception of parties or their humanity. A common argument against the sustainability of the video jury trial is that to perform its function, the jury must be able to distinguish accurate from inaccurate testimony, and that juries adjudicate credibility best if they can observe witnesses' demeanor in person. But it seems like that based on our literature review, that reasoning is actually false. First, research shows humans have just above a 50-50 chance ability to detect lies, 54% if you round up. So we're just really bad at knowing if someone is lying or not. And that's true in whether it's remote or in person. So our ability or lack thereof to detect deception doesn't change with an in-person or virtual interaction. Or at least there's no evidence that there is a difference between in-person and virtual interactions, but there's a fair amount of evidence that there is no difference. In other words, most likely humans are really bad at detecting deception regardless of the means of communication. And why is this, right? Because we rely on our ability or to rely on nonverbal cues, to indicate lying. So for example, we think fidgeting, arm and leg movement, or decreased eye contact is indicative of lying, but none actually are. It turns out while there might be some verbal cues that could be reliable for detecting lies, the vast majority of nonverbal cues, including the ones that we most likely tend to rely on, are unreliable, and that the reliable cues can be counterintuitive. But because we hold inaccurate belief about what is and is not reliable, it's difficult for us to guard the unreliable cues. So if there is an unreliable indicator for either honesty or dishonesty, the jury does suffer a little from losing the opportunity to observe demeanor in person. So the idea that having an in-person interaction versus a remote one is better, that the idea that might be better, it kind of erodes. Okay, so just to sum up, our inability to detect lying remains constant whether we're operating in person or remote. The medium should have little impact. And this applies equally to our ability to detect mistake. So 30 years ago, a researcher named Wellborn collected and summarized all of the available studies, most testing the reliability of eyewitness testimony, which was addressing the jury's ability to detect mistaken from accurate witness testimony. And he concluded, after going through all of this research, that, quote, the capacity of triers of fact to appraise witness accuracy appears to be worse than their ability to discern dishonesty, end quote. So to our knowledge and from our research, nothing has changed since 1990 in this matter. So if neither verbal nor nonverbal cues matter in detecting mistake, then there can be little difference between video and in-person hearings with respect to judging witness accuracy. So our hope, right, is as the justice system is kind of navigating the changing landscape of justice, we also want to think about, as we're thinking about new ways to access justice, we want to also question the foundations upon which the justice system was built, and do that through evaluation. Moving on to the next empirical concern, dehumanization, we have found that criminal defense attorneys have raised concerns of dehumanization of defendants in remote trials. They argue that in remote trials, triers of fact will have less compassion for defendants and are more willing to wage harsher punishments. If we were thinking about this in the civil trial context, you could extend this to either party. So for example, a personal injury case, the concern might be that juries would be less willing to award damages because they're unable to connect with or relate to a plaintiff's injuries. Or in a less protracted, but nevertheless, perhaps even more high stakes civil action, such as landlord-tenant cases, the trier of fact, which is usually a judge, might feel less sympathy for a struggling tenant and show more willingness to evict rather than mediate a settlement if dehumanization is in fact present in remote trials. But again, when we looked at the literature, it suggested that this concern is likely misplaced. And, before we go through that literature, another question to ask is who would be dehumanized, right? If it wouldn't just be the defendant who is participating that could be dehumanized, but any witness called, any person interacting with the jury. In this instance, an interaction would be someone to whom the jury is listening. So that could be the prosecutor, it could be the defense attorney, it could be any one of the witnesses called. And so the concern, if it exists, right, exists across the playing field. So while the number of studies directly investigating the possibility of online jury or bench trials is limited, somewhat analogous research from other fields exists. And that's what we looked at, both legal and non-legal studies, but the majority of the research that would relate to this are non-legal studies. So we focused on studies in which a decision maker is called upon to render a judgment or a decision that affects the livelihood of an individual after some interaction with that individual, much like a juror or a judge is called upon to render a decision that affects the livelihood of a plaintiff or defendant. We highlighted and we categorized the studies kind of in the priority of the greatest to least rigor of the evaluation. So that means we prioritized randomized field studies before lab or simulated experiments. We prioritize studies involving actual decision-making before studies involving precursors to decisions. And according to the research in that first tier of randomized field studies, which would be, of course, the most probing and telling for the possibility of online trials, proceeding via video conference likely will not adversely affect the perceptions of the triers of fact on the humanity of the trial participants. However, we do want to take note of the other findings of the other studies beyond that first tier of the most rigorous studies, which include some from the legal field. And you'll find that the ones from the legal field would be in that third tier, are only a few of them, but in both of these lesser tiers, findings are very conclusive, meaning that in some instances they show there'll be a difference. In some studies, there shows to be a difference in the ability or in the effect of dehumanization. In other studies, there is no effect. So when we think about it, all things considered, we just don't know yet if about the full scope of the dehumanizing effects on video conferencing. We need more rigorous research, specifically in the legal setting as well. So we don't have enough research in the legal setting to really know how this will pan out. And we want to make sure all that research focuses on the two empirical concerns we've talked about here today. And specifically, we would hope for this research to be of the utmost rigor. So we would hope that it would be a randomized control trial. We want to make sure that we're bringing about credible evidence that we can filter out any externalities and have evidence upon which the justice community can rely. So let's say we're game to try, right? We agree to do more randomized field studies. We want to see if the remote jury trial is a good thing. Can we? Does the Constitution allow it? And so to find out, we do need to turn to the Constitution. And the answer, as we're all learning to say with deafness, is maybe, maybe not. So the right to a jury trial is constitutional both at the federal and the state level. When understanding whether that right is violated with the remote jury trial, we look to the Confrontation Clause primarily. You can also do a due process clause analysis, but it ends up getting you back to the Confrontation Clause. So we'll focus primarily on the Confrontation Clause. And so we ask the question, or our question that we're asking is whether video confrontation satisfies the confrontation right. So whether having that confrontation occur remotely still satisfies your right to confrontation. But why does this apply to the jury, right? That question may be burning in your mind. The Confrontation Clause is about the defendant's right to confront witnesses against them. Does it matter in what medium the jury sees that confrontation? It turns out it does. It turns out there's a case from a long time ago, 1895 to be exact, that continues to be more recent cases that specifically says the Confrontation Clause requires the witness to stand face to face with the jury to allow the jury to judge demeanor and credibility. What remains unanswered is whether modern technology providing for remote interaction satisfies this face-to-face requirement in spirit. Because certainly the strict constructionist view of that is that face-to-face means face-to-face, right? But does remote technology effectively simulate that? But moreover, knowing what we know now about our ability to judge demeanor and credibility, what we just talked about, that our ability is just above chance level, is that reasoning still salient? So these are open questions. There's no precedent that gets kind of directly to that with the current technology. And I'd love to incorporate your thoughts into our discussion time, which that discussion time is coming up here in a few minutes. Okay, let's move forward. All right. So just having some closing concerns, talking about some of the issues, and then giving you all a call to action before we go to question and answer. So in the early part of this talk, we highlighted the alarming number of people, largely low-income folks, that do not have reliable broadband internet, and it seems neither do I. We can ask the question whether incurring the cost of creating public access terminals in community centers or hubs, or something similar like that to create access. We can ask whether incurring that cost warrants the continued exploration of an underdeveloped remote justice solution like ODR. So if we're going to continue to move forward with ODR, how do we address this digital divide? Often that means spending money on it. Is ODR such a good solution that it's worth spending that money? But as we think about ODR and remote jury trials in tandem, and then also build out from there all the potential for remote access to courts, the cost argument diminishes, right? So now it seems more, it seems like, yes, of course, that's a cost worth bearing. That makes way for the justification of that expense and a forum in which courts can try and fail with ODR while succeeding with representation from all communities in a meaningful way and other justice system interactions. But I caution, let's not just take what we have and move it online. Let's also draw from the body of evidence, reliable evidence in other disciplines to reimagine a justice system that's representative of all, and useful to all. It's uncommon, in the legal field to actually rely on other areas and create and look for analogous situations and rely on the learning in other spaces, and I would encourage us to kind of change that norm and start thinking more critically and looking to other disciplines and analogous disciplines and seeing if there's learning that we can adapt. And if the foundational reasoning for doing the things the way we do them is legitimately questioned, shouldn't we evaluate those foundations in addition to thinking about new ways to access this? It may be that there isn't any other better way, but we should at least question and look, try to determine that conclusively. So this talk is intended to address some of the issues and concerns with remote interactions in the justice system. There are others that deserve attention and deliberate thought, marginalization of users, representative samples of jurors, which is an issue that should be addressed both with in-person justice and remote justice, current disengagement of parties and new crop of disengagement of users, and many other things. But the only way to truly know if any of these are present in a remote justice setting, or if we are addressing what we know to be present with a new tool, process, intervention, is to try it out and evaluate it. So my hope is that this talk made you think a little bit more critically about some of these options, but also to know that we don't know what the best answer is yet in any of these spaces. And so that we should really be deliberate about trying to figure that out. So I want to leave a good amount of time for question and answer, so we can go ahead and do that now. I'm especially curious to hear your own thoughts about these issues. So please go ahead and place them in the chat or in the question and answer section. But I'm also keen to hear your solutions. Like I said, most of these things we don't have answers to. So if you have ideas, we should definitely talk about them. And before we get there though, sorry, Stephanie, I'm almost done. Before we get there, I just want to call your attention again to my contact information, but I also want to make sure to thank the 5 folks that you see on this slide. They are students that helped me put together a lot of the research that I was able to summarize for you today, and that you'll see in the subsequent paper. Okay, let's do question and answer, Stephanie.
Okay, so we have a few here for you. First, does the prospect of remote trials increase risk of jury inattentiveness?
So that's definitely, I think, a concern that courts are grappling with. So there have been a few remote trials, jury trials. There's been a lot of remote bench trials, but there have been a few remote jury trials. And so, one way the court is grappling with that is through jury instructions, right? They're just like it would in a regular in-person trial, is reminding the jury about the weight of the issue that they're there to decide, and to express to them the importance of attentiveness and paying attention, but it also, these instructions have been addressing things like putting your cell phone away, so making it be out of reach, being in a space where you don't have other distractions and where no one else is there as well. But there is definitely some concern that in the community about not only about attentiveness, but also about making sure that the juror is kind of alone in their space so that they are not sharing the details of the trial and deliberation with anyone else in their family.
How do you deal with, say, impeachment exhibits that a party's attorney may not need to disclose until cross-examination of an adverse witness?
In a remote trial, I assume. So you would display your evidence kind of the same way you would display your evidence in a regular trial. So if you're holding back a piece of evidence that you may or may not use unless you need to impeach somebody, you wouldn't put that out there until time to do that. There are lots of different ways courts are incorporating the presentation of evidence in a remote setting. And so, but it's not necessarily like seeing it in advance, right? The hard copy of that evidence.
Have you studied the effectiveness of using depositions of some witnesses in actual trial? This person has personally found that the deposed witness to be less effective.
Oh, no, we haven't. We don't have any evaluations in that regard, although that's really interesting. And, you know, I'd be happy to talk more offline about what an evaluation of that might look like.
One last one here. You mentioned the dehumanization of a video jury trial. Can you elaborate on the exclusive use of video in the Richmond jails and how that current practice and this current debate could change that?
I assume you mean the use of video for or arraignments. And so I cannot specifically talk about the Richmond jail. I don't have a lot of knowledge about their process and procedure, but I can say that there are lots of courts using video for arraignments or bail hearings now, and they were in some respects doing that before pre-pandemic. Of course, it has become somewhat exclusive post-pandemic, especially when you're incorporating counsel at those proceedings. And so, you know, I don't necessarily see, I don't have any conclusive evidence to tell you that it cuts one way or the other as far as dehumanization is concerned. I think what we're seeing, the evidence we're seeing is having counsel present is what makes a difference there, right? So having counsel there to help to distill the important facts necessary to the bail determination or the release condition determination.
One more popped up here. What about incarcerated clients for whom the speedy trial doctrine was thrown out the window because of COVID?
Yeah. You know, I think there was lots. So courts go through pandemic or not pandemic, through disaster planning exercises, right? They every court, it's very commonplace to have a continuity of operations plan that contemplates generally weather-related disasters. They do incorporate pandemics, but I don't think that the pandemic was the disaster that most courts were prepared for. And so with weather-related disaster recovery often incorporates a reconstitution of the process just in a different location. So if in the example of hurricanes, there are buildings are destroyed, courthouses can be destroyed, the continuity of operations plan would likely dictate that you would reconstitute in another location where people can gather. But the pandemic was different. So I'm not certain. I do think it caught a lot of courts off guard. And yes, there were a lot of suspension of speedy trial rules, at least at the outset. More than that there's an attempt to remedy that. I think courts also in that continuity of operations plan will list or have a kind of hierarchy of reconstitution of emergency operations. And so that usually does include speedy trial rights. So those folks who are incarcerated and are not able to be released on release conditions for whatever reason, and we can debate what are good and bad release conditions on it at another time, but those folks are often in that first tier of emergency proceedings. There are other things that satisfy that, and then there are those proceedings that are determined to be less emergent and can be courts can wait to reconstitute those. So what courts did, a lot of courts did, and a lot of law enforcement officers did, was to reduce, not only to address the speedy trial issue, knowing that there was not a way to get lots of people into the courthouse at any one time and manage those rights, was to release people, right? Or to stop arresting on certain charges. There were policies that existed in that regard too. So I can't say that these choices are good or bad. I wasn't forced to make them myself, but just giving you some background on how courts are making those choices. So most of those speedy trial rights have been kind of reconstituted, and folks are having their opportunity to bond out or to release on other conditions or no condition on their own recognizance more speedily now. But I agree that those were suspended in the beginning.
So often with video, little things like lighting in a room and the background seen on the screen can have a big impact on how a person is perceived. Could these small factors add up to a concern on perception of a party in a trial to their detriment, especially in a jury trial? And if so, how can we try to equalize these differences between parties?
Yeah, that's a great question. And so I think this falls into the category of we just don't have enough information about it. But I suspect, I would hypothesize similarly, right, that small details about the backgrounds, for example, I have a dog behind me, would that make or a good juror or a good defendant, right? And I think we are seeing lots of there have been lots of articles written about different ways folks have been displayed in their trials. Is that are people taking it less seriously when they're in a remote setting? I think these are absolutely true concerns and legitimate concerns, and one way to know if that makes a big difference is to move forward with the evaluation. And I think that's really, I think, the call to action here with remote jury trials is we just don't know enough about what will happen. And there are lots of concerns and hypotheses about what might be an issue, but we just don't know if it truly will be an issue that's dispositive, right?
Okay, it looks like we have time for one more question here. Which courts have you been gathering data from? Have there been any stark differences from court to court?
We are working with one court in Utah at the moment. However, you'll see lots of different ways courts are doing online, and that's in the jury trial context. For online dispute resolution, there's a couple courts in Iowa and courts in Florida that we are working with. There are other evaluators working in other jurisdictions as well. However, you'll see that there are courts kind of managing the trial aspect of cases differently. And especially as it relates to remote trials. So some courts are not doing any remote trials, but Texas is a state that's been doing lots of remote trials, most of which are bench trials, although Texas did have kind of one of the first online jury trials too. And they're broadcasting them all on YouTube. So you can watch them as a citizen from anywhere. And so it kind of changes also the scope of what open court is, right? There's a little more convenience to observing court than there was before. Michigan is also kind of a leader in that space as well. And you can go onto these courts' websites, you can narrow down into the location you want to look at. You can Michigan actually has an interactive map on their website that tells you right now what courts are broadcasting live and online. But then you also have there are some counties in California that are doing similar things like that. And then there are some courts that just aren't broadcasting at all. And so while they may be doing some remote interactions, they're not broadcasting that to the public. And what they're doing is making, limited space available to observe in the courthouse, kind of the one side of the process, but they have to restrict access to courthouses to some at the moment as well.
Thank you so much, Ms. Dancer, for your talk. It was a pleasure hearing all of the work that you're doing. Thank you.
Yeah, thank you. This was great. I'm really happy to have done it. I'm sorry about the internet connection. We changed to mesh Wi-Fi and it's not working.
Actually, it's been fine. I'm sorry to have interrupted you. There were just a few little skips, but it was a wonderful presentation. Thank you.
Oh, no problem. No worries. Let me stop my share and hand it over to you all to take on.
Next up, I want to introduce, please do the attendance poll for Ms. Dancer's talk. I am now going to introduce Ms. Nelson and Mr. Simek. Ms. Nelson is the president of Sensei Enterprises, Inc. It is a nationally known digital forensic managed information technology provider and managed cybersecurity firm in Fairfax, Virginia. Ms. Nelson is the author of the noted electronic evidence blog, Ride the Lightning, and is a co-host of the Legal Talk Network podcast series called The Digital Edge, Lawyers and Technology, as well as Digital Detectives. She is a frequent author with 18 books published by the ABA and hundreds of articles, and a frequent speaker on legal technology, cybersecurity, and electronic evidence topics. She was the president of the Virginia State Bar from June 2013 to June 2014, and a past president of the Fairfax Law Foundation and the Fairfax Bar Association. Mr. Simek is the vice president of Sensei Enterprises and is nationally known digital forensic managed information technology provider and managed cybersecurity firm located in Fairfax, Virginia. Mr. Simek has a national reputation as a digital forensic technologist and has testified as an expert witness throughout the United States. He holds a degree in engineering from the United States Merchant Marine Academy and an MBA in finance from St. Joseph's University. Mr. Simek holds the prestigious CISSP Certified Information System Security Professional and the Certified Ethical Hacker certifications, in addition to multiple other technical certifications. He is a past chair of ABA Tech Show and a co-host of the Legal Talk Network podcast, Digital Detectives. He is a frequent author and speaker on legal technology, cybersecurity, and electronic evidence tapes. And now pass it on to you.
Well, welcome everyone. John, I think you're going to show us briefly, right? No, we can not allowed to.
Well, that's good. You have no idea how lucky you all are. Typically,
we are going to share a screen. Then.
Yes, typically what
Well, maybe we're not.
Do we not have permission to share the screen?
Yeah, no permission.
Okay, someone want to grant us permission to share our screen?
Try it now.
Okay, there we go.
Okay, let's see if you guys are seeing the screen.
Yep, they got it.
Yep, we see it.
Okay, terrific. Thank you very much. And thank you for your invitation today. I know everybody is having a good time getting some education here on this wonderful material. And we really are better off not being shown simply because the PowerPoint itself speaks for itself. And, we do a lot of work on the design. So we hate to have you see the fact that we are constantly referencing our notes because we don't put too many bullets on most of the slides. So we constantly are looking down and distracted, which is a terrible look for a speaker. So we'll let the PowerPoint do its talking for us and we'll refer to our slides. We are in one place and that's because we're married. So if you ever do get to see us, don't be alarmed.
Just like the photo.
That's right. And we're going to start with where we are now and then where we think we're going. So this is a friend of ours, retired Judge Monty Aholt. And we remember fondly Monty saying, we're the only profession that works by looking in the rearview mirror. And there's been a lot of truth to that over the years. And we've been shaken up somewhat by the pandemic, to be sure. You'll remember that dinosaurs became extinct because they couldn't survive a major change in their environment. And the question is, can we? And the answer has obviously been yes. We've seen more movement than we ever thought possible. It has been a tough time. We've seen particularly solos have suffered. And there's been in the larger firms a lot of layoff and furloughs, but there still are some that are very successful that are hiring. One of our funnier stories from one of our friends, Mark Robertson, has a firm out west. He had in his firm a lot of oil and gas attorneys. Well, now they're bankruptcy attorneys. And as Mark says, it's same client, it's just a different area of practice. So that's being adaptive and pivoting when needed. So we never would have thought there would come a day when we'd be practicing law, some of us in our boxer shorts. But, that's where we are. As long as we look good from the waist up, most of the time we can do what we need to do and very successfly. So we've done a lot to change.
And we're definitely undergoing a paradigm shift. And it's really a new way of thinking. We'll never, ever go back to the way the old ways and the way things were before. Was there ever really a normal? That's certainly a decision point, or
will there ever be a normal again? The way we used to think of normal.
Never. I don't think you will be. A lot of folks say that we've pivoted in the practice of law. I hate that word, pivot.
Yes, but we all.
I'd much rather use Clint Eastwood's phrase from Heartbreak Ridge: improvise, adapt, and overcome. I think that's a better way to say it.
That may be our after dinner movie. Did we lose focus, John?
I didn't do it. Oh, here we go. Are you, brother? Oh, we have a poll. Hold on here. Let me get over here. There, go.
Thank you. So what we've seen in the past is that when offered a wheel under their cart to haul their rocks, lawyers would say, no, thanks, we're too busy. So you would give them a better innovation, a way to do things faster, cheaper, et cetera, and they were not interested. I'm happy to say that those times seem to be going away. And in fact, people are asking questions about how to do things differently and better and cheaper, and it's working. Now, other than resenting this woman for looking so darn young when I do not, she represents pretty much what I do all the time, which is scan the horizon. Primarily, John and I are the two rainmakers within our company. So we're always looking, and it's been 23 years that we have been reading multiple hours a day, both of us. I came from the days, believe it or not, in high school, I had the old manual Royal typewriter. By the time I started my law practice, I was up to an IBM Selectric, but that kind of gives you some clue as to how long we've been around and what we've been seeing. But if you don't scan, I mean, it's you know how a dog will put its muzzle up in the air and just sniff? Well, that dog's seeing what's around, what's happening. And that's what we need to do in this kind of world. That's time well spent to scan the horizon.
So we do have more time available to us. Vast majority of people still working from home. We're not really commuting much anymore. Certainly, we're not seeing this volume of cars on the road, but we do see a lot more than we used to.
Yes.
But it's a double-edged sword because we now have more time available to us. But the bad side is we don't have any forced downtime. At least before, what a lot of folks would do is on their commutes or while they're driving, whatever, they would catch up with family and friends, and they'd make phone calls, and they
or get learning through podcasts.
those kinds of things. But basically, they weren't really doing work, right? So you've got this mental break. So it could really be a bad impact, if you will, that we have more hours now. I know certainly Sharon and I are working more hours today from home than we were going in the office. So many of us are working too many hours, and we're just not taking the time to take those forced breaks.
Which we should, because there's all kinds of rest. I mean, there's the rest where you go to sleep. There's the rest where you move away from a screen so that you're not looking at a screen all the time. There's just time to be still, to meditate, to do whatever, to think about things like, what do I need to do with my practice? So one of the things definitely we want to impart is don't be stubborn about change. So many people want to do practice law as they always did. And we've gotten to the point now where when our advice is ignored and we're managed IT service providers and cybersecurity providers and digital forensics, we actually will document that we've given advice and that they've chosen not to take it. Now, but as the pandemic was hitting, we were giving very good advice about what you needed to do to protect against ransomware, which came on strong. And we had several clients who simply didn't want to pay any more money or have any work done. And 3 clients got hit by ransomware. Now, I want to applaud those clients because they took ownership of the fact that they had ignored our advice. But the 7 most dangerous words in the English language are, but we've always done it that way. So it is time to think about new ways and time to make some changes that make sense today and may make sense for the future as well. I know on this morning's news, they were talking about how many people are not leasing as much space. That's gone down quite a bit. So in terms of learning, I love this line from Winston Churchill. Personally, I'm always ready to learn, although I do not always like being taught. And I suspect virtually everyone listening today could have, that would resonate with a lot of us, I think.
Especially the students.
Indeed. This is Clio's CEO, Jack Newton, and we scored an interview with him at the last Clio conference. And I got the permission to use his wonderful picture here. But my favorite line from that interview was, we've moved 10 years into the future in 10 weeks. And that certainly is something we've repeated time and time again. Just today, we got notice of something that's coming up, which is there will be released a report by Clio on the 2021 legal trends for solo law firms. That will be released on Tuesday. So you're going to want to make a note of that, especially if you're thinking about hanging out your shingle. It is embargoed. So unfortunately, I cannot disclose anything from the report. However, on Tuesday morning, the embargo is lifted. So if you want to make a note to check Sharon Nelson's Ride the Lightning blog on Tuesday at 10 o'clock, that's when I will post a summary, because you don't want to read 46 pages, which is what I've been reading. But I will summarize the meat of the 46 pages for you in that blog post. And there's a lot of really, really interesting stuff. But let's go back to what we did last fall.
What we can talk about, though, is the legal trends report that was released October of last year. And it's loaded with a bunch of statistics. And this is where we are now as a result of the pandemic. As you see there from the stats, 85% law firms are using software to manage your practice. That's a good thing. Our experience has been a lot of law firms were not using practice management as an example. So that's good news that they're at least more folks are doing that. 79% cloud technology. That's a great idea as well. Makes you a lot more flexible. 62% allowing clients to share and sign documents electronically. 73% paying invoices electronically. And 83% meeting clients virtually. That's that whole Zoom thing. So,
yeah, two things I want to say before we leave this slide. First, these were not just Clio subscribers that were surveyed, so it would be on Clio. So the numbers are not just about their folks. The other thing I want you to do is take a look just at the percentages on the left there again, because this is how they were adapting, but this is what they plan to do in the future. And look how far the numbers have risen. Now we're up to 96% going to the cloud. 95% will support electronic document signing and signatures. 96 will accept electronic payments, and 96 will use law practice management software. So we're moving on up.
The only thing that stayed the same is video conferencing.
Yeah, I don't know why that stayed the same, but I'm here to tell you that 83%, that's gone up already. It just hadn't gone up, I don't think, by the time when they did the actual survey itself. Right. But I'm thinking that when they do the fall version of this report, you're probably going to see a higher number.
So some other trends that came out of this report. We're really a virtual workforce now, right? And no longer held up in offices. As our good young lawyer friend down in Richmond it says, we're under house arrest.
Graham Bryant, yes.
Yeah. So, but the key, at least, we're getting convergence now between clients and lawyers, and they agree now that physical office space just really isn't all that important anymore. It used to be, big prestige and status symbol, and you walk in the lobby and, you had this massive marble foyer that you could play basketball in, right? Not anymore. It's not important. And clients, certainly when they will go into law firms that way, they know that they're paying for that and they don't want to pay for it. So, and as some other stats, as you see up there, right, more and more folks are going to be giving up their commercial office spaces, and they're going to be reducing down. The footprint's going to be different. Now, timing is everything. Sometimes Sharon and I get it right, and then sometimes we screw up. We screwed up this time.
Yeah, we signed a lease in February, a 5-year lease taking effect in September, no less. So yeah, we really screwed ourselves good. But there's nothing you can do about that, and there's no out clause for us. We may be able to renegotiate, but that's the best we're going to be.
The other interesting thing, and our neighbor who is inside counsel for a large financial firm, he was telling us, they just pre-pandemic remodeled the entire floor, the legal floor, to be open office space to get more collaboration, everything going on.
And now they're going to re-architect it so that it's not open office space. So, money, what's money? This, to give Jack his due here, he's become very famous for this particular book, which is available, as you see, in paperback for $19.99 on Amazon. But note that no less a person than a Professor Richard Susskind from the UK, he actually reviewed the book too, along with many others. And he talked about the need to focus relentlessly on the needs of clients and to ceaselessly improve client experiences as one of the ways to survive through this pandemic. The book, by the way, was written prior to the pandemic, but it fit very nicely into this is how you survive and thrive. And there's no question in my mind that has worked out well for a lot of firms who took the good advice here. So not too much money for some really good suggestions.
So a lot of pressure being placed upon lawyers and law firms from the customers, from the clients, because what's the focus of the client? They're not buying billable hours. They want results. They're interested in a given output, not necessarily how long it takes. And so there's a lot of pressure now from clients now on law firms and how they actually practice law. So that's another way, not just the pandemic, you're getting forces to change the practice of law, but you're getting clients to force you to change as well. And as Jack has said, and Sharon showed you the book there, we're really the future. This is really the future focus. Client-centric law firms, and those are the ones that are going to be successful.
But one of the things we're having to do, I mean, you see this image of people shaking hands, is we're having to find ways to replace that and to make them feel like you are their friend, even though most of the time you may be seeing them virtually. We do a whole CLE, no, non-CLE on marketing during these times, and it has all changed. All the rules are different, but that is something to think about.
So as a result, as well, we have the haves and the have-nots still, not just among the clients, but also among the law firms. As you see there, the ones that help that help people more the solos and small firms, as opposed to the large mega law firms that are servicing businesses.
And that's been a real recent trend that's been documented by data, that the people who are business lawyers primarily are doing pretty well, whereas the people who are serving the average consumer, not so much.
But it's really an access to justice issue, when you talk about it. And technology helps. And I know a lot of the solo small firms are learning that if they haven't already known it.
So what is a chief sustainability officer? When the pandemic struck, I started noticing all of these announcements, press releases and whatnot, that the big firms were all getting chief sustainability officers, which I thought was kind of a dire title, although I do get the message of keep calm, we will survive. So what has happened is that these chief sustainability officers are not only sustaining the law firm, they are actually in the business of helping the lawyers understand how to make their business clients sustainable as well. And that has meant a lot of different things in a lot of different places. But it is interesting that we now have so many of these officers.
There's also a lot of pressure now to really adopt alternative fee structures. Hourly fees, they're really on the decline, and significantly because of pressure from clients. They don't want to pay those hourly fees. As I said earlier, they want those results. So they want some real innovative thinking as far as how can you structure the fees. They want a budget, right? They want to know how much is this going to cost me to get my business going off the ground, or my, this employment action that I've got. What's that going to cost me? All those kinds of things. So these are just some examples of alternative fees, success fees, and fee caps, et cetera. But I think one area that at least our experience has been that lawyers get themselves all tangled up with is they think that, well, geez, alternative fees, that's a fixed fee structure. It doesn't have to be, right? You can have hybrid solutions. It's not one and done. So that's where I think you can be really, really creative. In other words, you can do a fixed fee and then identify what the scope is of what that fixed fee is going to cost or handle, what it's going to cover. And then you'll have the contingency things. However, if we do go to get permits for this construction and we run into these issues, it's not fixed anymore. To go and battle it, appeal or whatever it is, it's going to be X.
Right.
So you can start putting those kinds of things in.
It's basically if the scope changes of what's being done. So one of the things we've seen, which I think is unfortunate, is we've seen a race to the bottom of fees to get clients. And the experts certainly warn against this. The lower price may not get you more clients, in fact, but may cause you a lot of trouble. In fact, the experts have been saying, don't be afraid to raise your fees, especially from clients who are referred to you, because remember that folks who are referred to you, they already know from someone else that you're someone to be respected, that you did a good job from them or something else.
So we have a question, Sharon. Oh,
yeah.
Well, it just went away.
Do you remember what it was?
Well, maybe they're going to ask it later. I don't know.
Okay. So one of the things that, and I love this photo, what you end up with when you do this race to the bottom of fees is you may end up with mismatched clients who don't really work with you or your kind of firm, toxic clients, which this guy certainly would appear to be, and clients that don't pay at the end of the day. And that has been a huge problem for those solo and small firms, which they're trying to figure out what to do with. But don't do that race to the bottom.
Now, more and more now, ABSs, alternative business structures, this is a huge controversial topic, especially in Virginia. I know when Sharon was president of the VSB, there were I could, from the hallway, hear the all-out battles of
Yeah, and there were no discussions. There was a lot of screaming. That's all I remember. And I was the one holding the gavel, trying to get everybody to be polite. It was not a simple time.
But some states have embraced it, and I think you're going to see more and more of this. Arizona, one of the first to go forward.
And we've got 2 more states that have sandbox experiments.
Utah, and New York have that,
and more states have this on their radar.
But I think it's really, the intent is to get the law firm to run like a business, and that's why there's a lot of interest in doing this. You can control everything that's going on, as a result of that. So it's I don't know. I'm not a lawyer, so I can't express my opinion on this one. I'll get in trouble.
Don't get in trouble, John. You're in enough trouble with me most of the time. Go ahead.
But you also need to budget for technology. I mentioned that earlier, right? That's going to make you more efficient because, believe it or not, this thing they call the internet, it's not going away. So it's going to give you a competitive advantage. Think about, just like, as the survey said, the Clio survey says, consider the cloud, going to the cloud. Don't forget about your cybersecurity. Especially now, since we have a different structure in the work from home environment, you're a lot more susceptible to attacks from the bad guys. So we want to make sure that we've at least upped our game a little bit and haven't forgotten about that.
And another mistake that people make is that they do not use business grade tech. And I can't stress the importance of this enough. I'm sure at some point in your life, your parents have told you you get what you pay for. And that is true. When you buy business grade, you get manageability, you get scalability, you get a longer life because they use better quality parts. And it is the one thing that every lawyer covets. It is fast, much faster than the consumer grade, which is, of course, slower and which uses cheaper parts to get to that lower price tag and therefore has a shorter life. So your overall best value is to use that business grade tech. Now, our friend Jack Newton has also said the cloud has become table stakes. And what he means by that is that if you're not in the cloud, you're not even in the game. And that is true. And it is certainly true today that the cloud protects you better than you can protect yourself. This is not to say that there are never problems with clouds, but most of the time when you have a cloud problem, it's because somebody on your end has misconfigured something on the cloud themselves, which has caused the problem, sometimes even a breach. But the cloud, they all have specialists in cybersecurity, whereas most law firms do not. So they are protecting you much better. And the other thing that we have seen is that in the recent surveys, they're saying every upgrade to the cloud, every upgrade goes to the cloud. So they may not be doing it wholesale in the larger firms, but piecemeal they are, and they intend to have an entirely cloud presence at this point.
So ILTA's 2020 tech survey said exactly that, right? Consider a cloud with every upgrade. So if you are going to upgrade an environment, look at the cloud alternatives first before you look at the on-premise solutions. And when we say that, I mean, more and more people now, they're not physically investing into hardware, right? They're buying subscriptions. They're doing, whatever. They're not even buying servers for storage or any of that anymore. Where are they going? They're going to Amazon, right? They use an AWS to spool up servers virtually. So, and this trend is really across firms of all sizes. It's not limited just to large firms or only small firms. And as you see there, 50% email is already in the cloud or is going to head there soon. So there are some stats to support that. And as you see here, if you look at Microsoft 365 Exchange Online, look at the number of attorneys, right? It's heavily skewed towards the smaller firms. The larger firms, not so much, right? It's a small percentage. And if you look in that a little further up, Microsoft Exchange 2016 as an example is 50 some odd percent have on-prem servers. But this is the platform that they expect to go to 12 months from now. So what's the trend? Well, the trend is certainly to the cloud. Microsoft 365 subscription base. You saw how big that number was previous, how much it was skewed towards the smaller firms in the slide before this, but it's a little more level now, as you see, right? The large firms now, over 50% then are saying in the next 12 months, they will be in a subscription, Exchange Online or Microsoft 365. They're probably a good 5 years too late, but video conferencing, what is everyone using? Zoom, it certainly is the 800-pound gorilla when it comes to video conferencing. It's the overall winner. It's very affordable. And why is it the winner? Well, because clients know how to use it. They like it. It can be used across all kinds of platforms and operating systems. If you're an Apple user, or even if you're a Linux user, you can, and it really doesn't matter the flavor of Linux. They've got clients to do that, but you'll see there, 71% now are using Zoom. We see Teams more for mid to larger firms, primarily because it's a great interior collaboration tool. And if they're already a Microsoft 365 subscriber, it's already included for free, as part of your subscription. So there's no additional cost to that. Now, Teams has some issues, but that's why we're seeing that in second place. Clients prefer to do business remotely, right? Especially during COVID-19. They don't want to come and visit you if they don't have to, especially if they can get their legal stuff done. But we heard previously you want to up your game, right? You want to look professional. So as you're doing these video conferencing, so some of the things you want to consider investing in: a green screen, audio is extremely important. Get a quality headset. We happen to use, when we're using headsets, we use the Plantronics. Any of those models are very good. External webcams, the quality is much better with those. We happen to have an external Logitech camera that we use when we have to really up our game with that. Connectivity. Don't get on the Wi-Fi if you can avoid it. You're going to get into spotty and bandwidth issues, especially if you've got other people in your residence that are competing for that bandwidth on the Wi-Fi. So connect up Ethernet if you can. And finally, you may have to increase your bandwidth with your ISP. Now, if you're a cable provider, you're going to see a big disparity between download and upload speeds. But if you're a Fios user, that's going to be a little more level, the upload and download speeds.
And you want to look professional too. And we have certainly learned about that. And you see in the upper part of the screen there, a Zoom meeting with audio only and with video only. And down in the bottom, you see the Teams video call or the Teams audio call. So yeah, we have heard specifically, and judges have complained vociferously about the fact that people do not dress as they should or appear professional. And they say, when you are in my courtroom, that's how I look at it. And of course, they are at the courthouse, most of them. So they're at the courthouse and they expect you to look like you would if you were in their courtroom.
Practice management, boy, it's essential, absolutely essential.
Now,
and these are some products that are out. This is not by no means inclusive. There's all kinds of them, right? Cosmolex is actually a tabs-free product, but there's a lot of them that are out there. Certainly do your due diligence, with them, but it puts all your data in one spot, which is really nice and makes you a lot more efficient.
And there are a wide ranges of pricing too. So you can investigate what will work for you if you're just starting out. Clio is certainly the most full featured, but it's also the most expensive.
Yeah.
So, take a look around.
It integrates with more things than not. Yeah. Electronic payments. I just can't believe that today folks are still fighting taking credit cards, as payments. So you really need to accept electronic payments, especially with the mail system the way it is and how slow it is, et cetera.
We've had mail delayed, including checks, by up to a month. So we have written our clients and asked them to go to the electronic payment, and we've told them very candidly why, and the majority of them have done so.
But you want to accept credit cards. You want to take that electronic payment, and clients are willing to do this. So you're going to get paid faster. But clients like it because they're going to get, travel points or bonus points or whatever by using their credit cards. But one thing to consider, and don't, I really hate this personally, is don't charge that convenience fee, for handling a credit card.
You're better off raising your rates than you are charging a convenience fee. It's all psychological.
Client portals. If you're using a cloud-based practice management system, I can't think of a single one that does not have a client portal attached to it. And as you see, these are some examples there: Rocket Matter, Clio, my case, those have client portals. The clients love it. They can have access to their matter. They can take a look at, what the documents are, what's the status of my matter. They can go into that client portal. They can make a payment. It's really very similar to when you communicate with your doctor. You get your lab results. You do all those kinds of things. So you don't have to worry about secure communications or any of that, because the portal takes care of that. It encrypts everything and it holds it all within in a very secure fashion.
And the reason we have our friend Jim Calloway's photo on there is because Jim recently wrote an article about how essential client portals are to solo and small law firms in particular. So that's an article worth looking up if you need persuading.
We've talked about electronic signatures, right? And contracts, DocuSign and Adobe Sign are the two most popular ones. But there's also e-notary services, but you have to be aware of what the law allows. And more states now are changing their legislation actually to allow for more e-notary type of things. So you don't have to do this physical contact anymore just to get a signature. Upgrade your Wi-Fi. I heard the prior speaker talk about a new mesh network. That's what we have. We have a Wi-Fi 6 mesh network, which is killer. Killer fast, killer secure, but you want to upgrade your home Wi-Fi. Most folks have the standard Wi-Fi router that they got from their provider, their ISP, whether it's Cox or whoever, Comcast or any of those folks, or even Verizon Fios. They're using the standard routers with those. But do an upgrade, get up to a Wi-Fi 6, which is going to get you more secure as well as faster speeds. Now would be a good time to have a security assessment as well, because especially since your environment has changed. Everyone's not participating in their network operations and running their practice from an office. So now you have all these remote folks that are out there. Do a security assessment, see where your vulnerabilities are, and so that you know what you need to fix. And then, is your remote access solution secure enough? Or do you need to up that game as well?
You can't fix it if you don't know it's broken. Yep. So security assessments are relatively cheap, and I'll talk about that in a second here. But there's an old adage in cybersecurity that every company gets penetration tested, whether or not they pay someone for the pleasure. And that's really true. If you don't want to go out and have someone try to tell you what's wrong, someone else is going to find what's wrong, and then you're going to be potentially the victim of a data breach or ransomware attack, whatever. So you probably don't need pen testing in most cases. That it's much more expensive, takes longer to do, et cetera, et cetera. But certainly a security assessment can be obtained at a very, very reasonable price. So which road do you take? Well, you can't take them all. I know it all looks dizzying. We were thrilled to be speaking to you today, but actually our presentation on this is about twice as long when we normally give it. It includes more ideas, more thoughts, more slides, but we just didn't have that time today. But just be aware that you do need to have a plan, and we can't just keep going. I think too many people are like a hamster in a wheel. They're just going round and round, and they're doing the same thing and expending all that energy and really not making a new plan and going somewhere different than they were. Albert Einstein, smart man, that Einstein, in the middle of difficulty lies opportunity. And I can't tell you how many new things we have tried during the course of the pandemic, and we have been extraordinarily successful at increasing our clientele, which is great. But you have to spend some time and some hard work getting to all those opportunities. And that is a continuing part of our future, because the pandemic is going to be an endemic. And when it's an endemic, we're still going to be practicing law in new ways constantly. We're going to have to evolve. It's evolve or die, I think he said in Jurassic Park, right?
Yeah.
You took away my focus again, my dear. There we go. And so there we are. And I think I did see a question flash by. Anyway, we're very grateful to have spoken to you today, and thank you for the invitation. And Stephanie, do we have anything to answer?
Hi, it looks like we don't have any questions so far. If anyone has any, please submit them in the Q&A function, and I'll be happy to read them.
Also, you see our email addresses there.
No,
you switched it. Well, all right. In any event, it's easy enough to find. I think it's on the written materials. So feel free to email us if you do think of a question. We're more than happy to answer, and we'll roll this back to you. Be safe and well, everyone.
Thank you so much. We really enjoyed that. So next we will have another attendance poll, and then we'll have a short break for the next 20 minutes, and we will reconvene at 2:40 with our Women in Technology panel. So have a great break.
Look at the cat.
Okay, sorry for the delay, everyone. You should all be able to turn on your cameras and mics now.
Great, thank you so much.
Okay, I guess we can get started here. Thank you all for being here. We really appreciate you helping us put on this awesome panel that we have planned for today. I just wanted to start off by kind of giving everybody a glimpse into why we think it was important to hold this Women in Technology Law panel. And that is because despite women making up the majority of those currently enrolled in law school and the number of women in law school rising each year, female founders currently account for less than 15% of legal tech founders overall, and even further below that than in tech startups more broadly. So it's definitely an area of the law where we see just a disproportionate in the amount of female and males that are present in this field. So we want to promote gender equality issues in the legal tech profession, and all these lovely women here with us are all accomplished legal professionals who will help us understand the current state of the industry by providing their personal experiences, explaining how they were able to get past any existing barriers presented to them in their careers, and suggesting ways that other legal professionals can promote gender equality in their own work environments. Our panel speakers are Milu Lammers, Sharon Nelson, Renee Danzer, Ashley Dobbs, and Veronica Canton. We've heard from 3 of our panelists so far. Ms. Lammers is the compliance manager at Elod Cloud, a cloud hosting provider in Houston, Texas. She holds a JD from the University of Richmond School of Law and a Bachelor of Arts from Middlebury College. Ms. Sharon Nelson is the president of Sensei Enterprises, which is a nationally known digital forensic managed information technology provider and managed cybersecurity firm in Fairfax, Virginia. Ms. Danzer is giving us experience drawing on her knowledge of the justice system operations and the pressures of the justice system. She joined the Access to Justice Lab at Harvard Law School to incorporate rigorous research into improving access to justice. Ms. Ashley Dobbs is an associate clinical professor and the director of the Intellectual Property and Transactional Law Clinic at the Richmond Law School, where she and participating law students provide intellectual property and business transactional legal services to nonprofits, artists, and small businesses. Professor Dobbs brings 10 years of experience in private practice, including her work at Hogan Lovells PC and one of the world's largest law firms, and at Bean Kinney and Corman PC, where she was a shareholder. In practice, she advised clients on the acquisition, protection, and commercialization of intellectual property. Her clients range from high-tech firms, government agencies, entertainment industry corporations, to small business and startups. Prior to law school, in addition to founding her own consulting firm, Professor Dobbs was a business and marketing consultant for 15 years. She offered strategic recommendations and business and marketing plans to her clients, including Fortune 500 companies in the advertising, banking, cellular, and automotive industries. Professor Dobbs was named as a rising star in intellectual property by Virginia Super Lawyers in 2014 and by DC Super Lawyers in 2015. Ms. Veronica Canton graduated from Notre Dame Law School. She is a chair to the American Bar Association Intellectual Property Law Woman and IP Action Group and chair of the Hispanic National Bar Association Innovation Committee. She was named a Fast Case 50 Legal Innovators, Techies, Visionaries, and Leaders honoree in 2018. She was also chosen as a Woman in Legal Tech 2020 by the ABA Technology Resource Center. Veronica brings various legal industry experiences, including work as a litigation, business, and IP attorney. Relevant to this symposium, Veronica is the co-founder of a legal tech company where she and other NDLS classmates created SAA company to connected attorneys with potential clients. So with that, we are going to start with Miss Lammers, and we'll go to Miss Dobbs, Miss Canton, Miss Nelson, and Miss Dancer. That's just how you appear on my screen when we're answering these questions. So first, what do you think accounts for the gender disparity statistics, and where do you think we are in terms of gender equality in the legal tech profession?
So I'll start. I have a unique perspective because I recently graduated 2 years ago from the University of Richmond, almost 3. So my class was actually over 50% female at U of R. So I was in a predominantly female graduating class from law school. I work in technology now in-house. For me, some of the things that I deal with on a day-to-day is I'm very often the only woman making decisions in a room with a lot of men. So I'm very often aware of not only my age, but also my gender in terms of the decision-making that I deal with. I cannot speak to that much that I've seen in terms of the gender disparity within the industry because I'm new, but I am I'm hoping part of the future. I mean, we celebrated recently 25% of my workforce on my organization was all female, which in a technology industry is actually a really big feat, and we did celebrate it. So it's definitely, I've had a unique perspective of cheering on anytime we get a new woman, especially in the technology team. If we get a new software developer or an engineer that's female, it's like the greatest thing ever, beyond that they're incredibly talented. But so that's been my experience thus far. And then Professor Dobbs, did you want to jump in?
Yeah, I'll jump in. So, my experience with legal tech specifically is probably much less than everyone else's. I can speak to some of my experience in business and related to tech and being in the legal field, but I don't want to take too much time from people who know more about this. I think it's the same problem that we have in the legal industry, which is some people call it a pipeline problem, but I don't think it's a pipeline problem as much as it is a retention problem. It's the societal problems that put that create that third shift of women's work on top of your day job that makes it hard to meet the metrics and to make the connections that are required to be successful in any field. And the continuing, there's this lack of leadership at the top to provide both mentorship and modeling, and the variety of perspective that would change the structures that prevent women from being successful systemically. Yeah, if I can add to that, as someone who's been in the legal industry, I was in the legal industry way before I went to law school. And so I had a different perspective going in. I didn't focus so much on that mental anguish of getting the perfect grades. As a fellow nerd, of course, I cared about the grades, but my focus was on the experiences and finding opportunities. And I happened to be in a phenomenal place in terms of experience and also being curious, where I sought out opportunities. And I think a lot of these things we'll see, and I'd be curious to hear from other colleagues on the panel, some of those opportunities that are presented to women to speak are on not necessarily in the technical aspects of the work. And I think that's very much lacking. I know plenty of women who can talk to you about artificial intelligence, blockchain, smart contracts, you name it. And a lot of times that those positions or those opportunities go to men, right? And so I think nudging and being comfortable with being uncomfortable and saying those things, I think it's important. Because unless we as women nudge, and also men and even people who are putting on panels or conferences and things of that sort, nudge for those opportunities for women, we are not going to see women's experiences exposed. right? I'm sure we have the statistics. Women have a high degree of PhDs and graduate degrees, and now going into the JDs. But again, these are some of the opportunities that we need to work on together as a team to get people, not just to talk about our personal experiences, but also to, I do nuclear research for A, B, and C, or I'm working on a company, and all those technical aspects that we already know we can do.
I can't remember the order, but I will jump in. So I 100% agree with especially what Veronica just mentioned. And I think that it's about being deliberate about who we're engaging to work on things with us, who we're citing as authority, who we're lifting up as experts in the field, and, being deliberate about not just selecting women, but selecting all sets of diverse candidates, right? So, this extends to people of color, this extends to people with lived experience. And until we as, a community are deliberate about identifying diverse voices, we will not see a diverse set of leaders. Professor Dobbs mentioned the pipeline issue, and I hear the pipeline issue again in all of those, categories of folks who we're not seeing on panels and lifted up as experts. I hear the pipeline issue, and that's a great excuse, right, to not promote people, but it's totally non-existent. There are absolutely ways to find expertise from multiple different cultures and genders and perspectives. It just you have to look for it, and it might be easy to just always choose the same people, but that also limits limits the voices, but also limits the knowledge that we're putting out there as a group and as a community.
I'm not sure of the order either, but I will jump in just to say that I think I'm the senior woman here, but by a considerable amount. Not that I'm sure anybody has noticed that, but it is true that I go back so far that there just weren't women in technology at one point. They didn't exist. And if anybody has been looking to hire women, it would be me. And I can still continue to see an overwhelming majority of applications for technical positions in the company, not the other ones. The administrative ones are all women, but the technological skills that are required are just not there. There's very few resumes from women, and that's nothing that I can control. I put the ads out, and it's whoever comes in that I have to screen from. And unfortunately, only once has there been a truly qualified, certified person who came on board, and we did hire her. She resigned several years later simply because she wanted to go back home. But I just don't see the numbers coming in. So the pipeline issue doesn't make sense to me from my own experience, because I'm not seeing a lot of women in the pipeline. Now, maybe they're just all going to bigger companies. I mean, that's possible, but it would seem to me that I would have seen more than one resume in 23 years that showed a qualified woman, and I haven't.
I think part of the issue, right, is we have norms that we all subscribe to as what are appropriate roles based on gender and cultural experience. And I think, Sharon, you just described that exactly. You suggested that administrative professionals are more often women, and people with technical expertise are more often men. And so projecting that, right, also makes it the truth. So that as we project that, we're forcing people into those roles, whether that's their chosen role or not. And so it also makes it more difficult for women to speak up and say, no, I do have this expertise. I am capable of doing this. And so, the more we change that dialogue, the more accepted it feels, the less of a leap it feels to take on these roles, right?
Yeah, and shifting to, if I could add to that, part of this, looking, tech perhaps that you don't have the pipeline versus retention issue as we do in the legal field, where there are a majority of women graduating from law school, but there's still the tiny minority of leadership at firms. But with tech, I think we look at why are girls not progressing in tech? What's happening in the culture, the bro culture, the bullying, the cyberbullying that chases them out of chat rooms, of areas that give them an opportunity to develop those skills as coders when they're young. And that I think is a societal issue that we're still grappling with.
And yeah. I think that we're doing a good job. I know that my daughter, who is a Girl Scout leader, she's asked us to teach the girls and get them a cybersecurity badge. The girls are going to coding schools in the summer. I mean, those things didn't exist back in my day, but what did exist, and what I think made me different from some of the other girls that I was around, is that my father, when he saw me playing nurse at home, said, "Why aren't you playing the doctor?" So he put that in my head, and all the way through, he was supportive of anything that I wanted to do that was not female in the terms of people who were growing up, in the 60s. So I had all of that, including a dad who, when I graduated from Georgetown, kept saying over and over again, "My daughter, the lawyer, my daughter, the lawyer." He was so happy, but I had all that nurturing, and very few girls did back in those days. And I definitely signal out Dad for saying, "You can do this. You definitely can do this. And we'll see to it that you go wherever you need to go to learn whatever skills you need to learn." That was such an amazing thing back then. And I was still in law school when it was about 9% were women. And we broke through the 10% mark while I was there, but it was odd. The guys, there was this wonderful study group, and I respected these guys, and I asked to join their study group, and they said no, a woman would be a distraction. So these are stories I realize that seem like ancient history to many of you, but I had to beg them to let me in and evaluate me to see if I would measure up. And of course, within a few weeks, that, bless their hearts, I mean, they all said, "We're so sorry. We had no idea. I don't know what we were talking about." So they were very gallant, and they did apologize, but that was a constant in the beginning. And I'm not sure there's not some lingering sense of that even now.
Yeah. Sharon, I would offer some input in terms of if you felt like traditionally, I agree with you. I mean, historically, like 20 years ago, there were not women working in technology as many as there are now, which is an awesome thing to see because there's been so much growth within the industry. I would say now, if you're experiencing, that idea where you have job postings open, but you're only seeing a specific, less diverse candidate pool applying, I would revisit the job requirements that you have laid out there. So for example, they've done studies that they've shown that women are less likely to apply for jobs than men if they're like, "Wow, I have 2 years of experience, but this is a 5 years of experience role. Like, I'm not sure if I fit that bill." Women honestly tend to be more aware of their potential, what maybe comes out on paper, and they're potentially not going after those jobs that are maybe have a little bit of overreaching job requirements that maybe aren't necessary. So I would have your HR teams look at and figure out like, okay, what's actually necessary for us to gauge? Could we take somebody with a little bit less experience if it meant that we could create a more diverse candidate pool, especially if you're seeing consistently getting the same types of applications. I mean, for example, I applied to a job that was asking for 5 to 10 years of experience out of law school. I had 1 year of experience out of law school in compliance. I got the job. And then a year later, I ended up taking over my boss's job when he left, and I manage a program. So I can tell you, I do not fit that bill. But when talking to the person that I manage now, she was like, "I don't even know how you got into this position because I wouldn't feel as comfortable applying to a job that on paper, I might not have the exact skill set."
I really appreciate, exactly what you're saying, but we're just a group of 15 people, so it's a small group, and the only thing that only requirement that would have given anybody pause was that they need to be certified in something that had to do with technology, and that's not an overbearing requirement. So I still am mystified, and I will always be mystified by the absence of people applying, because it is well known that I would hire people who needed nurturing and mentoring. So I don't get it.
Thank you all for those wonderful insights. Next, could you guys talk about the biggest challenge that you think that women in industry face, and what did you do to overcome any challenges that you faced in your career thus far?
I would be happy to start with a personal story, because I think it really touches on what we started discussing. Before going to law school, I worked at a big firm with their IP group. So I was very comfortable and confident in just dealing with IP patents, microchips, anything technology related. Going into law school, I signed up for several mentoring programs. I was assigned a mentor who the first and only 15 minutes I spent with this person, all he did was to tell me, you can't do IP. You can't do technology. You don't have the degree. You don't have the background. I went to MIT and I have all the degrees that to do all this type of work, but you don't have it. So you should really look into a different area of law. And so out of respect, because I was connected with this person through someone, again, a program and people that I'm still friends with and are mentors, I gave this person the 15 minutes. At the end of the 15 minutes, I said, I have looked at my watch. I have to get back to school. I need to study. Well, I didn't even carry and he kept going on. I was like, okay, you know what? This is not going to work out. So for me, having experiences like that and having people who were mentors, like I signed up for mentoring programs. And I know we have a lot of students who are participating right now. I signed up for way more mentoring programs than I could, that I probably should have, maybe 3 or 4. This person ended up being one of those programs where I just said, forget it. I'm not even connecting with this person again. The other thing I did was in terms of the classes, I sought out, and it was intimidating even having been in the legal industry before going to law school, but I sought out advice from different people. So I sought out advice from someone who was a year or 2 ahead of me in my career in law school. I sought out information from professors. Some professors helped me, some didn't. So I sought, and also from administrators, I sought out advice from people who were already practicing. Everyone gave me different advice. I put that together and I followed my gut, right? When I've received rejections, where I've received, redirection to areas where I knew I didn't want to end up like this person was, and even another person saying, oh, you should really go with immigration because you're Hispanic and you speak Spanish. I was like, really? Thanks. And I ended up saying, I was a little short with this person. I didn't give them as much space as the other person, but I thought, how dare you tell me, not only as a woman, but as a Hispanic woman, where I need to go. So I think that a lot of times as women, it can be a little intimidating at first. And again, speaking from experience, but we need to seek advice from different perspectives and put that together and follow our gut, because otherwise I wouldn't have ended up, and I'll share more about it in a few minutes, but I wouldn't have ended up starting a legal tech company with colleagues from law school during law school, right? So that's my personal experience that I wanted to share.
I think I would like to build off of what Veronica said, because it's such great advice about mentoring. When I started at Hogan & Hartson, they had an official mentoring program where you were assigned a mentor. And we did not connect either. And so I took it upon myself to find mentors, exactly as Veronica has described. And I looked around for who were people who had different perspectives, people who were in positions of power or had control over things that could help me do what I wanted to do. I did a lot of coffees with people to understand how the culture worked and how I could work it in order to get into the group that I wanted to be in, because I wasn't in it. And I networked and had conversations. I also had to take some risks that were uncomfortable. I went to the person who was the head of our office and said, I want to be in this other group. He also, it turns out, was a much higher level partner than I realized. And at one point says, why can't you just swim along downstream with all the other fishies? and just go along with what everybody else is doing. I'm like, because I'm not going that way. I'm not going downstream, and that's where I want to go. So can you help me get over there, please? And that was a risk. And there were some other times too where I discovered that a man had been hired to work for me as an associate, was being paid more than I was. And I had a couple of really bad days, and where I took it very personally. And then I finally decided that I honestly, I said, if I were a man, I would not be sitting here worrying about this. I would be talking to the managing partner about it. And that's what I did. I marshaled my arguments. I said, I'm a lawyer. I'm going to go lawyer. I'm going to go represent myself in this conversation, and laid out my facts and said, I cannot find another explanation for why this person is being paid more than I am, except that they are a man and I am a woman, because I have more experience. I have, and I put all that together. And it could have ended badly, and I was willing to, because I was unwilling to work in those conditions. And so it had a good outcome. But I think the story of it is, the net of it is finding mentors, taking control of your destiny, and being willing to take risks and stand up for what you believe in and what's right.
I think that one of the largest challenges that we experience as women in the industry is perception of who should lead the industry. And I think I touched on that earlier, but kind of building off of what Veronica and Professor Dobbs are talking about, as far as like, what should we be doing to progress in our careers and progress in the trajectory that we want to go to. And one of the things that I think took me a long time to realize, but has been the most kind of powerful way to really hone the way, my career the way I want it to be, was to recognize when my voice is valued in a conversation and when it's not. And when it's not, just leave. I mean, like if I don't need to press people to value what I have to say and the expertise I can provide, if that's not, because most of the time the reason that I am devalued is because I was devalued before I spoke at all, right? I was never going to be a valuable voice in this conversation. And so sometimes you have to cut your losses, as opposed to fighting the good fight and continuing to press on, and realizing when pressing on is only actually just putting you up against a wall that you will never get over, because there are plenty of ways to make impact. You just have to find where that is.
Sometimes I think you can start out being your own boss. And I think I was probably lucky. Whereas I know a lot of the women I know and respect so much, they're stuck in big organizations where all of the problems that you've been describing happen. I started as a solo lawyer because my daughter was born needing a lot of medical care, and I was advised to stay home with her. So I did that and started a solo law practice and had more children. So I was used to being my own boss. And then I got the idea that I needed to computerize if I was going to go up against larger law firms. So I was one of the very first solo lawyers who was fully computerized. And the gentleman who took care of my technology is still sitting here beside me today, because he became my mentor. And as he did all this technology with me, we decided to form a business together. And so we formed a business together. So I was still the boss. He agreed to become vice president, but it's really a partnership. But that meant that I never went through what you guys went through. So I was the boss from the very beginning. And even though my company is small, it doesn't have the kinds of issues that I think you've all had. And I wish there were an answer to what people do when there are glass ceilings where they work and where nobody does value what they say. Now, my middle daughter is actually the head of IT for Freddie Mac. So she obviously was not an apple that didn't fall far from the tree. But her lesson to me that she has learned, and maybe it's useful to others, is work on women empowering women. And that has been a big project for her. So I think that some of the things I've seen her do in terms of empowering other women. It's helped them psychologically. It helps in how they see themselves. And boy, do they get determined that they're all going to get to a good place together.
That's such a great point, Sharon. I was just reading a study that was talking about this disconnect, that one of the things that younger women or who are starting out in their careers, if they're, I started out as a baby lawyer when I was in my late 30s. So, but as people are starting out, they're looking for mentors, and women who are farther ahead in their careers do not perceive that they are needed as mentors and don't realize how important that is. And so I think that for those of us who are in a position to be mentors, to reach out and affirmatively take that opportunity and to try to encourage our peers to do the same. And for the people who are starting out in their careers, being willing to ask for that and to articulate how important it is to help those women above you or ahead of you to understand what a difference it's going to make for you, for them to provide you mentorship.
Going off of that point, do you think that these mentorship programs could help promote gender equality? And if so, how could a more senior attorney work towards developing a mentorship program?
I'd be happy to get started. I mean, absolutely, right? I've had mentors the whole time that I was in law school. I have mentors now. I mentor a lot of students, probably too many right now, but I love doing that. And I do think that going back to the previous question and the discussion, having that support is key. Will it help, or how can it help in terms of gender equality? And I'll be very frank and honest. I'm a potty mouth with my mentees, right? When they're having a bad day, I'll tell them, shake it off. And I'll pump them up. I'll talk to them about what they've done so far. I'll talk to them about, you made it to law school. A lot of people don't make it into law school. You made it through your first year, people drop out. You made it to this internship, you did that, right? So I pump them up, but I also talk to them about seeking support. And what Renee was mentioning earlier, right? When you have a voice, and you feel like you're not connecting with the team you're working with or the company you're working for, leave. You do not have to stay. And I know it's easy saying it right now, but I also say it from experience. The first company where I worked at, by month 5, I was like, this is not the place. And I knew it. So what did I do? I saved up as much as I could. And one of the key issues that women have had historically, and going back to the 50s, when women were so dependent financially on men, we as women had to, deal with whatever was on the table. Save money so that when you need to leave, you can say, I've saved enough to take care of myself for the next few months. I'm out. I'm not being respected. I'm out. And I think and I know it doesn't go so much into the gender parity, but I think it's empowering for us to do those things for ourselves and walk away.
Yeah, I think so too. I think from a perspective of, I think a lot about like culture, right? Because I work in compliance. So we say that buzzword culture all the time because I'm trying to build an internal culture of compliant behavior, right? Part of that is, of course, working very closely with HR. And my tips would be, obviously, first off, if an organization has a mentoring program, awesome. Ask them about it. If you're, interviewing the firm, focus on the mentoring program, figure out like how often do people actually meet with these mentors? What happens if maybe the mentorship isn't a match? Do you get reassigned to a new mentor? These would all be really good questions to ask during an interview. I also would look around if you're walking around the office, if we ever go back to an office, or, virtually if you're meeting people, via Zoom or whatever, figure out what the age disparity is across the organization. Because if you notice that there are a lot of, say, younger women and then maybe older women, but maybe not women of a childbearing age, that may actually be an indication that the benefits suck and they probably left for better benefits elsewhere, even if they liked the company. So I would look at that first. Also, obviously, ask for the benefits package, figure out, regardless if you want to have kids or not, you might want your, to also help empower your coworkers as well. If they ever want kids, or the person you manage, if they come to you and they're like, wow, we don't have paid maternity leave, why? you would hope that you have a really good answer for that, because otherwise they're probably going to leave. And I like this, honestly, this mentality we're having on this call of being like, don't be afraid to advocate for yourself. And as much as you might like working for your employer, if they don't support you and they don't offer really good family leave for either yourself or your partner, they don't offer really good healthcare benefits for you or your dependents, it's probably a really good indication that they might not care that much about the diversity that they're potentially talking to their candidates about when they're trying to bring talent on.
That's such a great point. And I maternity leave is another question, but going back to the mentorship thing, the other thing I wanted to point out too is it's not just women mentoring women. If you're a man in this room who wants to be an ally or supportive or see women be successful, you can make a really big difference by taking on and being an active mentor for those people, helping them see how that program works, helping them see things that are like behind the scenes of how the relationships work that maybe isn't readily apparent to someone who's new to the group, or looking for someone. It's not just men and women, right? It's also other types of diversity. Someone who doesn't look like you, if you can help them learn the ropes.
I think that extends to that concept extends beyond mentorship too, right? It extends to promoting your colleagues and the people that you value, whose voice you value in this space. That, you know, to be an ally to women, to people of color, to people from different cultures, people that don't look like you, to promote their work and their expertise, suggest them as speakers in your stead at times, right? Write articles with them, cite their work, you know, give them references as to clients for future business because of their expertise, and build that network, and then, you know, be an ally in that way as well.
You don't always have to have your mentors either within your organization too, because I know that have been over the years a number of men and women who have come to me to mentor them in how to move up the ranks of leadership within the Virginia State Bar, for instance, or the local bar associations. And so those were paths I could help put them on. And I was an original member of the diversity conference of the Virginia State Bar. And everyone there was devoted to being a mentor. And we all spread out and did different things in different ways, but it all ended up making a meaningful difference in the lives of a lot of people. I had to ask if I was eligible to join the diversity conference because I thought maybe you needed to be diverse. And fortunately, they let me in and they said anybody can join the diversity conference. You just have to support the principle of diversity. So as you can imagine, that was many years ago. But we have certainly seen a lot more involvement by a diverse group of people within the Virginia State Bar. And we are now actively seeking diverse participation. And that, to me, starting when it was almost all white men, that has been a great victory.
Can I add something about mentees just real quick? Again, because we're talking to a lot of students, be prepared when you reach out to someone, right? Look at their profile, be prepared with specific questions. Don't just ask the one question, how are you doing it? It's like, how am I doing what? Right? You make sure that you have specific questions, because that way you can get the most out of connections with people. But also when I connect with potential mentees who are ready, I'll take them under the wing, like under my wing. I'll invest the time in, I think, you know, when you do that work, it shows, and people will want to invest their time and resources into you and your success.
Thank you for that. So obviously we are in very weird times right now with COVID, and COVID seems to be making legal tech more important as virtual practices are becoming the norm. Do you think that this helps, hinders, or really doesn't have that big of an effect on gender equality in the legal tech profession?
Well, I think this has a huge potential for gender equality for women in the law. and for people generally, because some of the big blocks to being successful and being able to attain it were the things that allowed for a flexible work environment, right? If the only way that you could succeed at a big firm was by billing the most hours, but you were also primarily responsible for childcare in your household, you were going to lose that battle, right? And now that if you can add some flexibility, and in a lot of the larger firms, that was the other thing too, the resistance to providing leave or prorated accomplishment of bonuses based on having taken family leave, being able to have a flexible work schedule, being able to work from home. So all of these innovations and this normalization of flexible schedules and working from home, I think will help women in the law. Now, as for legal tech, I will leave that, I'll let the next panelists.
I mean, I can jump in here in the sense that from a technology perspective, you know, I work for Workforce. We went fully remote due to COVID, and we'll be fully remote until at least everyone is vaccinated. So very privileged to be in that position where I'm at. But I have noticed that the emotional toll that the coronavirus pandemic has taken on so many individuals, especially those with families, and those that are taking care of loved ones, whether, you know, they're related or family, friends, you know, it's unbelievable to me how much emotional weight still falls on women traditionally, even if both partners are both working full-time remotely. There's still, I mean, I see it with my two sisters. They both had babies right at the beginning of the pandemic, and both of them still, even though they all work remotely, all full time, my sisters definitely are the ones that are balancing more of the meetings around schedules and stuff like that. So there is also the thought too of, you know, one, I think going virtual has increased flexibility. And I do think, I mean, I'm somebody, I absolutely love working from home. Honestly, even if we go back into the office, I don't plan on going back because I like working from home. I love the flexibility of being able to just walk my dog whenever, work whenever I want to, and have more of that flexibility. And I'm getting less like pulled into like the quick stuff that happens in the office that honestly distracts from work occasionally. However, that being said, I will say that I think a lot of employers have realized like, oh, wow, we really don't need to do this anymore. And like our employees are self-sufficient. And also if you're in an employer, again, that like doesn't think you can be self-sufficient and like responsible for your time away from an office, like there's a concern there. But I would say ultimately, I think it has helped because for me now, I know having a flexible work environment is a very serious priority for me in my future career, just because I'm like, I like it, whether or not I have children or not. It's important to me. And it's because it helps just in every day. And I do the same thing with the employees that work for me. You know, I don't care if they go to the groceries in the middle of the day because that's when it's the less traffic. I genuinely don't care as long as they get the deliverables when I need them. So I think COVID has helped a lot of employers and managers realize like, wow, I don't need to micromanage my people, and maybe flexible work environment is a really significant benefit we can easily offer.
I think regardless of technology, we still need balance. We still need support, and we need the flexibility of different routes, right? Not that if someone's working at a law firm, they don't necessarily need to go the partner route. Right? If there's someone working in a legal tech company, that they don't need to work the crazy hours with the product developers. And I say that because I'm part of a networking group where at one point it was 50 of us in one group, and it's 35. Now we talk about how technology can be overwhelming, right? Having back-to-back meetings on Zoom, it's draining, right? So I think we still, even with technology, it's facilitating our ability to be home and do things like you mentioned, Malu, like going to the grocery store in the middle of the day. Less people, less traffic, just, you know, in and out quick. But at the same time, more perceived availability for meetings or potentially perceived availability. So I think regardless of having the technology, we still need to manage that with some balance.
Yeah, I totally agree with that. And that I think is the challenge. So I have been working remotely prior to COVID. In theory, I traveled all the time too. So when I wasn't traveling, I was here primarily and not in Cambridge. So, and that was an interesting experience that I requested, and I challenge you to make those requests yourself when it's not advertised as such. And my job prior to that was fully remote. And the challenge, right, is that you are always in your office. And so creating those boundaries, but also creating those expectations in your colleagues and your superiors too, that just because I'm here doesn't mean I should be feeling required to respond to emails at 10 p.m. or even within like an hour. I mean, it's okay to let things wait for a day, and just being cognizant of your own kind of mental health, because COVID has also kind of really highlighted some stressors, and there are gender-based stressors in households that I think, Miley, you talked about as well. And maybe you're experiencing that, and maybe you're not experiencing that. But either way, we should just be kind of patient and kind with everyone, and not place our expectations that we place on ourselves onto other people, and just be cognizant of kind of everybody's needs, but also not feel obligated to be responsive when you're not in a position to be responsive. It's totally fine.
And that stems from the top. You're quite right, Renee. You know, you have to have a corporate culture where your employees know what is an emergency. If they're on call, if they're the emergency person for an IT emergency, well, yeah, but of course they're not on call every day. So, you know, but you have to also, we've had folks over for outdoor dinners when that seems safe. And we have a staff meeting. We have one today at 5, and people are welcome to have a glass of wine, and we play games. And I try not to communicate with them more than once every 2 weeks as a group, because it just would seem too much, too overwhelming. But once every 2 weeks, there's enough stuff that you want to say to people. And one of the things we do, which I think is really great for everybody, is we do call outs. And call outs are just praise for another employee who did a good job, who did something to help one of their peers. And that is good for mental health. And they always laugh through that as people are getting called out, and people go clap. They're very excited and re-energized by all the approbations. So there are ways, I think, to help keep balance for everybody. And of course, you know, the women do have particular stressors, and I've had private conversations with them about the ones who want to stay home and the ones who say, please tell me I have to go to work half a day. So, you know, you really just have to kind of balance it. And I also think we're just lucky to have a small company, because you can have that kind of personal attention and somebody who cares about you, because you've only got so many people that you have to deal with. In a big organization, that's a much harder prospect.
Yeah, I would say, man, I love the idea of doing like a positive call out. I think that's such an awesome just idea of just like reinforcing, you know, just like wins, especially because we don't get to celebrate as many wins right now, because it's kind of all the same. Like we're all effectively living kind of the same day over and over again. So yeah, we do like a wins list internally with our team. But what I would say as well is something that I have heard. Obviously, I'm still relatively young in my career. And so some of my peers that graduated from U of R, you know, they're potentially in very large law firms, or they're doing more traditional legal work, not in-house. They're working for law firms. And what I've noticed is they're really struggling. When I thought that COVID would actually potentially give them a little bit more freedom and more space, it's been really interesting to hear from some of them say specifically like, no, there are no boundaries anymore. So like they were working really hard to set boundaries with partners because like when they were in the office to be like, no, like there's certain days I want to leave at this time. And it's really hard to do that when somebody knows that you're like, well, you're not going out, you're not doing anything with your friends. I know you're home. So at 8 o'clock at night, why not answer this email? So I would just encourage you. I mean, I have said I am in a flexible work environment, which means sometimes I do stuff in the middle of the day and then I'm working at night, but to respect other people, I always use delayed send on emails. I never send an email at night. Just schedule it for 8 a.m. the next day. That way that person doesn't feel stressed about the fact that I'm emailing them at 9 at night just because I was moving around my time. I don't expect them to do the same thing. I have the same understanding with my bosses. My bosses have very, very poor time management skills. They love what they do and they work all the time, which means they slack me very often on the weekends and I do not respond to them. And they understand that that's okay. That's not an expectations that I set with them because I'm very clear that although, yes, I saw their message, I will schedule a notification reminder for myself in Slack to remind me first thing Monday to be like, hey, yeah, I'll get back to you. But like, that's okay. And again, if somebody is making you do those things, reevaluate your priorities because it might not be worth it.
It's also okay to just be honest and say, listen, I don't intend to respond to emails or take phone calls at this particular time on weekends or in the evenings. If you're finding like that this is a regular occurrence and it's making you uncomfortable, just have the conversation, right? And just like, I don't feel comfortable, or I'm trying to set boundaries so that I can also have work-life balance, right? And do, whether you have other things to do or not is inconsequential. It doesn't matter. You don't have to have a reason.
Yeah, absolutely. And liberal use of out of office messages. I am out of the virtual office for the weekend.
I love that message.
I was thinking about when you mentioned Slack, I was thinking about the idea of legal tech opportunities for women in the wake of the pandemic. And I think it's actually for anybody, but it's also perhaps an opportunity for women who might be entrepreneurial minded, that this has, again, I think, tenderized the industry that had been resistant to change and new ideas, and this idea of like, ooh, documents on the cloud, is that safe, right? That now the industry as a whole, the legal industry, is getting more accustomed to these new ways of doing things, which I think opens the door for people who have good ideas to launch and sell them.
Absolutely.
So I think we are out of time. So I just wanted to thank you guys for taking the time to answer all these questions and sharing your wonderful insights.
This has been great. Thank you so much for the invite.
Yeah, thank you.
Thank you, Stephanie. Thank you, Carl.
It's been a pleasure. Thank you.
So we put up the last poll for attendance. If you could please fill that out, we would really appreciate it. A few last notes here before we close up for the day. There will be a link to the recording of today's symposium, which will be distributed sometime next week. So if you would like to rewatch anything or catch up on something that you missed, that will be available to you. And as Dylan mentioned earlier in the day, LexisNexis offered to host a raffle for us. Anybody who is registered and did attend today's meeting will be entered into a raffle to win that gift card. So just keep a lookout for your emails. We'll make the drawing sometime today or over the weekend and send out a message early next week for the winner. The entire Jolt staff thanks everybody so much for their participation, the speakers, for all of their wonderful insights, Professor Geis, Mr. Spahn, Mr. Bull, Ms. Lammers, Ms. Dassner, Ms. Nelson, Ms. Canton, Ms. Dobbs. Everybody did such a fantastic job, and thank you all for that. Carl, thank you for helping us get all of the technology correct and helping us make this successful. And Miss Mary Ruth Walters, thank you again for doing so much behind the scenes and making this a successful event. So thank you all. Thank you all for your participation. We really appreciate and hope to see you at next year's symposium.
Okay, I've closed the polls. It looks like everyone answered this time. That was great. And we'll figure out all the attendance stuff later. But thank you guys too. What a wonderful symposium.